Hi guys, so we just started. We are going through the status hearing for the severed co-defendants awaiting
And
trial.
this needs to not be televised because we don't have everybody dressed out. Did you already submit that? Is that live stream?
They just told me to come film it.
They told you what?
They told me to come film it, but I'll turn it off.
Who told you that?
Fine.
Okay, well, it's not up to them. And really, none of that should have happened. I thought that was clear with the deputies yesterday because not everybody is dressed out.
Oh,
People in jail garb.
oh, so I think we'll be able to listen. I would hope we'd be able to listen, but I guess we're not going to be able to see around the courtroom. So they're saying that Whitaker is saying that she doesn't know that the media had approval to be recording the status hearing. Maurice already panned the camera around the room. I don't know, I don't know what the other defendants look like. Was that Eppinger? I need to pull up pictures so I can learn the who's who. But they showed somebody. We'll figure out, I'm sure, who it was in their Jailhouse Blues or Fulton County Blues. Also pointing out real quick, the verdict clock was adjusted. It looks like they took like 45 minutes or so off of it. So, because yesterday when we ended the stream, they were ending for the day. And I think it was at like 15:40, something like that. I don't know the exact number, but they did rewind this clock a little bit. So, we'll see. We'll see. Let's also look at Kathy Roussan over on Twitter and see if she's given us an update. Because she had posted that, and she's with Law and Crime, she posted that that Law and Crime will be covering the status hearing. So, no update there. I'll keep refreshing. And Judge Whitaker's reason is she doesn't seem to be aware that they have approval to do this, and at the very least, it seems like she doesn't want them to be shown. But at the same time, we're muted. So I don't know if they're muted because they're not doing anything right now, or if as soon as they muted it, the hearing started to proceed. So we'll wait a few minutes. We'll figure out what's going on. We'll wait till we get an update. But what a mess. What a mess. Whitaker is in a mood. Yeah, I would be surprised if especially it's in the same courtroom. I mean, let's go. Search. Because yesterday, oh, yeah, so they're definitely cutting it. Oh, the deputy made them turn off the camera completely. Oh, this is crazy. This is crazy. And I really wanted to see how this was going to go ahead, right? A status hearing isn't always the most exciting thing, but when you have several co-defendants awaiting trial. Yes, they have. The other status hearings have been broadcast. So I thought this was going to be more interesting than usual for a status hearing because, the other defendants, they're all going to say, we've been ready for trial. What are they going to say when they're asked? Like, are you guys ready to go? Do you have all the evidence that you need? Has discovery been completed? I wanted to hear the answers to that sort of thing. So, yeah, so much for transparency and sunshine. Oh, boy. Submit that Rule 22 right now. Do it quickly. At the same time, it might be as simple as not much happens today. So, Joseph Papp is probably in the courtroom. We'll look for text-based updates. I don't know if Maurice will hang around and give us updates. I don't know. So, but what's weird is, let's see. So did the case that we're looking, right? That would be the case number for the YSL trial with the 6 and now 2 defendants. I mean, they must have just retained that case number when the others were severed out of it. So, I don't know. Hopefully they quickly get into Rule 22. But, let's see. I believe there was a Rule 22 application for the Munktunk proceeding. I could be wrong on that, but I believe there was an application of some sort. And yes, they filmed the last one, but the guess is, since it's a separate case number, the Rule 22 doesn't apply, doesn't carry over to the case number for what could be one case for the remaining co-defendants. I don't know if they're going to ask for severances from each other or what, and divvy it up even more into more cases. Sign into this portal real quick. Poor Maurice got put on blast. Whitaker's like, what are you doing, Maurice? He's like, they told me to come here. Who's they? And I don't think he really wanted to say, I don't think he wanted to snitch. He didn't want to rat. Let's see. I don't know, because they still come up under the same case number, so that can't be a reason either. Like, it's all still under the same case number, so how would you need to apply for another Rule 22? The consideration I was making out loud here, trying to come up with a reason for it, I don't really think that that's the case. Yeah, because this is the same indictment number. They're going by this. They don't have a separate number here. So if you're going to apply for Rule 22, you'd submit it under this. The same thing that they already have a Rule 22 for. So, I don't know. I don't have a possible reason even. I don't have a possible explanation. Oh, boy. Yeah, I don't know. Still no updates over on X, but, you know, maybe they're making some moves to move things along. And not for nothing, but maybe we'll get some jury questions bright and early this morning. I do think that the jury skipped over count 1 and has not started deciding that yet, because I am shocked that we haven't had questions about the meaning of certain things. So, with that being the case, whether we get to peek at this hearing or we get a jury question, I'm sure there'll be something going on today. Yeah, and I don't know. So again, yeah, the last hearing, the last status hearings, those were televised. And there is no separate case number in existence for these remaining co-defendants, not that I see. So I don't really understand why a Rule 22 granted for the same case number. I don't know. I don't know. And I'm waiting like, Maurice, please tweet something. Yeah, I would love to hear it. I mean, and we're going to get updates regardless, but it's going to be in writing, and, you know, writing can only tell you so much. Right? We won't get to hear like the tone of which certain people say things, right? We'll just be reading words on paper. It's not quite the same as getting to hear and or see it. No, Sheena, we know. We saw that they popped into the camera. We know that they came up. We've been watching. So, yeah, and I'm looking at the other streams. Nothing else has anything going on either. They're all just showing a random overlay or a logo. Yeah, so yes, Talk to Me podcast, not for nothing, but this is something that has been talked about before. I know that Doug addressed it again because it came out as news. But there was a juror that was followed for several weeks. It was being surveilled. It seems like the state didn't want that person on the jury and was trying to look for a reason. So they were following them around to find out if perhaps they didn't actually reside in Fulton County. And that would be, you know, a reason to get someone off the jury pool. So Doug retweeted something that had mentioned that yesterday. But that isn't that isn't a new revelation. So he was just making a point that that is the only instance of surveillance that we're aware about, and we're only aware because Love brought it to the panel. She brought it to the court to try to get the juror off the panel, right? So it's possible that this was done for other jurors and it wasn't known. Doug also did give this reminder here. When will you guys ever get that Max Sharp knows absolutely everything about all 6 terabytes of discovery in this case? And there's nothing you can tell him that he does not know. Nothing. I'm sure he appreciates the assist, but have a little faith in the man. So a very big compliment there to Max Sharp. And then let's see. Big thank you here. I see STS is out here sniping with the gifted memberships. Thank you so much, STS. As far as attorneys for the next defendants, I know we have Nicole Fagan. That's, unless things have changed, that's Christian Eppinger's attorney. Let's see. I think AJC has an article on this. Let me see if I can find it. And shout out to AJC for having a ton of articles, but that's going to make this a little bit of a search. How does Nicole spell her name? She use an H? Oh, Tinquarius Mender, not Eppinger. Okay. Okay, so I think this is who we saw when they panned the camera then, maybe. I don't know. There's a mask, so I can't really tell. But I do believe Nicole Fagan is still working the case, but she's representing Mender, not Eppinger. What else do we have? So Fagan is Fegan, and Khalif Adams' attorney is Tiambre Calland. So this is Khalif Adams, this is Tiambre Calland. Let's see. I don't think they talk about other attorneys in this one, but there are two of the remaining defendants. So Khalif Adams again, Tiambre Calland, his attorney, and then Nicole Fagan and Tinquarius Mender. Let's see if we can find another article. No, is he another Qua or Quay? Let's go back to this article. Remember they had the plea deal hearing for the severed co-defendants that were awaiting trial? We'll have to read this with the understanding that maybe some attorneys, like the names have changed, but we're going back from an article from June of this year. Who do we have? All right, so we have attorneys not present for Javon Fleetwood and Jimmy Winfrey. That's Roscoe. Let's see. Fleetwood objected to his lawyer's absence and lack of communication. Judge Dempsey responded, I appreciate what you're saying. He isn't here today, so we will deal with that as appropriate. So I'm not sure who his attorney is, but Let me say this in response to what you just raised, sir. In general, anyone paying attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for an attorney to be appointed to represent a defendant. Whew, that's kind of some shade from the judge here. I wish he was a bit harsher. Dempsey went on to say that it also takes the attorneys time to prepare a case and communicate with their clients. After Winfrey also objected, saying that his lawyer was ineffective and he wanted a new one. Dempsey told him that the court would have to find out why his lawyer was not in court first. Fleetwood's lawyer was reportedly absent because of a family emergency. Demise McMullen's attorney was present on Friday. So tell us who it is. I want the name. However, he was recently assigned to the case, and the judge gave him additional time to prepare. Let's see. They're not going to give us attorney names in here, are they? All right, those are the 6 on. Oh, interesting. So Christian Eppinger, current YSL status unknown. All right. So he's just kind of in his own bubble here. Same thing with Jaden Myrick or Set Trip, YSL case status unknown. So, yeah, so no attorney is named here. So sorry about that. All right, so they did file a Rule 22, but the judge didn't sign it. That's a mess. All right, so, well, Judge Whitaker made us shut down the camera saying we didn't have a signed Rule 22, which is permission to broadcast, live stream, record for these defendants this hearing. We filed that motion with her clerk on November 25th, but the judge never signed it. Interesting. Because they also didn't give them a chance. I mean, maybe that's just not indicated here, but it sounds like it wasn't denied, and there was also no hearing for Law and Crime to, make their argument why they should be allowed to record this. So, I mean, I know there's a holiday in between that, but we still had yesterday. Whitaker had time yesterday. Do you guys think Whitaker had free time yesterday? Yes, we had 2 sets of jury questions for like an hour each apiece, somewhere around that. But I don't know. All right, awesome, Red Bunny. Yep, and this is not unusual. The status update was reset for Friday. So, and then it will be streamed. So, that's not unusual, you guys, for status hearings. Like, all right, are we ready? Nope. All right, well, let's get back together on an upcoming day and see if we've gotten it together then. That same thing just happened yesterday with the Courtney Clinny case. Coincidentally reset for this Friday as well. And the defense did say they've done all their depositions in the Courtney Clinny case. So maybe on Friday we'll finally get a date for the OnlyFans murder trial, the Courtney Clinny trial. I don't know why it's not giving me Kathy's updates in my, like, I have the bell on for her. So let's see. Well, in any case, here comes drama, says maybe she was making up all those lunch days she had to reschedule. Oh, man. Oh, boy. Hilarious. So Harp City, sorry again that I couldn't quickly find. We could go through the ledger here. You guys are gonna have to give me an assist here with remembering who's who by the time I'm done reading this. Let's go to the portal. This probably would have been the smarter way to do it. At least to get the attorneys' names. It won't really have much context about, the last thing they were participating in. But let's see. We've got Khalif Adams. That's Tiambre is representing Khalif Adams. Let's look at Blaylock. Thomas McIver Clyde. Oh, that's AJC. No wonder that name sounds familiar. Hold on. Sean Hoover. Okay, so Sean Hoover we've seen, I think, with some of the plea deals. Right? Sean Hoover. Was that Wooney Lee? Sean Hoover helped somebody else. Also, lead attorney here, Justin Hill. Or Hill Justin? Maybe this is backwards. Or maybe their first name is Hill. I guess we'll find out as trials proceed. Who do we have next? Let's look at Javoris Bradford. Okay, hold on. The portal's being a little silly. Let's sign back in. And Jennifer says Sean Hoover is defending Ernesto Williams in another RICO case. We've also got, and thank you to Mook. So, updates from inside the hearing. Jimmy Winfrey might be interested in a plea deal. Love has a status update on Justin Cobb, but didn't want to make it public, so they are at sidebar with Cobb's attorney. Cobb is the one that's been on the run. Judge just took a recess to deal with another matter. So, I don't know if that's a jury question. The jury might have a question. All right, so let's get this feed. I do have the feed running, so as soon as we hear some noise going on, we'll toggle back over. We can keep looking at the attorney names in the meantime. So yeah. Recess this remaining hearing until 10:30. And this is a good point. Maybe it's assigning the Rule 22. Let us in. But if we look back over here, who are we looking at? Javoris Bradford? Before the portal did portally things. Oh no, I'm familiar. I'm well familiar with Nicole Fagan. I know she was arrested, and from the last that I heard, the charges haven't moved forward against Nicole Fagan. They said that she was like interfering with justice because she allegedly let a different client, not in the YSL trial, know that that the police were looking at him and to be careful with something. I'm forgetting the exact details. But funnily enough, that's just sitting. Nothing's moved forward with that. So I don't know why when I click, is it doing it for all the names? Well, let's refresh this window. This portal is so janky. Like, it's always just doing something. Let's try Justin Cobb first. All right, so Justin Cobb is the one that's on the run, but there's a status update. Active attorney is Kareem Cashlin. I wonder if there's any document updates besides... Nope. So, there's Justin Cobb. Try Javoris. Yeah, there's something going on. It's not letting me look at Javoris Bradford. So, we'll just put a pin in that one. Maybe we can Google that name and get a attorney name. Oh, okay. Eppinger has all the attorneys. Eppinger has Eric Johnson, Eric Cho, Dolores Hurd, and Sean Hoover. So this might be why I know this name too, is from reading the Eppinger bond hearing stuff. So, because remember, Eppinger got bond. He was granted bond. Let's see. Miles Farley would be the next one. Who do we got? Okay, so Miles Farley has. Oh, okay. Oh, yeah. So Anastasios Menetas, that's the one that was accused of. He had the prescription pills with him in court, and they like detained him in court and accused him of like trying to smuggle stuff in. And it was just his own prescription pills. So he's probably a familiar face. Let's see. If you watch any of the pretrial stuff. Okay, I'm not going to pull up the mugshot picture. We're not going to do that. But this is him. Because I don't think it's right that he even has a mugshot. But that is Anastasios. And let's see. And then also Chelsea Golding and Atia Vareen are attorneys listed for Eppinger. I think we're going on to page 2. Javon Fleetwood, who is considering taking a plea deal. Right? Am I getting names mixed up? Well, what did Kathy say? Nope, I lied. It was Jimmy Winfrey only. Only Jimmy Winfrey. So let's refresh on this because I just got it wrong. Jimmy Winfrey might be interested in a plea deal. Love has a status update on Justin Cobb. So there we go. Back to this. All right, so Sean Hoover also, with lead attorney here, Mohammed Luemba. Dang, Sean Hoover is out here everywhere. Let's see. Yes, Rebecca, that was a reason she gave, that the defendants are in their jail garb. So. Ooh, so Joseph Papp says, my understanding on Rule 22 is that it's attached to the case, not the defendants. Yeah, that's what I was thinking. I thought maybe there was a separate case number created or something. That they did something just to give a separate identifier to the next trial. So we'll see. We'll see. Yeah, I don't think there's a guarantee that there's a question. It just seems likely that there's a question, you guys. So, going back to figuring out these attorneys, let's count how many times we see Sean Hoover. He is everywhere. Let's see. Yeah, Miss Candy, that's kind of visually what I remember. That they were in the blues. And, you know, typically my understanding is it's not in front of the jury, so you don't necessarily have the same argument to make, right? Because it's not really gonna, I guess there's an argument that everybody's gonna watch this televised hearing and could see, because it's just so popular. It could taint the jury pool. But really, the protection is so the jury doesn't see you in your jail clothes or in handcuffs or shackles, because it's just inherently prejudicial. So, let's see. So, Judy, I do have the window open. And we'll toggle over here if that's the case, but I didn't see Kathy say that they're going live at 10 a.m. for a jury question. And Law and Crime's the one that controls the camera, so... but we have it open either way, so we'll have it. Who's next? Well, now I'm getting confused. Did we just do Javon Fleetwood? We're gonna get a deja vu if I did this already. Yeah, okay, so we did that. My bad. Let's go to Demikian Garlington. Okay, so Thomas Mondelli. Thomas Mondelli. Thomas R. Mondelli. Demise McMullen is Clarence Hollins, Terrell D. Dark, Willis Bryant Green III, and Meng Hui Lim. He's got a whole squad. Well, we can look at Tinquarius Mender is Nicole Fagan, but maybe there's other counsel of record. Nope, just Nicole Fagan here for Tinquarius Mender. And Nicole Fagan might be someone that rubbed off on Doug Weinstein. I mean, Nicole Fagan, her philosophy is letting your client play an active role with you in their defense. And she has a book on it. Got something. Got Proof is the name of the book. So there you go. Nicole Fagan, Got Proof. But her philosophy when she's representing a client is to have them play an active role in their defense. So yeah, so she was arrested, but there's been no movement on that. They haven't done anything with it. So, and that's been like a year. All right, I think we have jury question live and ready to go. In the meantime, my bad on slowing down here. Harp City, thanks for this question, though. STS says prior status hearings were under Glanville. Yes. So this might be a Paigeism. I like that. Paigeism. Yeah. So, and I wouldn't, I know Love specified she doesn't want to talk about the Justin Cobb thing on the record, but I don't really feel like the state opposed a status hearing being... A lot of status hearing stuff, pretrial stuff, you get to say things that are favorable to your case as the prosecutor. So I don't really imagine the state would oppose that type of thing, but who knows. So yeah, Paigeism might be the reason here. Ajina here says, Love thought this case was going to help her political aspirations. Her future opponent will have plenty of sound bites. Oh my gosh. I can't wait. If this is the case, I can't wait to see it. I wouldn't even be able to participate in like the local election because I don't live in Georgia anymore. But I would watch. And on Twitter, I know you guys would probably be helpful, like clipping the sound bites. Like, here's one. Here's one. Oh, this is so funny to think about. I love this little food for thought here. Thank you so much, Gina. Brooklyn, thanks for becoming a member. I swear you've been green before, but welcome back. Nick Starro, thank you so much. Says make the chat blue, and then I think it's green. But 5 gifted memberships, so 5 chat members are now green. I think some types of color blindness might make green look blue, right? So in a way, could also be making 5 people look blue, depending on the beholder who's looking. So thank you so much to Nick Starro. Make sure you guys are saying thank you in the chat if you got a gifted membership. And you guys already know the drill. This is not the Big Nick or the other Big Nick mentioned in the trial. This is the Nick Starro that streams this trial. The other Big Nick. Let's see, Nick. My YouTube, my internet browser always wants to pop up your old @ name, and it says this channel's not available. That when you had Nicholas Starro trial watch. Um, so I'm always like, what happened to his channel? And then I realized you changed your @name a long time ago, and my browser never updated. So make sure you follow the other Big Nick here. Link is in the chat. And no, I think this is actually going to be a jury question. The status hearing is in recess until 10:30 because of another matter, and I think that other matter, it certainly seems like a jury question. So, and yeah, Moby, I think that's like such a weird, that's a weird reason. And in a way, I want to like, I guess that's like kind of cool. Let the public, if the defendants want to be seen, like, remember Woody said, you don't want them to see what you did to me when he was a witness. They didn't want to put him on the stand without street clothes because they had held him over the weekend in the jail and they wanted to put him on the stand, but the state didn't want him to look like he was in jail clothes. And Woody said, no, put me out here like this. Let them see what you did to me. Right? But I thought this was weird too, you know, pretrial hearings, and recently Sarah Boone asked to be able to wear clothes to the pretrial hearings because they're televised and people would see her and it could affect her defense. And she tried, I think she made a okay argument for a pro se defendant, but it was denied. You know, you don't have the same rights when the jury's not there in front of you. So, yeah, it just seems like it just doesn't doesn't make sense. Oh boy. All right. Gonna retweet this from Kathy, but she just gave us an update that the camera's back and she thinks there's a note from the jury. Show this thread. Is there more? Okay. I guess show this thread on X means replies, not just the original poster making more posts. So we'll go back over here. And if you're just joining somewhat recently, I think it's interesting to note that they did account for some overcounted time. They reset the verdict clock a little bit because it was around this time when we ended yesterday. And when I pulled up the stream today, it was at like 14 hours and 59 minutes. And we were well over what looked like 15 hours yesterday. Because I was like, guys, we hit 15 hours. And then technically we actually hit 15 hours sometime this morning. So this is adjusted a little bit. Yeah, so there is a hearing in the open records case today. I believe that's at 1:30 p.m. Eastern. And yeah, so I don't know this whole logic about not showing them in jail garb. I mean, if the defendants don't want to be televised and they've made a request for this not to be televised with them in those jail clothes, I guess I don't know. I still think the public has right to access, like, why it couldn't have been audible, right? Record it, have the camera on, but getting the audio feed while not actually panning the camera around the courtroom. What's the explanation for that if the reason is the appearance, the clothing? So who knows? I don't have an answer. I don't have an answer. I just have a little bit of confusion here. Sonia says Justin Cobb interested in a plea. Hold on, let's get that tweet again, because I kind of did the same thing. So, a status update for Justin Cobb, but they didn't want to make it public. So, from what we know from Kathy, we don't actually know about Justin Cobb. But for Jimmy Winfrey's interested in a plea. Right? So, two things here. Two different people. But I did the same thing. I was thinking of Winfrey. Who's the other guy that I got the name confused with? And had to correct myself. Was it Javon Fleetwood? I think it was Javon Fleetwood. I got them mixed up here, so I had to reread this twice too. But that is our update from Kathy. Thank you, Sonia. And Renee Stevenson, are you going to stream the Fani hearing today? Well, on one hand, I don't want to have two instances today where I pull something up to stream it, and they're like, oh, nothing's actually gonna happen, right? With the status hearing, they're like, no cameras, no Rule 22, oopsie, can't stream it. With the Fani hearing, I could pull it up and then she might not show up to testify. She might not show up to speak. So, and Woody spells it W-O-O-D-Y, but the state just likes to never get things right. So even in their closing arguments, the state was still spelling names wrong. Names of a key and important witness who was on the stand, I mean, technically for over a month because of the pause in between. You know, not a little deal, not like we haven't heard his name, not like we haven't had to write his name many times, yet they still can't spell his name right in a closing argument. So, who knows, who knows. Also, I've been waiting to try to see, but just in case he said hello and I just happened to miss it, is Sapphire Ridge News in the chat yet today? Because Sapphire Ridge News sent over $20. We're going to order a toy for the Angel Tree wish list. But I'm looking for him. I want to make sure if he wants to help pick something, he's here for it. I'm scrolling up and this is tons of chats. So good morning to everyone. Sorry I missed saying hi to everyone. We got right into it today. But I'm here, I'm looking here for Sapphire Ridge News. Show me some signs of life, Sapphire, if you're in here. So you can't see me. What I thought was interesting, and honestly, I hate to say it because it's such a sad story. The woman, Jamie Komorski, the one who was awaiting trial, her trial was supposed to start yesterday. She was driving drunk, and her blood alcohol test was 3 times the legal limit. She struck a golf cart that was carrying like a husband and wife that just got married like minutes or maybe like an hour before, and the wife passed away from the injuries. The husband was badly injured, and 3 other passengers in the golf cart were also injured. She got up and pled guilty, no plea deal. She just pled guilty before trial started, and I have an ounce of respect for her doing that instead of dragging her through a trial. But yeah, a lot of settlement outcomes recently. Let's see what we've got here. Christina Weaver.
All right, good morning, everybody. We have a verdict. We have 2 verdicts. And I do not want there to be any kind of disruption or disturbance in court, regardless of what this verdict is. So, can we get the jury out, please?
Wow. So about 15:45 of deliberations. Holy moly, you guys. Yeah, I wasn't ready for it either. Oh boy.
All right, thank you very much. All right, ladies and gentlemen, I understand that you all have reached a verdict. Mr. Foreperson, is that correct? All right, and was it unanimous? Yes. All right, and this verdict has been filled in and signed and dated by you, correct? Or for each defendant? All right, and I noticed that Mr. Kendrick's verdict form is dated December 2nd. Is that because that's when you all reached the verdict with regard to him? Okay. And then Mr. Stillwell's is dated today? Correct. Okay. All right, Mr. Kendrick. You have been found not guilty on all charges. Mr. Stillwell, can you please stand? You have been found guilty on count 64, possession of a firearm by a convicted felon, and not guilty on every other charge.
Holy moly.
So, ladies and gentlemen of the jury, you are officially released from further service, and I cannot express the degree of thanks that Fulton County owes you for your service, given the length of this trial.
Wow.
You have paid close attention this entire time, and I appreciate your devotion, as I'm sure do the parties in this case.
That means
you
Yak
are
is going to
welcome
be
to
free.
stay for the sentencing, or you can return to the jury room. I would like to speak with you in just a moment in the jury room. If you all do want to stay, you're welcome to stay. Is there any objection to the form
I'm
or
here, I'm
the
turning my camera
legality
off.
of this verdict? Any from the defense? All right. All right. Is there any reason that we can't go ahead and sentence? You may.
All right, approaching instead of doing sentencing right now. I think, so count 64 could carry time, but I wonder if they could do it as probation instead of in custody. Holy shit, you guys. And she just flat out read it as not guilty on all counts. They didn't go through it count by count and do the suspense. Wow, 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 wow. Whew. And not for nothing, but imagine they finished the status hearing and someone like took a crappy plea deal. I mean, this could impact how they approach the other defendants, maybe in a positive direction, maybe in a negative direction, right? Who knows if the state's going to come forward with more scorn. If you're joining now, I know the news was late. Deamonte Kendrick is not guilty of all counts. Shannon Stillwell was only found guilty of the possession charge, which we talked about that a little bit, guys. You know, having that, I think it would come down to having that FN in the car, the gun that belonged to Taisha Alexander. Like, I don't think he could just say the jury probably decided he didn't just accidentally have it in the car and didn't know about it if he knew to throw it out the window. I would love to hear their thoughts on that logic, but I imagine it's something like that. Let's see. So this is a charge that was reduced down. Remember, there was a partial grant of the verdict from 133 to 131. And they're back from the sidebar.
All right, so are we going to go ahead with sentencing? Is the state, I know the state had filed a recidivist notice.
Yes, Your Honor.
Do y'all intend to
fight
stand
this.
on that?
Yes, Your Honor.
All right. So the recidivist is A and C recidivist. That means that I have no discretion but to sentence to the maximum on that count. And the sentence possibility is 5 to 10. I must sentence to 10 years. However, I can probate any part of that sentence
Probation.
at my
Let's do it.
discretion. And so the court sentence on count 64 for Mr. Stillwell is going to be 10 years to serve 2, with credit for time served, the
He's
balance
free.
served on probation.
Wow.
All right, I am going to recess.
So Stillwell's coming home.
I'm going to recess for a moment, and we will reconvene on the status conference in a few minutes.
Wow. let me just write that down, get this all right.
You have 30 days to file a motion for new trial if you choose to do that. Your
No.
attorneys will represent you on that unless they are excused from that representation by me. You also have 30 days from either this date or the date the motion for new trial is ruled upon to file a direct appeal if that's something you would like to do. And given that this is a felony conviction, you would have 4 years from the date that those direct appeals are finished to file a habeas corpus petition challenging anything about the constitutionality of this conviction and sentence. All right.
This is honestly, to me, it's fair, and I hate that firearm possession can be used in such a crazy way, right? I think there's a lot of people doing time because they had a firearm on them, and I think it's a tool that police weaponize. But at the same time, I completely understand how the jury came to this conclusion. I have faith again. I have so much faith again. Like, oh, I can't wait to go into another trial and be like, I don't trust juries all over again. But wow. Oh God, let's see what you guys are saying. And honestly, shout out to Whitaker. She said, I have no discretion on the time. I have to do 10 years, but I can probate it. That's kind of how she delivered it. Wow. So lots of caps. You guys can use all caps in the chat. Lots of wows in the chat. Whew. And Jim, you're in the chat. You saw, and I'm sure you're not shocked. Of course, Hilton wanted to push forward 100% with the recidivist notice. So, recidivist, as they spell it. They skip some vowels there. Paige turning them loose. Oh man, the state is sick. Yeah, and they've got to approach the stuff with the remaining co-defendants. And if I see evidence that suggests, something about the other co-defendants, I'm not going to go into it and be like, free them all, right? I'll listen to what I hear. But if they present the same style of case for the remaining co-defendants, I'm going to feel the same way. I'm going to end up feeling the same way. Tay-Biz TV says the state looks cooked. Heck yeah, they do. Oh boy, and my thumbnail has the wrong date in it, you guys. I had a thumbnail prepared yesterday, 12/2, saying the verdict is in, so I threw it up real quick there. I'll fix the date eventually. And I guess technically the jury said they did their verdict for Yak on the 2nd. They knew yesterday that Yak was not guilty, and Doug was out here stressing. Whew. This is crazy. Hold on, let's show... This is crazy. I hope we get pictures of them leaving. But I think this time, unlike no other, once again, let's show some love to Thugger Daily, who's been in this for the long haul. Like, you can see the numbers on these posts just going up right now. People hearing the news. But definitely the person, if you want to share someone talking about the verdict, I think this is the best place to share the news from, is Thugger Daily. So, and let me get through, my bad. So Leah's dad says, as someone critical of Whitaker, this is a win move. Yeah, and the way she did it, guys, I'm saying that tone stood out to me. Like, she was like, I can probate it though. That stood out. Whew. Yep, conviction on just one count is such an L for the state. Huge L for the state. Let's see. My military mind says, yes, grown old men can cry. Praise God. Heck yeah. Love seeing that super long hug with Doug and Deamonte Kendrick. Love seeing it. And I can't believe he just got stabbed in the head. Right? And this isn't to fault the jury, right? They took their time, they did their thing. But if timing lined up that the verdict was reached last week, then the cards wouldn't have been in place for that to happen Sunday night. Isn't that just crazy to think about? So Renee Stevenson, does this mean Miles is free and won't have to go to court? No, unfortunately. However, it could change the way the state pursues a case against him. Maybe they'll reconsider any deals that they offered him, maybe change the terms of it. It might also mean they tighten up and adjust the way they present their case if they still want to insist that those two cars are responsible. Now, what'll be very interesting to me is, say they go with the theory that Deamonte and Garlington reached across Shannon Stillwell in the car and convince that jury, no matter what the video shows, that the shots came from that car, and they find Deamonte and Garlington guilty after all of this, right? You have no RICO. So we have this is the first time we have a disposition by a jury. This case has been fully adjudicated. We got through sentencing. The jury said no RICO. The jury said no RICO. So what does that mean for Fani Willis, who likes to get up there and brag? She misrepresented the plea deal for Jeffrey Williams. She made a statement saying that he pled guilty to the gang charges, which he did not plead guilty. He did NOLO to those charges, the gang and count 1, RICO. What are you going to get up there and say? Let's emphasize this on Twitter here. Jury said no RICO. I think that's huge. That's huge. Because now the only guilty we have for RICO was a plea deal from someone that was probably sitting in Rice Street. So where is the RICO? We can ask it all over again. All right, yeah, we can replay it if you guys want to replay it. I think this is a huge moment, and it was short, so let's just replay it. We'll skip the part where Stillwell Shart approaches. Let's replay it. Oh, sorry, I never shared the screen. Oh my god, guys, sorry. A little bit of a boomer moment there, my bad. Thank you, guys.
All right, thank you very much. All right, ladies and gentlemen, I understand that you all have reached a verdict. Mr. Foreperson, is that correct? All right, and was it unanimous? Yes. All right, and this verdict has been filled in and signed and dated by you, correct? Or for each defendant? All right, and I noticed that Mr. Kendrick's verdict form is dated December 2nd. Is that because that's when you all reached the verdict with regard to him? Okay. And then Mr. Stillwell's is dated today? Correct. Okay. All right, Mr. Kendrick. You have been found not guilty on all charges. Mr. Stillwell, can you please stand? You have been found guilty on count 64, possession of a firearm by a convicted felon, and not guilty on every other charge.
Look at Max. I love that you can hear the hug smack.
So, ladies and gentlemen of the jury,
You are officially released from further service, and I cannot express the degree of thanks that Fulton County owes you for your service. Given the length of this trial, you have paid close attention this entire time, and I appreciate your devotion, as I'm sure do the parties in this case. You are welcome to stay for the sentencing, or you can return to the jury room. I would like to speak with you in just a moment in the jury room. If you all do want to stay, you're welcome to stay. Is there any objection to the form or the legality of this verdict?
No from the state.
Any from the defense? All right. All right. Is there any reason that we can't go ahead and sentence? You may.
We'll skip it a little bit.
Going to go ahead with sentencing. Is the state, I know the state had filed a recidivist notice.
Yes, Your Honor.
Do y'all intend to stand on that?
Yes, Your Honor.
All right. So the recidivist is A and C recidivist. That means that I have no discretion but to sentence to the maximum on that count. And the sentence possibility is 5 to 10. I must sentence to 10 years. However, I can probate any part of that sentence at my discretion. And so the court sentence on count 64 for Mr. Stillwell is going to be 10 years to serve 2, with credit for time served, the balance served on
The
probation.
relief on Max's face right there.
All right, I am going to recess.
Look at bots.
I'm going to recess for a moment, and we will reconvene on the status conference in a few minutes.
So let me fast forward this. Maybe I'll keep Law and Crime open. Remember, this camera's in the courtroom, so it's pretty much fixed there. But I do want to open Fox 5 Atlanta because sometimes they do pressers. Let's see if they have anything live. They're still showing the seal, but I am going to open a window. Keep that open. Close. I have a bunch of tabs open from these articles. And let's do 11 Alive does a lot of pressers too. So I want to keep those open, and we'll cut over. I think this is just a lady talking. Let's see. All right, so I have a few streams playing, and if I hear anything with the presser, you guys can tell me in the chat. We'll make sure we go over and look at it. I would imagine we're going to get some pressers from the attorneys if they're willing to speak. And yeah, that's right. Miss Weaver starts and finishes it. She showed up for, I think, an interesting day. A cases Whitaker is beyond fair. She had her issues, but she saw the state for exactly who they are and acted accordingly. And I do think it's really interesting. I feel like she harbors some type of remorse for the way she sentenced Mungtung. That's just my own kind of like gut feeling. I don't have anything to, hey, Whitaker said this thing. No, it's just my gut feeling, right? I think she was pretty harsh to Mungtung. And then with the other pleas, and then now with this sentencing, she's been like, well, hold on, this whole case is a mess, actually. So, unfortunately, I think it took that Mungtung sentencing for her to get here. But just my gut feeling, Latasha Gaffney says, I want to cry, play it again, please. So we did. Do you want to play it one more time? I did also portion it out, clipped it out separately. Rather, you know, the first hour of the stream was waiting to watch a status hearing that we weren't able to watch. But it is clipped out separately. When we get through some of your thoughts, we could potentially watch it one more time. So hold on for that. We'll come back around to it. Sunshine says justice prevails. With the Statue of Liberty here and the justice scales. Love those emojis. See? Gotta be... I really hated the way they like demonize emojis in this trial. I like emojis. I like the way Sunshine here is using them. Mrs. Bennett says, God is good. Welcome home, fellas. What an outcome that they both get to come home. Right? Yeah, Shannon has time served. It's scrolling fast. The Cuff Boys is definitely going to be screaming. Oh my god, I can't wait for him to do his video. Whew, cannot wait. But yes, here it is. Miss Jess had said Shannon with only 2 serves. He's walking out too. He will be walking out. So, Jameer says, how have you been? And since I haven't been that active in this case, we're hoping for a guilty. Well, I was hoping for a not guilty. Although I think my stance was we were going to get a possession charge for Stillwell. And I wasn't trying to predict that as in make it happen. That's just kind of where my feeling was. So it wasn't like a hoping for a guilty. It was just a prediction that there could be a possession charge that came back. And I think luckily for Shannon, and I'm not trying to make light of probation. Probation is a big weight to carry over your head, especially with Vivarito hiding in the bushes looking for you. Especially it seems like she really liked watching Shannon Stillwell. But I think that's a better outcome than having to do time. Definitely doing time. So, good to see you. Thanks for popping in. Heart of Inspiration says, let's not lose the fact that not only did the jury find no RICO, but also that there was no gang activity, meaning that YSL is not a gang, according to a jury, not according to a plea deal. Right? That is also huge. That is definitely huge. Big shout out, tons of love to Heart of Inspiration. So glad to have you in the chat speaking with us today. What a day, guys. What a day. We started off with like disappointment, like they're not letting us see the status hearing, and then we get a verdict. And it's like, all right, well, we'll take it. We'll take it. Thank you again to Heart of Inspiration. Another great content creator, you guys. If you could show some love, that would be amazing. Latasha Gaffney says, all those typos in my comment. It's okay. It happens. We all do it. And the state does typos in official documents, so don't be embarrassed. Don't feel bad. Gamba Kufu says, thanks to Kat and the mod. Shout out to the mods for making this super long trial feel like it was quick. Get those likes up. Heck yeah. Hashtag YSL free. Be careful now. Be careful now about them hashtags. They might show up on an unredacted exhibit there. Thanks for being with us, Gamba, and showing love to the mods. Janky Grandpa says, great news, let's go. Heck yeah. Heck yeah. And I think this is the closest you can get to an FU to the state for the way they presented their case. Like, do you think this is a win for them? Someone was found guilty of having a firearm. You took an L on 2 murders. And I guess you still have other defendants you're going to try and hopefully try to get a conviction against somebody for these 2 murders. But when you're saying that the murder was a gang ordeal, a gang activity, and half the people you're accusing of being responsible for it were found not guilty, it doesn't seem like you had the right people or the right theory of the case. Heck yeah. J-Dub says, I bet that status hearing has a change of tone now. Isn't that so interesting? The verdict came down smack dab in the middle. Whew. Whew. Right! RG, put the numbers to it. RG224 says they wasted $20 million for a gun charge. Like, holy moly. That's a lot of money. Michelle Warden says, group hug, yes, justice served for Shannon and Kendrick. Heck yeah. Heck yeah. Marlena Max says, thanks for being such a great host, Kat. Hold on, thanks for being a great chat, because I could very easily be a grumpy host or not want to do this anymore if I didn't enjoy the chat, if I didn't enjoy, there's 2 sides of a live stream, right? So thank you, chat, because if I didn't love you guys, if I didn't love the people in the chat, there wouldn't be a point in doing a stream when I could just go watch it somewhere else. So Marlena, thank you for the kind words, but right back to you and the rest of the chat. Nika says, I'm so happy for these men, literally in tears. Yeah, I had to turn my camera off. I think if I was like prepared for the verdict, I would have been a lot more waterworks. That was more of a, oh my God, this is here. The verdict is here and it's not guilty. Whoosh. So I got it together pretty quickly, but I understand. Lady BC says, praise the Lord. Yes, I'm not particularly religious, but it certainly feels like just a moment, a whole moment, right? Something that you can't really put into words. Oh, Sassy just got here saying I missed it. Go back about, and we might circle it back in a little bit here. But if you go back about 15 minutes in this stream, you'll be able to see it. Glad you got to join us, Sassy. Mr. Rev Up says, I know Brian Steele is pissed off. You know, I think Brian Steele has a good way to deal with looking at the world, looking at the things that happen. So I hope he's not actually pissed off. But that loss of opportunity to really argue why this is so wrong, what the state has done, I know that that's kind of like got to make him feel like lump in his throat a little bit. Pissed off, I don't know if pissed off is necessarily the right emotion that I would use, but I'm sure he's feeling something, right? I'm sure he's also feeling a lot of joy for these two defendants and these two co-counsel, as well as a lot of joy that this was a big L for the state. So, Creative, I like the way you spelled this. Creative Brain maybe is your whole name. The real winners in this case are these two. Young Thug should have gone all the way. He would have been a free man versus that plea deal. I think that that's very possible, right? I mean, if they didn't find these two guilty of the Donovan Thomas murder, they didn't find them guilty of RICO, they didn't find them guilty of gang activity. And again, you can't know for sure, but I would guess that they wouldn't find similar charges for Jeffrey Williams. Now, unfortunately, don't forget, they did find Shannon Stillwell guilty of possession, and they were asking about, well, was Yak's watch, was that Yak's watch? Did his attorney say that that was his watch? Well, if Thug got stuck with those possession charges, you know, the way you can navigate sentencing could be a little bit different. He wouldn't have had a recidivist issue, Jeffrey Williams. He wouldn't have had to deal with that. But I think he had a lot of possession charges on there that could have tacked some time onto him. So at the same time, I think he would have won against RICO and the gang charge counts, but I don't know if the jury would have found not guilty on the possession charges relating to the raid. So you've got to take all of that into consideration here. We'll never know the exact option, the possible outcomes, but I don't think he was just clear cut to get through unscathed. The jury was clearly willing to find somebody guilty of a possession charge. So, yeah, the Butt Nuggets mom, and I love to say your name, Thug would have been found guilty of the drugs and guns that were in his home, in my opinion. I'm leaning that way too, based on this verdict that we got for the other two, and that question about the watch. So you just never know. But yeah, I still agree, like, it could have been a played even, right? He could have been found guilty of something, but still been free and maybe less than 15 years probation, depending on the math. So, you know, I don't have an absolute response to this, but just some food for thought, and I appreciate it. Penny G says the state has egg on their face. A bunch of eggs. A whole dozen, a baker's dozen. This massive trial all for one gun charge and 0 time. Yep. Crazy. Crazy. Miss Suspicious says God is good with the green heart emojis. Drop all the green in the chat. Heck yeah. Heck yeah. Love to see it. We gotta use the mess out of these green emojis now. Some nose swiping. Make sure this season, right? Cold flu season starting, got the sniffles. Always wash your hands, especially if you wipe your nose. but I can't wait every time I'm going to watch a game and I see an athlete do this. Is that Shark walking by the camera? I'm just gonna think about this trial. Every single time I see it, I'm gonna think about this mess of a trial and how the jury came back and said no RICO. No gang charges. Like, just a mess. Just a mess. Doubling back, I just toggled between a few of the streams here. Nobody's showing a press conference at this point in time. I do want to look. Do we have anything from Doug yet? I'm sure Doug has so much. I mean, probably trying to make sure his client is good, right? And I'm over here looking for a tweet. We'll see it when he tweets something. We'll keep looking. Look at all the green. Look at all the green. Oh, we have a Kokomo tweet. I don't have a notification for him. Oh, I don't even follow Kokomo. Hold on now. He comes up on my feed all the time, so I just assumed I followed. But that would explain. Oh, heck yeah! He just said F yes. There we go. There we go. So we'll get that going. Shout out to Kokomo. Is this Max just standing here in the corner of the camera? Oh boy. Yeah, Dennis. I mean, this is where Eileen Thug would have probably got the gun and drug charges. Probably the same outcome besides the RICO not guilty is big. I mean, the no RICO is just crazy. More than ever, I cannot wait for a press statement from the district attorney's office. I just can't wait. Like what are they going to say? Are they going to try to twist this as some type of... Are we just going to get up there and say they were found guilty on all counts when they clearly were not found guilty on all counts? Just like we misrepresented the plea deal. And heck yeah, I would love to watch more of Max Shart's trials. Doug as well. If you guys see that they're defending somebody and you want to tune in, I love watching. They're very different in their styles of lawyering. And I don't know if we'll have an opportunity to watch them kind of play on the same team again, right? Unless they end up representing co-defendants in the future. They'd be working individually, and I think that'd be interesting to watch. They have to go back and do the processing to be released, Niecy Lynn. So I would imagine that the attorneys are going to be sorting that out. Whew. Oh boy. Positive Q, so when will we know the appeal status of Ryan? I mean, I don't know. Let's see. I don't even think for the Blaylock appeal, which was heard last month, I don't know if there is even a forthcoming opinion listed for that yet. No, so not yet for Damon Blaylock's appeal. As far as the appeal for Rodalius Ryan, I don't actually know any time frame for any movement in that. But for Damon Blaylock, which is a similar matter, it's the same underlying case, still no forthcoming opinion announced yet. So, but maybe it's December 3rd, maybe in the next couple days, this will update, and we'll see. We'll check back. But good reminder here. Thanks, Positive Q. I feel like I keep flipping back here and all we're getting is random cuts of Max as he walks by. Shamina Wright, happy birthday. All right, everybody take a moment to say happy birthday in the chat. Happy birthday to Shamina. Shamina says, great way to start off my birthday. Heck yeah. Heck yeah. Big cheers to that. Hope you get to do something extra nice. This is great news. Great energy today. Whew. Yeah, definitely big emotion here, Natasha. Definitely a big emotional day. I can't wait to see the attorneys speak. And one of the most beautiful things, one of my favorite post-acquittal verdict was Travis Rudolph. Let me know in the chat if you guys watched the Travis Rudolph case. That was a man in Florida, his ex-girlfriend or situation, Dominique, set her, I think like a brother, cousin, and two of their friends to get some get back. She told them that Travis Rudolph like hit on her or something. When really, there was some infidelity. Dominique was like married, but she was mad that Travis Rudolph might have been talking to another woman with a natural butt. It was like a crazy case, but she sent her family members and their friends to go to Travis Rudolph's house and try to set them up And Travis Rudolph's brother ends up like chasing one of the four down the street. So Travis Rudolph chases after and ends up shooting through the car and killing one of the four that came to jump them. So the question was, is this still justifiable use of force when we ran down the street? And the jury found whatever logic they got to was in that moment, because Travis Rudolph was firing because he claimed he saw someone in the passenger side point a firearm through the windshield, so he started shooting at that moment. They found it was in fact justifiable use of force because in that moment there's a new trigger, a new reason. Someone in the car pulled up a firearm and was threatening your life all over again, and they acquitted him. They found him not guilty, and he came out, he was hugging his attorney, and that was such a great moment, I think, to watch. Like, because at the end of the day, it's like, don't show up to my house to shoot me up. It's kind of how I felt about it, right? And I really love seeing that moment between his attorney. And I think they did some interviews with Brandy Churchill. The attorneys did some interviews with Brandy Churchill. I think that's her name. And it was just really heartwarming to see how emotional it was for the attorney and Travis Rudolph. Megan B says they should play Lizard Walk as they leave. All right. Well, let's see. I'm going to send you not a redirect. But if you guys want to check out Dennis Byron, there's a link in the chat if you want to hop over there. So if you want to check that out, support Dennis over on his channel here rather than having me stream snipe it. But his link, I just dropped it in the chat there. Yeah, Michelle Warden says, I am screaming and thanking God. The jury's seen the lies from the state. Yep, and that gives some weight. We gave multiple considerations to why might they be asking this question. We don't know for sure, but what are the possible reasons that we can come up with? And one of those possible reasons was they're fact-checking the things that the state said in their closing argument. And then they're going, oh, no, now that we watched it back, we don't need to watch it again. We saw what we needed to see, and it's not what the state told us in closing, right? So I think this is I think we can definitely, I think it's safe to say there's a good possibility the jury thought the state was making some lies and misrepresentations there. Because again, they didn't just walk in the door and come right back out with their middle fingers up to the state, right? They looked through the evidence and they still said, nope, we don't see what the state is saying here. Thank you, Michelle. Sandra Sublet says, tears of joy. Kayla, your husband is coming home. I know Kayla usually does a WTF Wednesdays every Wednesday night, obviously Wednesday. That might be for sure one to tune into. She does it with Miss Jefferson and Millionaire Mel. But yeah, her husband's coming home, so that's probably a good moment here for Kayla, for sure. And I believe she was on a cruise and she's home from the cruise, so timing works out. The timing definitely works out there. Errol Glee, I almost said Errol G, says, great job, Kat. Love your channel. Thank you so much. Thanks for being a member. Heck yeah, she done. Shannon can now say I beat a murder charge. He can redo that song and actually have it be true. The state's got to be so mad about that. You made his song come true. Before that, his lyric was just like fantasy. You made it reality. And not in a direction that favors you, state. Love this, she done. Thanks for the reminder there. I didn't even think of that, but that is great. Nancy New One Too says, Shannon has been living with this over his head for 9 effing years. Both have been stabbed, Shannon twice. A woman died due to this. And they were so... The way that the state would just kind of like... And really this was Adrian Love for the most part. Like, barrel over this Tiara Jones story was a bit offensive, was a lot offensive. right? You mumble into the microphone, he was loved. When you're talking about Donovan Thomas, you fight to put on victim impact, what I think is victim impact statements in the middle of the guilt phase of a trial by bringing Donovan Thomas's parents on the stand. And yet, when it comes to Tiara Jones and Shannon Stillwell and Shakoya Duncan, the incident that they went through, you're kind of like, oops, hee, collateral damage. That's the read I got of how Love looked at that scenario. And I don't really think that that's fair play as a prosecutor. So, great point here. Nancy knew one too. And 9 years is a lot to think about. I mean, think about what you guys were doing 9 years ago. So, is Doug live on an interview? Where is Doug live? Or is he like live on TikTok? Because I don't see an interview from 11 Alive. Fox 5 is showing the Georgia seal. Where is Doug live? Where is Doug live? Yeah, you guys keep saying in the chat Doug is live, but where is he live? Because none of the local news stations are showing a press conference or anything. So. I hear a woman speaking with Dennis Byron. I don't hear Doug speaking over there. Unless all three of them are on and I'm just not catching it. But again, you guys are more than welcome. You know, don't feel bad if you go over and watch. But the reason I'm not stream sniping it is because, you know, this isn't just inside the courtroom trial coverage. This is somebody's channel. So if you want to watch somebody's content, I'm going to send you right over there to do it. So there's the link again to watch that. I don't hear Doug's voice though. I just played it for a little bit just to hear when you guys started saying Doug was live. And I don't hear it. So. Yeah, so I don't know. I don't have anything live on any of the local news stations. Unless they've got a different stream. Let me see if 11 Alive has a different stream for it. No. Okay, it's an alternate juror on Dennis's live. Whew. I would be so relieved if I was an alternate juror and, like, they found them not guilty on the murder charges. Imagine you're an alternate juror and you have, like, the opposite opinion and the jury that gets to go forward votes guilty. And you're like, oh, I would have not been with that. Oh, boy. Yeah, I don't see anything currently live that is a press conference, guys. So it might be a replay. Of the press conference he did yesterday. Yeah, and I don't see, like, this is, like, I'm not lying to you guys. Like, Sylvia's channel is not doing anything right now. So, I don't know. I don't know what you guys are talking about. I'm sorry. But again, feel free, like, to go check out and watch something else. Is it on her other channel? Oh, well, heck, I don't know. So it's not Infamous Sly. Oh, she has 2 videos up. All right, so I'm going to link over there again if you guys want to go and check that out. This is the link to the live that where she's actually live. So feel free to go and check that one out. Oh, that makes sense, because I was like, I thought it was just my StreamYard messing with it, because this is all I see, so I don't know. So I'm just going to toggle back over there, and the link is in the chat for you. Jamila says, to be honest, Whitaker did what was right. The state got the 10 years and both get to go home. I'm so happy for them all. I was so nervous. What a weight has to be off everybody's shoulders in that courtroom. Well, on the one side of the aisle in that courtroom, right? Like, holy moly. Especially I can imagine, you know, Miss Betty and Miss Tasha, you know, mom and grandma. Just imagine what they're feeling like. I mean, I think that hug was so real. The relief on Max's face. To me, Short seemed more relieved than Stillwell. Stillwell was a bit more stoic in his expression. But as soon as Max heard not guilty on 64, but then heard, I mean, guilty on 64, but not guilty on everything else. As soon as the next thing after reading a guilty count was the words not guilty, Max went, like, it was a thank God moment. So, and I agree here. Thank you so much, Jamila. Sierra says, I'm happy crying with the green heart emojis. It's that kind of day, you guys. One happy white girl says, let's type hug in the chat and have a group hug. There is a hug emoji. I love the hug emoji. So take advantage of that. Shout out to one happy white girl. Positive Q says, good morning, Moz and chat. Word for the day, fight. They fought to the end. They fought for their freedom. I'm so glad Paige was here. Merry Xmas to them. I'm glad, and I still think that Paige had a turnaround around the Mungtung plea hearing time. I'm glad she did, though. I'm glad she did. I really think a few months ago, she probably walked in, like, with the impression that we wouldn't be here unless it was obvious that these men were guilty. This is such a huge, expensive trial, and I want to keep it going for that. And I really think she pivoted, and I'm glad she did. Thank you so much, Positive Q. Latasha Gaffney says, it was the zoomed in video. It showed the red car move when Shannon ran the red light, which means he wasn't shot at that time. Yep. And they only wanted to see that. They did want to see it in reverse, but forwards, they only wanted to see it one time, and that was it. So, and honestly, that's pretty impressive, because back in the jury room and then during trial, they didn't get to control and hit stop and play. They didn't get to go and replay it on their phone and zoom in. You know, they saw it when it was played while someone was on the stand testifying to it. They saw it played during closing. And then they saw it when they asked the court to allow them to watch it again. That's it. And they still saw it. They still knew something didn't add up about that 34 seconds. So great point here, Latasha. I think they took the evidence seriously. Jaha Lewis says, can this trial help the other defendants? I do think that it tightens up, it constrains the state a little bit. I think the biggest impact would be if the state did any self-reflection whatsoever, and I'm not sure that they will do that. But really, like, you would think a prosecutor might realize, like, hey, we couldn't convince this jury after this many days. We couldn't convince them of the guilt, so maybe we want to take a different approach to these defendants here. So I'm sure it'll have an impact. How much? I don't really know. So, KC Dog says, God bless them. Free Mungtung. I think this result was because of the cameras in court. My eyes watered. Very big cat sigh. Aw. Thank you for all your dedication and coverage. Heck yeah, no problem. I mean, I love doing this. I love having you guys to speak with every single day that we had a trial to watch. And yeah, still, the whole Mungtung thing is just kind of like, I mean, that's 5 years. Maybe he won't be there for all 5, but like, think about it. He didn't want to get up there and say that these guys did the Donovan Thomas shooting, this whole McDonald's meeting. And this jury, the first time we have a jury come to a conclusion, they're not buying that whole theory either. This jury did not buy that theory. So Moontung, if we boil it down to just being about that item number 8 on the factual acknowledgments, the McDonald's, that he had personal knowledge about the meeting at McDonald's or whatever. If we just boil it down to that, it seems like the jury found that that's not true, and the jury is the finder of fact here. So what they wrapped Moontung up on, that factual acknowledgement number 8, the jury doesn't seem to believe that that was a fact either. And there's no parallel application. It's not like the jury's finding here is going to apply to a Moontung's plea and probation revocation, right? It just, technically, it does not work that way. But in reality, when we use common sense, when we use logic, that just seems so twisted to me. He's in trouble because he says something's not true, and it was Miss Love's truth, and not the truth, not his truth. And then the jury also agrees that what the state's truth was, they don't find that to be fact. They did not make that finding here. Somehow, Moontung is still roped up for it. Just a little crazy to me. So, and thank you again, KC Dog, for, not just the super chat, but all of your commentary and insight throughout this trial. Kim Roberts with the all caps says, Merry Christmas. Heck yeah, home for the holidays. What a wonderful holiday it's going to be for these guys. Even if they don't celebrate, right? But you're home. You're home. And I think even people that don't celebrate every holiday, I think holiday spirit still rubs off on people.
Okay, and just don't show the Zoom box, okay?
Yes, ma'am.
All right.
All right, so we get to hear the status hearing, you guys.
Okay, so there's Telfair. Great. So we'll go ahead and admit him back in. Thank you for pointing that out. All right, so it may be that new offers will be forthcoming to all of the defendants. I mean, these are still very serious charges. I know that some of you all are young. Is Miss Weaver, well, she said she wants production. Okay. We have to start over because we're not taking any of this down.
He's hilarious for that.
I can't see around all of my various computers to see that she wasn't down there. She did tell me she was running out though, so that's my bad.
Terrell Dark, is he here?
Yes.
Okay. Dark, Judge. Okay.
All right, so the Rule 22
This is a status hearing, you guys.
was filed mere minutes ago, which is why I didn't have any notice of it.
What? Is this from AJC or who?
She forwarded me something that was sent last week.
Look at Miss P.
Okay.
Well, what I am looking at, actually says that they would like to record proceedings that commence tomorrow. So and that's from Atlanta News First. That's the only one that has been forwarded to me, is requesting something starting tomorrow, which obviously would not cover today. And it was forwarded to our public information office at 10:16. So there does not appear to have been any kind of Rule 22 even filed at the time this proceeding started at 9:30. That, regardless, You can tape under the circumstances that you and I already discussed. Just make sure not to show the defendants because they're not dressed out in civilian garb, if you will. All right, thank you. All right, we now have our court reporter. And so before we were officially on the record with the court reporter, I had let everybody know about the verdict that it had been returned in the trial that was ongoing until a few minutes ago in Mr. Kendrick and Mr. Stillwell's case. And it may be that new offers will be forthcoming to some or all of you. It may not be, I don't know. That is not for me to decide. That is for the state to decide. And the charges against some of you are very serious. Some of you are charged with murders. Some of you are charged with other very serious felonies. Some of you are just charged with RICO or gang counts. Those are serious as well. I don't know if the state is going to regroup and take a new tack. I have no idea. I would imagine they'll be talking. And I'm just wondering if it might be a good idea to set maybe a new date for a final plea again. I know y'all had a final plea once in front of a senior judge. It wasn't the judge that was going to preside over the trials. I'm happy to do that, but I kind of am going to need to know sort of how each of these cases is going to progress, if there are going to be charges dropped or null pros, if the state is going to move forward with everything. And if there isn't resolution, then we are going to need to sort out a trial calendar, the time needed to try the case, whether there are any outstanding motions that need to be handled prior to a trial. And then if it's going to be a trial, any motions in limine, and at some point get proposed jury questionnaires and things like that. And it may be that it's a little too early, given the latest developments, for the state to be able to have any answers for that. I see that Mr. Body has been abandoned at council table and is sitting there all by himself, having been dragged into the case fairly late in the game, much like me. But Mr. Abadi, do you know the answer to any of the questions on how the state might intend to proceed?
I think some of you are, some of you are probably correct. I think a new date in the future, the near future, would be the most beneficial for all parties to make sure that we're all on the same page, and if there are going to be any new updated offers, we can get those a little time to get those to council.
All right, so let's look at a calendar. Yes.
Really quick on behalf of
Sure.
we were very close to a resolution today that was essentially a time-served offer. Mr. Murphy's been in custody for 18 months. We have asked for a slight modification to that offer. I would really like, if possible, because I would go into legislative session too.
Sure.
It's the holidays, and if he is this close to a time-served offer, I would like some consideration to perhaps get his offer done today. If the state feels like they can do it. I know Adrienne is gone. She's left Mr. Body here, but I have been texting with her. We're very close to it.
Okay, and that's fine with me, and I'm here all day, and I'm willing to entertain anybody's offers. So,
I have no issue with that. I know, in my, I guess, communications with Ms. Miller, I don't know if we're right there as it relates to the updated offer.
okay.
But I think if your honor is available this week at another time, if there's a court appearance that we can do, whether it be via Zoom, to take a plea. It sounds like the time is not the issue, it's the specific charges.
Okay, so, and I would assume all of the attorneys know what the pleas were for Mr. Nichols, Mr. Huey, and Mr. Ryan as well. I can certainly be available tomorrow. If you will recall our discussions at the bench. I'm not sure about my availability after that.
Okay. Yes, sir.
But yeah, certainly, y'all work on that, and like I said, I'll be here all day tomorrow, and on and off, I have a couple of other things on my calendar tomorrow, but should be here for most of the day tomorrow as well. Does anybody else have an offer outstanding, or is everybody wanting to sort of wait on what might be coming forth new? Everybody wants to wait, but I would too. Okay. Is it premature to discuss length of trial if there is going to be a trial for any of these
This is what she wants
defendants?
to
And if
know.
it is, that's fine, we can reconvene.
I mean, I think it would, my estimation would be no more than 90 days. That would be my estimation.
I think that is a reasonable estimation. Okay.
No more than
All
90
right.
days.
So why don't we look at the calendar and pick a date before the holidays? Would that be reasonable, Mr. Abadi, to think about a final plea date before the holidays?
Yes, sir.
Okay. Is everybody going to be around like December 18th, which is a little over 2 weeks from now? Would that be a good day for everybody? People are kind of nodding yeses. Okay. All right, why don't we set,
Judge, I have a calendar on the 18th. I don't know if that.
all right, we could do the 17th.
sounds-
How about the 17th instead? That's 2 weeks from today. All right, why don't we set a final plea calendar for all of the defendants in this case for December 17th, and we can maybe know some more by then, and even for the people who aren't going to enter any type of a resolution at that point, we can talk a little more intelligently about what it's going to look like to move forward. But to the extent that there is going to be a trial for anybody, I mean, I'm thinking sooner rather than later. The facts and the evidence, some of the charges against these defendants are different than some of the charges that were in the case as it existed with the last 6, but a lot of them are the same, and I think the state should be pretty ready to go. So I'm envisioning, like, by February, we'd be trying the next case to the extent that we're going to be trying any cases.
Yes, Your Honor. Eric Johnson for Mr.
Yes, sir.
The question that I would have, Your Honor, is...
Do me a favor and talk into the mic, because we do have people on Zoom, and it's easier for them to hear.
Yes,
Thanks.
Your Honor.
You can pick it up if you want. You're kind of tall. I don't think you want to hunch over like
Eric
that.
Johnson for Mr. Eppinger. The question that I had, Your Honor, is, given the timing and scheduling that we're talking about, how long would it take for the transcript of the prior trial to be prepared? Because I know that there were certain witnesses that testified in the prior trial whose testimony may be used again in additional trial.
So it would,
trial.
yeah, and it's a good point. It would probably, to the extent anybody knows which witnesses, that would be helpful so that the court reporter or court reporters can focus on that testimony instead of just starting from day one and going all the way through. Because I think if we do day one all the way through, it's going to be a while. And the court reporters would probably like a holiday as well. So be thinking about, if you all are thinking I'm going to trial, be thinking about which of the witnesses' testimony you would like, and then we can have the court reporters focus on those.
And I guess my question, because it's likely Mr. Eppinger will be proceeding to trial, notwithstanding whatever happens resulting from this verdict, is the court going to take into consideration the time that the court reporter will need to prepare that in the scheduling the...
Well, I'll have to.
Okay. But I will inform her as to which specific witnesses, the testimony that I need.
Okay.
Thank you.
Any other questions? Any other kind of procedural matters? Does anybody have motions outstanding? You shouldn't, because you've already been to a final plea, but...
Your Honor,
will likely have a plea in guard. Is that something that we could argue on the 17th?
Get it filed, and I don't know if anything, I mean, I'll have to look, and I'm sure the state might have a response, but, yeah, we can go ahead and take care of that, whether it's substantively or on some sort of a other basis, we'll handle that. But please get it filed, like, before the end of this week.
Understood.
And Your Honor, I know that Mr. Evans does have a previously filed immunity motion that would need to be heard at some point in time.
Really?
Yes.
Well, I don't know why nobody else has heard that already.
It was filed.
Did you all have a final plea date without that having been heard?
It was never called for a hearing. It was filed quite a while ago before his case was severed on the initial trial. So that would need to be heard at some point. That may be dispositive of some of the
Okay,
cases.
how quick, it may be, it may not be. How quickly could the state and the defense be ready to have that heard? Because that may be something we can hear before the holidays. Maybe.
I guess I don't know what the immunity motion.
Microphone.
I mean, I assume he's charged with shooting 2 police officers, right?
That is correct, Your Honor. And that is the circumstance under which the testimony from the prior trial will be
Right.
needed to possibly impeach the witness at that immunity.
So you'd like that even by the time of the immunity motion or the immunity hearing?
I just need the immunity hearing scheduled at a time in which I can obtain that, Your Honor. That would be.
Right, that's what I'm saying is you'd like the transcript or at least a rough of the transcript of, well, you'd need an official transcript to impeach them of whichever witnesses those are. So you can go ahead and get me and the court reporters a list of those witnesses by the end of the day today.
Yes, Your Honor.
So that they can be focused on that. And then I will find out from them their time estimate, and we'll set the immunity hearing at a time after those transcripts are available.
Thank you, Your Honor.
So the immunity motion is related to
So it would be related to the shooting of the 2 officers, so,
the state to be ready tomorrow.
okay. Well, we can't have the transcripts ready tomorrow, but I hear you. So we'll be waiting on the transcripts, and as soon as those are available, we can set that.
I don't think he has an immunity right as it relates to the shooting of the 2 officers with an arrest warrant, which they were trying to execute on Mr. Evans. It's like a waste of the court's time.
This isn't the hearing.
So I don't want to get into substance now, but if the state has not filed a written response and would like to, go ahead and get that in by the end of the week.
Yes, Your Honor.
All right, anybody else with outstanding motions?
Your Honor, not an outstanding motion. Back here, Attorney Terrell Dart for Mr. McMullen. I was just appointed and filed an entry on this case August 5th, so I don't have any discovery or anything. I'll be concerned trying to be ready by February to try this
Oh,
case.
you can get ready by February? You're a defense attorney.
I hear you, Your Honor. I'm just letting the court know.
This is going to be a 90-day trial this time, not a 2-year trial.
I hear you.
And I am sure that Mr. Abadi will provide you with all of the discovery. It's in about 1 million Dropbox links, but I bet he'll consolidate it into one for you.
Thank you, Your Honor.
All right. And frankly, whomever
Passive
the prior
aggressiveness.
attorney was on the case really should already have discovery and it's their responsibility to provide that to you. Do you know who the prior attorney was?
Your Honor, I have no idea who that may have been.
I mean, I don't either offhand, but that might be a route to go as well. But Mr. Abadi will get it to you. What else?
Your Honor, I have a request on behalf of Mr. Mender.
Yes, ma'am.
Nicole Fagan on behalf of Mr. Mender. If we are going to have another final plea on the 17th, if we could request that the state have all offers, whatever's on the table by the 14th so that we can communicate so it doesn't happen in the rush of the moment.
Sure. Yeah, I guess we're not in my regular courtroom and this it's not my regular team of people, but my rule is that the state needs to have the final offers to the communicated to the defense at least 2 business days in advance of the final plea. The 14th is actually a Saturday, so let's say by close of business the 13th, 5 p.m. on the 13th, all offers need to be communicated. Thank you for bringing that up. All right, who is Melissa Reynolds in the waiting room? Anybody know? It could be somebody with the, I guess, one of the prisons, so let me go ahead and admit them and see.
They're gonna yell free thug mistrial.
Yes. Is that Mr. Adams?
That's in the.
Okay. All right. Well, I'm sorry that he missed most of the status conference, but you can update him. And are you able, I think that all of the prisons have the ability to let y'all Zoom privately with attorney and client?
They do, Judge, we can set up a legal conference, so.
Okay, and I can even leave y'all, if you'd like, in a breakout room after this is over with, so you can catch
That would be great.
him up. I think we can do that. My staff attorney is saying, no, we can't. Why can we not?
She's so gleeful. I'm not mad about it, just noticing it, you know? She's like, come on up. She is jolly. Oh boy, I still can't get over her pointing out that Mr. Abate was left abandoned at the state table. That is so funny. She said, don't show the cameras.
Just when we're finished,
but
you
I'll
just
tell you what's
need to
happening.
join the Zoom on your phone, and you can step into that little conference room back there so that you can talk privately, and y'all will be in a breakout room, so only the 2 of you will be able to hear what's going on. Okay, so Mr. Adams, your attorney's going to catch you up with what you missed. We've basically just been talking about scheduling. We haven't discussed anything substantive. All right, so I think that's it, and we will see everybody back here.
Last thing, one more thing, I'm sorry.
Yes, no problem.
Your Honor, upon Mr. Mender's severance, we didn't receive any new discoveries. So I'm not sure if any new discoveries outstanding, and I can't speak for any other attorney on the case, but everyone here has been severed. So I don't know if everyone has everything.
All right. Why don't I ask Mr. Body, can you just gather up all the discovery and maybe, in order to make sure that everybody has everything, just reserve on everybody?
Yes, sir.
All right, I appreciate that. All right, anything else? All right, thank y'all for your time, and we'll reconvene on December 17th. I'll see everybody back then. Thank you.
All right. They said December 17th, right? Because they said 18th earlier. They changed it to the 17th because the one attorney had a calendar issue, right? So, but that's it. They're not doing anything before the 17th. All right, so December 17th, note that down. We'll tune into that. Seems like a Rule 22 will be in effect and they'll actually pan the courtroom. Thank you, chat. I have other feeds up that aren't showing any press conferences. I encourage you guys, if somebody's doing an interview, watch it on their channel. Spread the love around there. We can go back, we can run back the verdict reading one more time. So many thoughts, guys. She does not want to play about this other trial. And when she says 90 days, I think she means 90 calendar days, not 90 days of actual court sessions. I think she wants this done in a month and a half. Not 90 days as in we had 167 active days of this YSL trial, but it spanned 2 years. I think she wants 1 month and a half, 1.5 months. She's not playing. Oh, man. I tried to scrub through Fox 5 and I didn't see Max on that. I mean, it was the same feed because I didn't see another live video. This is when the status hearing starts. I mean, maybe there was another... Okay, wait, so they do have two different feeds. Okay, the other one I still only see court feed on as well for Fox 5. So I don't know if they like, sometimes they air it and then it's gone, if you guys see it there. Let me try 11 Alive. Okay, 11 Alive is just the feed and news coverage. Yeah, I don't see in any of the news feeds. So. Then again, I encourage you, if Sylvia's interviewing people, if Dennis is interviewing someone, I mean, the right thing to do would be watch it over with their channels there. So there's that. And for whatever reason, I'm not seeing a press conference on any of the news channels. So, and I checked Fox 5. So if someone wants to send me the actual link to whichever Fox 5 link has the press conference, we can definitely watch it. Like, I don't know why it's not showing on YouTube. Every once in a while, they end up putting that stuff up later. So. I mean, so the only option, I mean, this just looks like a clip of the verdict. So if it's not in this particular feed, which I didn't see when I scrubbed through it earlier. Yeah, this one live stream that Atlanta News First has up doesn't have the outside interviews. It's just the in-court stream. So my bad on that, you guys. And again, if you want to check it out with Sylvia or with Dennis for those interviews, like, definitely I encourage you guys to go do that. And if we do get a link from one of the news stations set up outside with the press conference in there, we can check that out as well. But for whatever reason, the streams that they have up don't show the feeds. Anything outside the courtroom, at least. So. Also, Shortness says, I would love to be a fly on the wall when the jury finds out all the craziness that happened behind the scenes. I mean, I would love to know what, if anything, kind of, even if they tried to block everything out, what still was kind of pervasive. Like, did they hear about the Fulton County conditions? Did they know about Fulton County because of, maybe they heard from a friend or coworker, separate from this trial, right? Not as part of a conversation about this trial, but maybe they had somebody tell them a story about Fulton County. They have something in their awareness that could impact the way they view things that isn't necessarily them looking or researching this trial. I would love to just know the bubble of thought. So I'm looking forward to that. And I tried 11 Alive. I see the chat still trying it. If somebody wants to send me a direct link, and I promise I've pulled up all of these local stations and scrubbed through it, and I just didn't see in the feeds that are available on their channels a feed from outside of the courtroom. So I checked 11 Alive, I checked Fox 5 Atlanta, I checked Atlanta News First, Law and Crime, None of them had something happening outside the courtroom. So again, if you guys want to send me a direct link, we'll be able to go look at that. Let's see. Toothless Tiger, very kind, says, "Hi, Kat, mods, and chat. Congratulations, Yak and Doug." Right? Still a big moment here. And one of the things I think was so crazy about this trial is that they bookended this trial with Marissa Viverito. And guys, with the remaining co-defendants, Viverito is still going to play a big role. She's the key witness, signing off on, different affidavits for the remaining co-defendants. She's going to pop back up. So there will be a continuing mess with this trial as it moves along. And I'm not saying I won't be open to different evidence, right? We're going to hear some stuff that we may not have heard in this trial. We're going to hear some things that we heard in this trial, but we're actually going to see the relevant defendant sitting in the room, right? So it is going to be a little bit different, but there's still going to be some of the same players. We're going to see Viverito again. We'll probably see, I don't know what they're going to do with Dennis. That's hilarious. That's a whole Pandora's box, but we'll probably see from Gaither. We'll probably see from Thorpe, right? And can you imagine them having to do all this on the stand again? Viverito trying to keep her testimony straight. Can't contradict something you said on the record under oath in a previous trial. And I bet these attorneys, you have multiple attorneys again, you have multiple pairs of eyes, ears, all of their teams that can be ready to catch. Like, hey, that's not what you said under oath previously. Right? It's going to be super interesting. And also interesting, these plea deals might change. So, good to see you, Toothless Tiger. Another awesome content creator. Great thoughts and very calming to listen to. So if you haven't already checked out Toothless Tiger, hop on over there. I'm sure she's going to be doing, content about her thoughts and reaction to this verdict and what's going to happen moving forward with the remaining co-defendants. Shortness says, "I would love to be..." Oh, we got this one. My bad. Lovely. Thank you for the 10. Y. Turner says, "Prosecutors of the state should not be able to participate in any of the YSL record label trials or hearings ever." Well, unfortunately, I mean, I guess they could bring in like a special prosecutor, but still, you're still kind of brought in by the state here. So I don't think there's a practical solution for this here. And I don't think the feds would touch this. And if they did touch it, they'd probably look at the financials, right? It'd be a different ballpark. And maybe the feds would do that groundwork and then still decide, no, we don't really see RICO here. So, because remember, pecuniary interest is an element for a federal RICO statute. It's not an element, but it is something that the state claimed that YSL as an enterprise was participating in. They were doing these things in a financial interest in furtherance of the enterprise. They alleged it even though it was not a necessary element for RICO under Georgia statute, and then they never looked at financials, which is just backwards. So who knows? It's going to be a mess either way, I think. Janice says, "Kat, you have been amazing covering this trial. Love your insight. God is good. Deamonte and Shannon, go be great." Right. And I am so excited to just like see if we hear about plea deals for the others. And the circumstances could be different for the others, but if the jury found nothing here for these two. And think about all the people that took pleas. Like all the people that took pleas because they were sitting in Rice Street and didn't want to be there. That now because of their guilty pleas, they have this record. They have this record. Because they didn't want to sit in Fulton County after being denied bond. It's just a lot to think about. So I'm happy for these two, but I'm like mad about other stuff floating around it. Thank you so much, Janice. Miss AB says, "Good morning, just jumping in. Verdict. Heck yeah, you got right here when you heard the news, didn't you? Good to see you. Hope you are doing well." Bridgetta says, "Kat, thank you for letting me be a part of your YouTube, and this is my family for life." That's so awesome. Love the dog picture. And again, I'll cover other trials that piss me off. That's kind of my criteria, right? Pisses me off or there's something very oddly interesting about it. Otherwise, I'm lurking in the bushes watching somewhere else. But we will meet again. We will follow this YSL case as it plays out for the other defendants. And you'll see me come back around when I get pissed off about some type of case. Yes, we will be here on the 17th. We will look at the next status hearing, this update here. GB says DA presser about to blame Juror 56. Oh, I wouldn't be surprised. And that's the thing, I don't think it looks good to blame something because who's responsible for presenting the case? Who has the burden of proof here? Who has the duty to lay out the foundation and the facts for what they're trying to prosecute somebody for? You can't really blame somebody else. So take the loss state, and I don't think they're going to do it. Oh, I can't wait to see it. GGT says, can Thug interact with Yak and Shannon? Now, I think if it's in the course of music, as far as the terms of his plea, he has permission to work with Sergio Kitchens. That's gonna... I mean, I would still tread lightly because I feel like they're going to put so many eyes on these guys. I don't think that this being watched from the bushes type of scenario, I don't think that this bushes thing is over. I don't think them having a microscope on them is over. And even, I might say that might not be right, that might not be appropriate. At the same time, if you can do something, even though maybe you shouldn't be in a position to have to go out of your way to keep the government out of your life. Even though you shouldn't have to, sometimes it helps yourself to be aware, take certain precautions, and mitigate the risk of someone trying to aggressively prosecute you, right? So I think he can, in the course of it being anything related to music, his business as a music artist. But at the same time, I would tread lightly. Like, here we are rapping together. We're creating songs together. Very obviously us doing only music. Making sure there's no one can say anything but. But yeah, so Gigi, I think there's like strings attached here, whether they should be or shouldn't be. Wonder Nurse says, do you think Thug is regretting his guilty plea? I would imagine that that's such a heavy decision that it's possible to have mixed feelings on any given day, right? You ever wake up and just laying in bed thinking about something, you start thinking about something from a while ago and wondering, well, what if, right? To wonder what if, I think, is human. I think it's something that we can't help. Whether that amounts to a full regret, I don't know, like 100% full regret, I would say probably not, because you still never know the outcome he would be facing. And again, the jury clearly was willing to convict on a possession charge, and Jeffrey Williams is facing several. So just because Yak got all not guilties doesn't mean that Young Thug would have gotten all not guilties, especially since a lot of the charges the jury had to consider for Deamonte Kendrick were possession charges for things found in Jeffrey Williams' home during the raid. So I don't think there's an absolute, I'm sure as a human being, as anyone would, there would be wonder, curiosity, what if, maybe a little bit of regret, maybe a little bit of remorse, but 100% I don't think so. But great question. And I would never know what's in someone's head. Flesh of the Gods, who's going to be going live soon, probably to talk more about this. Big shout out to Flesh of the Gods. Got the updated profile picture here. Says, much love, cat, chat, and mods. Guys, make sure, especially, we'll set up a redirect when we've got a lot to get through, but we'll redirect over there at some point. Flesh of the Gods is such an awesome channel to hang out with and watch all this hot mess of this RICO trial play out. So make sure you check that out with us later today. Y Turner says, now RICO for the state. Yeah, get them with the RICO. Well, they jumped ship. It's not much of a RICO anymore if they left Abate sitting at the table by himself, which is just so hilarious to me all day. Oh, man. Let's see. Oh, and true. Okay, great point, Compound Cochran. This is right. If Yak isn't a convicted felon, he can be around Thug. And the jury found that he's not like RICO. He's not part of this gang affiliation, no gang activity. So I think they'd be hard pressed to say he's like a YSL. Like factually, did a jury conclude that he's a member of YSL? Doesn't seem like it. So if that's criteria that Jeffrey Williams needs to stay away from, seems like the jury found the opposite as a finding of fact against Deamonte Kendrick. Well, not against, but in relation to Deamonte Kendrick. So great point here. Thank you for this, Compound. Let's see. And I'll refresh some feeds. I see we're going through the same thing about somebody doing an interview, but just to help me, guys, when someone says somebody's doing an interview, it doesn't really point me anywhere I can go and pull it up quickly just to hear that somebody's doing an interview. So, as a best practice, saying where somebody's doing an interview, where it would be possible to pull it up, that would be, very helpful. And I'm pulling up, I don't see, same thing. A lot of the channels I have up, they're not doing any lives right now. So if a channel's running something back, let me know. And I'm not trying to not pull these things up for you, but I'm just telling you these news stations, I'm not seeing them currently live with this, so. STS says recollaborations. COVID-19 showed musicians doing tracks from their separate homes. Right, and that's true too. We don't even need to be hanging out together. I think one problem is, and things could be different now, but if Jeffrey Williams is the one with the studio and the equipment, it's kind of like, well, that's where we want to go to have the stuff to record, right? So there's ways we could work this out, but at the same time, if there is a physical requirement for us to be within proximity of each other, that makes a slight difference. But yeah, people can do amazing things without ever being in the same building as another person, especially the way that like someone could record a verse, send it over to somebody, and it can all be done. Really cool. Love technology in that way. So there is a plan B here solution, right? But I don't think they should be held to that. I hope that they're not held to having to be apart from each other. You guys said you wanted to see Shaq's new tweets, Kokomo. But yeah, we have the FES, we have the Take It to Trial with Yak, we have Juror 56, what do you want for Christmas? And then defense attorneys around the world are like, bring me my money. So there you go. There you go. An update there. All right, here we go. Thank you. This is starting in the middle. I promise this is starting here.
30-year-old about turning his life around and having a second chance at life and making it mean something and being there for one's children and for one's family. So I'm just so happy, excited for Shannon. I'm happy and excited for his grandmother, who I was able to hug, and I'm happy for his kids, and I'm just very hopeful that this is a turning point and there's great things coming in the future.
Max, is this a fair and just verdict, do you think?
Absolutely. Absolutely. The jurors, we asked so much of the jurors, and they really scrutinized the evidence, and they demanded real evidence, and it wasn't there. And so we are thankful for the jurors, and it's just a great day.
Did you have a chance to talk to the jurors?
I did, and I'm not going to comment on the discussions with the jurors, but I will just say I think the fact that they deliberated for 4 days, and also that just the amount of time that they put in, they certainly scrutinized everything, and they did their jobs as jurors, and we are appreciative of that and so thankful.
Can you reiterate again what he was only found guilty on one charge and what that means for the future, him getting released, all that stuff?
So he was found guilty of possession of a firearm on March 17th, not the day of any of any other crimes. It was the day that he was arrested. Okay. And there was a gun that was registered to his girlfriend that was found near the scene of where he was arrested, and that's what he was convicted of. Judge Whitaker, we are so thankful to her for having an open mind. A lot of times when you take a case to trial, you just get the maximum sentence for daring to take on the state. Judge Whitaker did not see it that way. she gave Mr. Stillwell a time-served sentence for the time that he has served, followed by probation. Mr. Stillwell has a couple, or I think one other criminal matter that needs to be resolved. I am hopeful and optimistic. It's nothing like this case. It's a case that was picked up while incarcerated. And we're hopeful that there will be a quick resolution of that case, and Mr. Stillwell will be able to get back to his life and his children and his family.
You think he'll be home by Christmas? Is that
I'm hoping.
Okay.
That's not unrealistic.
I know you don't want to get into exactly what the jurors said, but what do you think their one sticking point was?
I don't think there was one sticking point. I don't think there was. You know, so many people have been watching this case. You know, in opening, I said from the beginning about the witnesses in blue suits and wearing the Fulton County blues, and I think the world got to see how cases can be built the wrong way. Just finding people that are prone to lie and talking to them at their most desperate time to try to get them to say things about other people, and I think that's what happened here, and I think the jurors recognize that. And of course, regarding the 2022 case, that was on video, and I think we explained what we saw in the video, and I think the jurors likely saw the same thing.
What kind of message should this verdict send to the taxpayers of Fulton County?
Oh, I don't know about all that. The message that was sent to me is my client has a second chance at life, and we're just so thankful for that. And I know he is, and we are also just so thankful to the press for covering this, and all the people that at some point the public began to root for us, and that did make a difference, and we appreciate all the people that have been supporting us throughout this process, this long journey.
Can you speak to the conditions in jail?
I mean, and I don't mean to, we know that Shannon was stabbed in the stomach earlier in this trial, while this trial was going on. We know we had to break for a week, or at least a week, might have been 2 weeks for his recovery. I was the only person allowed to go see him in the hospital. And so that was, you know, and then Mr. Kendrick was stabbed in the head recently. So obviously those are serious, and we got to make sure we take care of people, especially people that are not even convicted of anything. And so that's I think it's something we need to address. I'm not blaming any particular person, but it's something as a society and as a city we need to take care of.
Right, so there is that. Thank you to Amy for sending that over, Amy Harrell for sending that over on X with the link. Also, the Christina Weaver fan account and JC here. So
the work, having a personal life, coming back down here, super grateful. I just got so much emotion right now. I'm full, yeah. I'm full, and I'm full. Day in, day out, going to work, having a personal life, coming back down here, sleeping in the courtroom. They having to wake me up, doing this thing over and over and over again repetitiously. Every day. Every day. My son stood up 30 months. My son stood up. And we was victorious. I'm thankful to God that a mother love went beyond the world. And I'm thankful. I never gave up on my son. Never. He said, Mama, I'm not taking it. I'm standing up. And I stood right by him every day. Every day of the week, I stood by my child. And he said, no. And I said, I'm going to stand with you. I'm going to stand with you to the end.
To Mom.
And we stood down to the end. You never give up. No matter what's thrown against you. You never give up. Never. And he stood down. And I'm right here every day. Every day I stood up with him. Every night I prayed with him. And I told him, son, this is bigger than you. This is bigger than you. And I'm thankful to the people all over the world that prayed, gave me encouragement. He gave me encouragement. Big Jeff, Miss Sylvia, everybody around me. Taylor, Cole, I got so many people. My family members in Miami, Florida. Everybody that gave me hope and encouragement. And Deamonte stood every day. He watched them say bad things about him and disgrace him. And I had him and I raised him. They divulged his character. They said bad things about him, but we got the victory. And in life, you never give up. Never. You never give up, no matter how bad it looks. God said he'll make the enemy your footstool. I look to the hills where my help come from. I had bad days, I had good days, I had emotional days, but I damn if I was gonna give up. And I'm thankful for everybody that's been around me in my life who encouraged me. I'm emotional.
So shout out to mom. Shout out to mom. That's Yak's mom. That's Miss Tasha. What, like, that's what a feeling for mom. I'm also, like, I didn't see anything from Miss Betty yet, from Shannon Stillwell's grandma, but, like, what a feeling for the family members. And I think the point she made of people standing there and encouraging, I really think we're hearing from mom, but I feel like that was probably hugely inspiring for the defendants as well. I mean, Doug always, in every video that I see Doug do, he tries to go out of his way and mention that the support, the thoughts, the encouragement from the community are not just helpful for him as an attorney to keep doing this work, but also something that is reassuring and making his client happy, right? So I think this stuff is really important. And what a way to see it in the moment here. So shout out to Yak's mom. Let me link here. That link is in the chat there. But yeah, so I guess Stillwell's still going to be in custody, it seems like, dealing with the other count. So, and I believe that was either for having a shank or a cell phone in possession while he's incarcerated. So we'll see how that plays out. And then I think those were, thank you guys again for sending those over on X for tagging so we can get them. I think that's what I got sent from you guys. So shout out to Amy, to JC, and the Christina Weaver fan account. Also just a huge day all day today. Yeah, oh yeah, Renee Stevenson says the defense put up no case in chief and they won. Right. Praise those lawyers. And again, that could have been a risky gamble, right? I'm sure they weighed pros and cons of doing so, but it worked out. It worked out. Great point here. Great thing to discuss here, Renee. Thank you for the 5. The Adventures of Chloe and Daisy says Juror 56 can be a book title for his jury exposition. Yeah, heck yeah, just Juror 56. I mean, we'll know what's being referred to here. We've got the channel emoji for it. Good to see you, and thanks for being a member again for the 3 months here. Chloe and Daisy, cute picture. KC Dog says that I read your chats in different tones, so accurate. You know, I don't really know. I know sometimes when we quote, like, Judge Whitaker or something, I might put a voice on, but I don't realize that I do this, so oops, but glad you like it. Green-eyed lady, thanks for becoming a member. How many, I don't know, is it 12? Look, hold on, I'm telling you, just like a grocery store shelf that's fully stocked, you try to put new information on it, something falls out. I forget these things. I might have had this exact number in my head like an hour ago, and it's already pushed out of memory. So let's pull up this portal again and count. And that might change because it sounds like a few are considering taking pleas depending on what the final offer are and any final negotiations. And if they're considering taking a plea and the terms get better because of what happened today, which Whitaker was sure to emphasize a little bit in the status hearing, you know, they might be more inclined to take a plea with better terms if the state feels like they're checkmated. So we have, well, this is, hold on, that's Kendrick. All right, so let's make sure I look at the names. So we have Khalif Adams, Damon Blaylock, Javoris Bradford, Christian Eppinger, Miles Farley. We technically have a 6 for Justin Cobb. It still says judicial hold. He's on the run, but maybe he's not. There was some update that Love didn't want to put on the record or in front of the cameras today. So we'll count that as 6. 7 is Javon Fleetwood. 8 is Demikian Garlington. 9 is Demise McMullen. 10 is Tinquarius Mender. 11 is Jaden Myrick. 12 is Jimmy Winfrey. So, and we don't count Shannon, even though this is open because that's different. So 12. Yep, 12. So there you go. Great question, Watcher of Trials. Michelle says, Eppinger's lawyer wanting the transcript. We all saw the cop lie about announcing himself. The cop ambushed him. And I'm wondering, they said they wanted the... Did they want the transcript from... They said the immunity, for the immunity hearing. So they were asking for the transcript of his testimony in this case. That makes sense. But yeah, I think this is going to be interesting to see play out. And this is a serious charge, right? I think this is a serious... we had conversation about, their discussion within this trial for these 6 co-defendants about Eppinger and shooting a cop could be highly inflammatory, right? And that's a big thing that you want to look at for voir dire. Seating a new jury, can a jury, if you sat on a jury panel, would you be willing to say that there could be times where it might be justified to shoot at a police officer? Like, think about the intense level of jury selection when a question like that is on the table. And for these co-defendants here, Christian Eppinger is actually going to be in the room with them. It's not going to be like, here's 6 co-defendants in the room and we don't even see this guy that's being talked about right now. What does this have to do with these 6? Right? This is a serious charge, a serious question to ask each and every potential juror. So I think this is going to be important, especially any remaining pretrial stuff that they want to establish here with Eppinger. Could have a big impact on this case, not just for Eppinger, but for the remaining co-defendants. So very interested in seeing where this goes, Michelle. Peter Ortiz, my bad on being late on this. Some of us missed the verdict. Please replay. We will. We've replayed it. We've played it twice. It's clipped separately. We'll wrap up the stream by playing it one more time. I just have a lot to get to, but we will get to it. One Happy Work Girl says, I'm looking forward to the Netflix original, From the Eyes of the Juror, a YSL trial catastrophe. Great word there. I think that's a good descriptor. Esquire 1995 says, so proud of the defense attorneys. Enjoyed the coverage, Kat, mods, and the chat. Top notch. Love my time with y'all. Well, thanks for being here with us, Esquire. G. Lander says, cue Tupac's Picture Me Rollin' for these boys. I think there's so many songs that they could play. There could be a whole playlist for this. And Atkins is gonna drive home listening to all of them. Oh boy. Yeah, and the other good question, where is Boyer? Where is Boyer? Where is Boyer? He is not on this indictment. His name is not here. But he's facing some serious time because of a different gas station shooting, right? Where there was 3 victims, 1 loss of life, 2 charges for attempted murder for the other 2 that were injured. So, let's see. Miss AB says, Woody and Glanville brought me here. Cat in the chat kept me here. It's been a wild and awesome ride. I appreciate reading my reduced super chats. What? No, I love you, Miss AB. You could be in the chat for free. You guys please never feel obligated to send a super chat. I know when it's busy, I try to read as much as I can in the chat in general. Obviously, don't want to shut out somebody who's sending a super chat, but please don't ever feel obligated to send a super chat. Miss AB, we love you here. And Miss AB is also saying, has anyone heard from Granville? He's got his other cases that he's doing, minding his business somewhere else. Curious how those cases are going. Curious how some of those evidentiary rulings are going. Is it the same for those cases as he went through the motions in this YSL case while he was still presiding? Because that probably sucks for those defendants of those cases. So, good question. I know the answer is simply that he's presiding over other cases, but how those are going, that's a big question. Ike, good to see you. Ike says, victory has 1,000 fathers, but defeat is always an orphan. It's Abate sitting alone at the state's table. Neither Fani nor Love nor Hilton is in the room. Shame. Heck yeah. What a visual Whitaker gave us by saying that. Holy moly. Latasha Gaffney says, does this mean Shannon and Yak can be around thugs since they don't have gang charges? I do think that they might be in the clear for this. I think, you know, we gotta be careful because, and this is crazy, like Jeffrey Williams isn't supposed to possess a firearm, and he's a celebrity, he's got a lot of money, he's well known. According to the state, he has people that probably are trying to get some get back at him. There's multiple reasons why he would need security and protection. But at the same time, we saw the state try to stretch the meaning of constructive possession. So, what risk is Jeffrey Williams under of prosecution because he has someone around him? Like, I can imagine the state trying to say that they want to get Jeffrey Williams because someone that's hired as security, contracted out as security, has firearms for the protection in the line of their work that they're hired to do. And I can just picture the state trying to just be dumb about it, right? So at the same time, I think all three of these guys just have to be extra careful, even if they aren't actually doing things that they're ordered not to do. They're just going to have a microscope over them. They're going to have a microscope over them. And then as far as, you know, that exception, I don't know if he needs explicit permission to be around them to do music. We'll have to see how that plays out. I think we won't know until we see someone try to constrain it or call attention to it. What I would say is just because something seems like it would be allowable, you never know who's going to try to make a deal out of something either way. So, and yes, so he could have security with weapons, but I'm just saying, look at how the state has tried to stretch constructive possession. Just because the judge clarified something doesn't mean that the prosecutors can't try to ruffle something up. And then you have to wait for your day in court to argue, no, and hope that a judge throws it away, right? The prosecution can always try no matter what a judge has previously said. So, like, no matter what, they're going to be under a microscope, and they're going to be under the microscope of overzealous APD, overzealous investigators from the DA's office, and overzealous prosecutors. So, if they can find a way to try something, they will, even if it's garbage. That might be why we have a whole RICO case here in the first place. Violet says, here's to you, K&W, with the noodles. Thank you so much. I love a good bowl of noodles. And Violet, thank you so much for gifting to the wish list, the Amazon wish list, which we're going to do before we close up. We're going to purchase something. Big thanks to Sapphire Ridge News. We're going to do more purchases for the Angel Tree children's gifting wish list. And no pressure, you guys. I'm just dropping the wish list in the chat if anybody does want to participate in that fundraiser there. Violet, thank you so much for gifting. KL says, thank you, Kat, for your coverage. You're my first and only membership. I'm honored. Love your insight and wonderful spirit. I'm so honored. Thank you so much, KL, for being here. Paulette says, just saw the verdict. Must say I'm so happy for them. I'm crying. Yeah, it's been an emotional day. This is an FU to the state. Love you, Kat. Love you right back. And I agree that this is an FU to the state, and I love to see it. Miss AB, I think talking about Whitaker here, says she's happy it's over. 90 days, not 2 years. She said we are not doing that again. Latasha Gaffney says, oops, going backwards here. Let's see. Yes, Latasha says Thug, Shannon, and Yak's attorneys, their fees just went up. Yesterday's price isn't today's price. Yep, and duly deserved. And I just want to say my piece on one thing. I think everybody has the right to have a defense attorney. So I think when we hear, oh, attorneys make so much money, of course they're willing to do what they do. So what? So what? Unless you could get specific with me about a specific attorney doing something unethical in the representation of their client, I don't care if they get paid. I don't care if they get paid. So that's my take on it. The price has gone up, and it's a pet peeve of mine when people complain about how much money a defense attorney might make, right? You know, I don't think it's easy work by any means. I think as a positive, look at the weight that Doug Weinstein has lost. You know, he said that he made physical health he wanted to make it a habit. He wanted to have a good habit with his physical health to help him get through a long trial like this. But at the same time, we've talked about, you know, is Atkins losing his hair? Other attorneys, they look like they've aged. This trial's taking a toll on them. This chat, we've commented on those physical signs, the change in someone's apparent physical well-being or just level of tiredness. So this is a physically taxing thing. Should someone do it for free? No. No. I say direct any gripes about a defense attorney getting paid. Direct that gripe to the waste of money that goes into trials that end up with a not guilty verdict like this. That might as well have just been a waste of time. Why did we prosecute it in the first place? Right? That's my rant. That's my soapbox. That is my soapbox. Jamila says, my heart dropped. I feel like they are family. I mean, you spent a lot of time following along and watching their story, so I get this. One happy white girl says, God, we pray you're with these young men. Hope somebody keeps looking out over them. It was really nice to see Miss Tasha, Deamonte Kendrick's mom, like pour her heart out, right? Happy to have her son free, right? Really important to see. It's so important to have people in your life that care about you. It makes a big difference. David Liebold says, beat 2 murder raps, Paige's lawyer 60 for that. Heck yeah. I hope that song just like gets a ton of plays. Harp City says, literally tearing up with joy. Guys, a whole day. A whole day. Gloria Smith says, oh my God, thank you, Jesus. Deamonte, thank you, Jesus. Deamonte not guilty on all charges. Shannon guilty on the gun charge. Thank you, Jesus, he didn't get charged for more for the murder. Yeah, huge difference, right? It's one thing to be like, oh, you have a record, what's it for? And you're like, possession. Right? Very different than, I murdered somebody. They found me guilty of it. Big, big difference there. And you could see the relief. Again, I think Shannon was pretty stoic, but you could see the relief on Max's face when the not guilties were read. Thank you, Gloria. Renee Stevenson says, amen. They got it right. I agree. Jennifer Devine says, Judge sounded happy he's going home. Time served. I agree. I really think in her head she was like, but I can probate it. Like, she really had a tone with that, that I happily read into. Survivor Speak says, 2.9 watching, 583 likes. Please hit the like. Hit the like button. She works so hard to bring us this content with clarification so all are able to understand. Thank you for the kind reminder, Survivor Speaks. And you guys, if you've been hanging out here long enough, you already know. If you guys love trials, Survivor Speaks is another one you should be following. So make sure you are following Survivor Speaks. I think you just wrapped up doing the rewind on the Anthony Burgos trial, right? I think that was your last. So I think you're on, well, let me see. You have something scheduled, what your next topic is, what your next case is going to be. Oh, nope, still on Anthony Burgos. But I think you're in the sentencing phase of it, right? So my bad. We're still on Anthony Burgos of Willis. So there we go. There is a link in the chat there. So make sure you come hang out. Especially I know like probably like half the chat, this is just a rough guess, but like half the chat is here because they wanted to watch this particular trial, and half the chat likes to watch trials, and this is a trial they happen to be interested in. So especially if you're interested in watching other cases, Survivor Speaks is a great channel to be following because you'll get to go through these rewinds, watch the live trial action. Great, great channel and great chat, very friendly chat too. STS says, oh, we got an update regarding, our semi-adopted channel cat here. We're going to act like we've half-adopted STS's cat here, Simon. Simon's been going through it, you guys. But Simon's going in for a status check and hopefully removal of stitches and the cone of shame. Ear is doing much better. Simon still hates the cone. I'm not going to lie. The picture is so great because it's like almost a perfect circle to the profile picture. So everybody, send some good vibes to Simon the cat in here in the chat. Send some good vibes. Poor animals. You know, I always wonder, like, why do I have this cone on my head? What do they be thinking? Um, Sweetie says, shout out to Judge Whitaker for not dragging it out. She said, we're getting this done. Done, done, done. All right, let's watch. We've got, I see something with comments from Doug. Let me cue it up. Get this going.
Your reaction, what happened?
You know, Deamonte and I I want to say we were surprised because given that the jury had clearly been looking at all the evidence, we thought that this was the only outcome they could really come to, but nevertheless, we were thrilled. Just, he's looking forward to getting out, getting back to his music, getting back to his family. All the supporters he's had, all the prayers, all the love. It's been wonderful. And I didn't say this earlier to everybody else, but I have got to thank Judge Whitaker. The entire case changed when she took over. We got a fair trial, and anyway, it's just a wonderful experience.
No, I ain't no regrets. No regrets. You know what I'm saying? He
That's
did
Big
what
Jeff.
he felt like he wanted to do. So he's grown. He made his own decision.
Have you spoken to him since this?
All right, so this is Big Jeff. This is Jeffrey Williams' dad. It sounds like he was asked a question about Jeffrey Williams taking a plea deal, and his answer was no regrets. So we'll replay that because it cut in the middle of it.
Experience.
No, I ain't no regrets. No regrets. You know what I'm saying? He did what he felt like he wanted to do. So he's grown. He made his own decision.
Have you spoken to him since this happened?
Yeah.
And if so, what was his reaction to today's verdict?
Today? No, I haven't spoken to him today.
How is he doing?
He's doing great. He's doing great. Honestly, he's doing great. So he don't have a word. You know, we still fight. We still fighting out as well. It's not over for us.
What do you mean by that?
Huh?
What do you mean it's not over for you guys?
It's not over for us because I got another son and a grandson that was arrested about this case that I'm still fighting for.
You've been an outspoken critic of Fulton County DA's office. In light of today's verdict, what is, I got a message for them?
I still feel the same way about the DA office. It's a piece of shit. So, you know, we got to get those people out of there. All right? If we want to continue to have justice, we got to get them out of there.
I want to say that I'm thankful. I'm thankful. I stood down, 10 toes down every day, day in, day out. I stood by my son. It was his decision to not take the plea. And I said, whatever you want to do, I want to do. He said, no, I ain't taking the plea. He didn't take it, and we stood down. I prayed. I thank God for all the supporters all over the world, people who were supporting me, texting me, DMing me. I appreciate the love, and the love. All the prayer warriors, I'm thankful. God is good. He did his big one. They used my son rap lyrics against him. How dare they do that? It's a freedom of speech. They just did so much corruptness in this case. And they threw things against the wall and it didn't stick. I'm thankful. I'm grateful. I just got so much emotion right now. I'm full. Day in, day out, going to work, having a personal life, coming back down here, sleeping in the courtroom. They having to wake me up, doing this thing over and over and over again repetitiously. Every day. Every day. My son stood up 30 months. My son stood up. And we was victorious. I'm thankful to God that a mother love went beyond the world. And I'm thankful. I never gave up on my son. Never. He said, Mama, I'm not taking it. I'm standing up. And I stood right by him every day. Every day of the week, I stood by my child. And he said, no. And I said, I'm going to stand with you. I'm going to stand with you to the end. And we stood down to the end. You never give up. No matter what's thrown against you, you never give up. Never. And he stood down. And I'm right here every day. Every day I stood up with him. Every night I prayed with him. And I told him, son, this is bigger than you. This is bigger than you. And I'm thankful to the people all over the world that prayed, gave me encouragement. He gave me encouragement. Big Jeff, Miss Sylvia, everybody around me. Taylor, Cole, I got so many people, my family members in Miami, Florida. Everybody that gave me hope and encouragement. And Deamonte stood every day. He watched them say bad things about him and disgrace him and I had him, and I raised him. They divorced his character. They said bad things about him, but we got the victory. And in life, you never give up. Never. You never give up, no matter how bad it look. God said he'll make your enemy your footstool. I look to the hills where my help come from. I had bad days, I had good days, I had emotional days, but I damn if I was gonna give up. And I'm thankful for everybody that's been around me in my life who encouraged me. I'm emotional beyond words. I am emotional beyond words, beyond measures. A mother love. I never will give up. And I taught him that to give up, never give up. No matter what the traditional system say about him, never get up.
All right, so there was that. Also in the chat, before I forget, like, I saw the comment while that was playing, and I'm losing it. I think it was Madeline. So Thug's brother and one more relative of Thug is in jail for this RICO. Was those two in court today? So I think what Big Jeff may have been referring to was Quantavious Greer, who really, he took a plea, but then got picked up on a violation, a probation violation. So he's currently in jail, in custody. And I think the other relative might be Greg. And Taylor Umbridge was looking at that this weekend. Or maybe it was yesterday. Like, my days are all haywire. Let me see. Get the link. Okay, I don't see it. It's possible that it was during one of her jury watch streams. So I'm gonna link, sorry, I don't know which video it actually is. But here's Taylor's channel. Sometimes I've seen her, like, she'll record something, take it down, edit it down, make it more concise, and then re-upload it. So that's a possibility too. So my bad on that, but it's possible in one of those streams that's still up, that's where she was talking about Greg and the indictment. He's indicted with several others for gang charges. So that might have been what Big Jeff was talking about. So, not sure, but just a guess there. We got something we can get away from this, this nice, lovely logo here on the screen. Let's see. Where's Thugger Daily? Let's put some Thugger Daily on the screen. And guys, I see you guys saying that Cuff Boys has his video up. I'm so excited to watch that. Shout out to Cuff Boys. Oh, okay. All right, so we'll get this up on the screen. Let me see if I can make it smaller, because it's Get ready, ladies. Get ready, ladies. It's gonna be Jeffrey Williams with a chat room favorite here. So looks like they're using FaceTime, maybe, right? Uh-oh, FaceTime. But it looks like we've got, I think that's Kokomo up there in the corner. So was just trying to find some Thugger Daily to have on the screen with us. And this is the post that we get. I don't know if I can make it fit the screen better. There we go. We'll zoom it out a little. So there you go. There you go. Heck yeah, this is awesome, Blount Boy TV. You know who Jera56 is? The GOAT? The GOAT? Shout out to Jera56. And shout out to Blount Boy TV. Jamila says, I'm crying. Well done, lawyers. Heck yeah, price definitely going up. Sandy says, love this and can't wait to hear from jury interviews. I think a few will probably speak out. I mean, imagine like if they haven't actually been talking about this case. I like to just assume that jurors are following the rules the best that they can. But imagine like after all this time to finally be able to say something. It's a little bit different than a week-long trial, right? Where you, all right, Monday through Friday, maybe we deliberate the following Monday and Tuesday and then we're done. Right? You miss a weekend, you miss like 5 days of watching the news and chatting it up with your family, going on social media. But imagine 2 years, right? Finally being able to get that off your chest. So I'm sure we'll see some interviews here. Again, I think Dennis had an alternate juror. So if you want to go over to Dennis Byron's channel, I think it's under his Hip Hop Inquirer. Have to double check on that. Because I usually, like, I follow Dennis on Twitter. I don't know if I really like watch his YouTube, but I think his channel might be Hip Hop Inquirer. So I'll have to get straight on that. But I think he had an alternate juror on. So, and thank you, Sandy. Let's see. STS says not guilty on RICO. That's interesting. That's extremely interesting. And this is going to be, I think this is the scathing burn to the state. We finally have a jury verdict, and it's no to RICO, no to gang charges. So crazy. Okay, you guys are saying in the chat that the alternate juror is nuts. I wish I hadn't watched a bit of it. And Angie says, don't bother. The D's life is going to say she was going to say guilty. Now, I'm not saying if those things like turn your stomach, like I'm not going to say go watch that and get your stomach turned. But at the same time, I think it's important to be aware that that's why juries are risky. Like if she had been on the jury panel and wasn't convincible and we had a hung jury when all 11 other jurors might have been willing to acquit, right? Let's focus on Deamonte Kendrick. I don't want to have to specify every time except one count. We're just going to play it simple for the sake of conversation. Everybody's willing to acquit except for one. Sometimes it's how the cookie crumbles, right? That's the risk. And if that were the case, you know, these questions of, you know, should Thug have not taken a plea? Well, the jury could have been 11 plus this one, right? So you just never know. You just never know. So, yeah, and AK says that the juror said that the defense was disrespectful. Whew. I wonder which alternate it was. And she started off by saying she was mad at the other jurors for going not guilty. Now, I'm not going to lie, I probably will watch it because I just like to hear why people think the way they think. Yes. No, I know Coco's not Thugger Daily. Kokomo is not Thugger Daily. But this is great. This is great. At least I don't think the voices are the same. So, but yeah, we just got this up here on the screen for no reason. Like, I really just wanted to pull Thugger Daily up, like, you know, show him some love on this day of all days, right? And then coincidentally, here's a picture here with Jeffrey Williams and Kokomo, a chat favorite. So, let's see. Yeah, Leah's dad says, is someone critical of Whitaker? This is a W move. I think I read this earlier, but I agree. And I think it's fair, you guys. I think judges, when we hear an attorney speak about judges, they obviously practice. They'll probably have to practice in front of that judge again. When an attorney says something very nice about a judge, there can be a lot of truth behind it, but there also might be a sliver of, well, I wouldn't come out here and say anything scathing, even if I wanted to, right? But at the same time, when you compare that to a YouTube chat and the YouTube chat slang, you know what? I appreciate Whitaker for that. I think the sentiment rings loud and clear. That I think people here, at least in this chat, are very happy to see that Whitaker said, look, you know, 10 to serve 2 times served, and the rest will be served on probation instead of in custody. I think the chat was very happy that she used the discretion that she could use in that way. So I think this is good here, Leah's dad. Always love to see someone. I think it's important, right? We shouldn't always be 100% for somebody. We shouldn't always 100% be against somebody. Nobody's ever 100% perfect or 100% wrong about every single thing. Like the broke clock can be right twice a day, right? So this is good here. I think this is a good way to approach things here, Leah's dad. All about the shade. Heck yeah, perfect username for today. Love Paige gave the state the middle finger. Heck yeah, all about that shade too. I am your username today. I am all about it. Paige seems all about it. The island that Abate is just stranded on over there by himself. Hilarious. Love it. Shout out to all about the shade. Jennifer Devine says, in your face, love. I hope they sue. All right, these chats might have come in right at the time right after sentencing, I guess, right? In your face. This is a hilarious sequence here. Nas said, LMAO, Thug got more time than SB. I mean, true, right? For this probation, right? He's got the 15 years. It is what it is, but there could have been a risk, right? This alternate juror could have been on the jury, and you just don't know. Hindsight, you know? Hindsight is hindsight. It's 2020. Sweetie88 says, if this ain't a slap in the state's face, a huge warning for the next set of boys' trial. That, mind you, will be the same trial because a few guys are facing the same charges for the murders, right? A lot of the same overlapping things that we heard about in this first trial for the 6 co-defendants that went down to 2. I don't know if the state's going to have any self-reflection. I don't know if they'll try to come in twice as hard, swing in twice as hard because they took this L, right? You know, sometimes, like, when you watch sports, sometimes you see, like, the greatest performances after someone gets, like, 3-4 straight losses. That 5th game, like, they're out for blood. So, we'll just have to wait and see. But yeah, definitely some sort of impact on how this is going to play out. Black Butterfly says they took this ish to trial and beat it. They sure did. They sure did. And I really think, I know we have that possession charge, we have the count 64, but I mean, a jury's asked, did they have a gun in their possession? Did they knowingly have it? Right? If they check those boxes, unfortunately, it sucks, but that is what it is. But they beat everything else, which I think is a huge, huge, huge victory. Amber Don Them Johnson says, ready for the YouTube creators reaction verdict mashup. Yeah, they're just gonna have me be like, hold on guys, I'm turning on my camera. I do love those. Those were great for the Depp v. Heard trial. The creators that clipped together a bunch of those clips. Those are really great to watch. Gloria Smith says, I think the jury did that to make the state think they were going to have a guilty plea. Hilarious. Hilarious. You know, asking the questions, you mean? Asking about those certain pieces of evidence. And what I would appreciate is if they were torn on something and they looked at the evidence again, I do have an appreciation for that. Again, they didn't have a replay button. So if they were unsure about something, I think the right thing to do is to say, we want to look at it again, instead of just saying, we're just going to guess. We're just going to guess. Especially if that guess would be towards, in support of a verdict of guilt, right? Some juries seem to do that, right? I don't know what goes on in deliberation rooms, but there are some times where I just feel like juries just went in there and felt guilty all along, didn't really want to look at the evidence, just came right out with a verdict. So I have an appreciation here for the way the jury did this. By all means, let them ask their questions. If it was because they wanted to say ha-ha to the state, that's even funnier. That's even funnier. Carrie Williams says, justice served. Well done, jury. That's the thing. I don't think the state, nobody can come out and tell us that the jury didn't do their job. And it's so disrespectful, right? The same way that I just said an attorney might want to stay on the nice side of giving praise to a judge, even if maybe they have some criticisms. The way you see attorneys package that up, it's usually in a very professional way, right? You don't want to bite the hand that you got to practice law in front of. But same thing with the jury. You don't want to come out as a prosecutor making a statement, as a district attorney making a statement, and throw shade at the jury. But sometimes that seething feeling seeps through. And I wonder if we'll get that here with this DA. Because who do you blame at this point? Who do you blame? You sent a whole email praising one of your lead prosecutor on this case, Adrienne Love. You sent an email praising her not too long ago. What was that, like a month and a half, maybe 2 months ago? Are you going to suddenly blame someone that you sent a whole nice, warm Uber driver story to? Who are you going to blame? Who are you going to blame? So, oh boy. Speaking of DAs, one happy white girl says, thank God the DA's office lost their asses off in these cases. Yeah, I think they're carrying a huge L today. And again, I don't know if that's a good thing for... It's one of those things that if I was in the shoes of somebody considering a plea deal around December 17th, I might be like, well, holy moly, let me really give more weight to the option to cut my losses and not risk going through to a trial. What if I'm one of these co-defendants and I hear this juror alternate interview, right? And I'm like, oh my gosh, this woman could be on my jury, right? You know, the things that could impact how the next case moves forward, the next co-defendants, their trial moves forward. I really think the impact could go either way. But today they are carrying an L. The DA's office is certainly carrying a giant L. like pull it down from a big storefront, one of those giant sign letters. Just walk around with it. Oh gosh. Oh boy. But I agree here, you know, they're carrying the L. I think this is justice served. I think this is well done for this jury. I haven't listened to that other juror interview, but I'm interested in hearing the sentiment. And kind of from what I've heard, I'm like, oof. Sonia says we did it, Slimes, with all the green hearts. Heck yeah. Tay Biz says for Asgard. Shout out to Dougie Wine. Oh, I love that, Dougie Wine. And Mad Max for the dedication and fight. An amazing day today. It was really nice to see them speak. It was definitely nice to see them speak. Let me do a refresh over here on X and see if we've got anything. No. I mean, maybe. There's a lot. X is very busy right now, so maybe there is something interesting, but nothing refreshing from, you know, the news anchors, the journalists, Thugger Daily. So, one happy white girl says, White Woman Whitaker, I think, right? WWW, the World Wide Web, gave the state the slap in the face she's been wanting to give them. It did feel like that. I think it felt like that for sure. And again, I wish I still had quick access to all the shade here. Love that username. But yeah. Can't find it, but heck yeah, I appreciate all the shade that, in my view, Whitaker was giving to the state today. Maybe she wasn't, but that's how I read it. Amber Donnham Johnson says, so y'all, YSL is not a gang? That's the outcome that I'm walking away with today. Hilarious. David Newth, good to see you, says happy belated Christmas dress rehearsal. Also, am I too late to point at the state and do the Nelson? Ha ha. Hold on, should we pull one of those up? Hold on, can I get that sound effect really quick? Okay, is there a way I can turn this volume down before I blare your eardrums out? All right, we've got this quartered down here. We'll get a quick haha. So there you go. Thank you so much, David Newth. Love that sound effect and very perfect for this moment. Cat B Dog says, I feel sorry for those who took plea deal with time, particular for Williams. I get it, right? It's one of those bittersweet things, right? Could have had a different outcome if we kept going, but at the same time, you made the decision for whatever reason you made that decision. So I feel sorry for, like, it's a lot, right, to weigh on you to think about these things over and over. But at the same time, I still think that in the moment, made the decision that was right for whoever one particular person was. You know, whether it was Nichols' decision, Huey's decision, Jeffrey Williams' decision, the way that they made their decision in the moment, I gotta respect it. Because I'm not in their shoes. Marcus Williams says that video with the fourth car pulling up sealed it. Terrible detective work for sure. Viverito's handling of the watch didn't help either. Yeah, I really think that watch thing stood out to a lot of people. And you're mentioning Viverito here, but I think Viverito's unwillingness to concede anything at all, she wouldn't concede to. She wouldn't even concede to within the same 2 minutes. You just gave 2 answers to what you think is being said in this call between Boyer and Garlington about scene, city. You just said 2 different things. And she didn't even want to admit to that. We just saw you do it. You look dumb. You look so dumb. And unfortunately, maybe for better or for worse, right? Maybe the same way that we're all like, wow, Viverito, what are you doing, girl? Like, maybe that same sentiment will carry through for this next trial. But at the same time, maybe a different jury will stick more to what she says. Maybe she'll improve her delivery. She seems to me like the person that instead of having some self-awareness and doing some self-reflection, any reflection she does do is going to be how can I say the same thing I was trying to say the last time, but say it better so I don't get called out by a defense attorney again, right? To me, she seems like the type that's going to try to improve her delivery, but stick by her guns and not change her stance on literally anything, right? So that's extremely frustrating. And again, we've talked about this. Imagine if that FedEx video didn't exist. I know the FedEx video is what they used to get this LPR read or whatever, so they say. They also had the frozen camera footage. So I think they would have had the LPR reads regardless. But without this FedEx video, we wouldn't be able to have Max say 34 seconds. We wouldn't be able to have the jury say, can we run that back? Imagine if we did not have that FedEx footage. Just crazy. So, thank you, Marcus Williams. Sean D says, great job, Kat. We love you. Love you right back. Will Shannon have to sit in jail to wait on probation conditions, or will he get it to go home today? So because of this other pending thing, I guess he's stuck for a little while longer. So not really sure there, right? Or maybe there's and it's such a short time window if they're moving forward with that. I mean, maybe there's a reason that they would go and ask for a bond on that remaining issue he has to deal with. But by the time that plays out, like, the whole thing could run its course, if that makes sense. So it seems like he might not actually be coming home today because of that outstanding case that he's got to go through. So, but yeah. Nana Banana says, K&W, you're a beautiful person for all you do. Thank you so much, Nana Banana. And I believe you hung out with us while we were doing our angel gift shopping and wish list. So thank you so much for being a part of that. Sassy Experience. I know Sassy joined us late today. Like the verdict gets done reading. I think sentencing gets done. I see Sassy pop up in the chat. Sassy has been here with us watching this trial like every single day. And she comes in and she's like, oh, I missed it. Right after sentencing, we go back to the seal. Sassy says, Cat Girl, you've become my favorite YouTuber. Aw, thank you so much. Riding with you. I'm glad you got to join us today. Definitely glad you got to join us today. Violet says, God is good. Can't stop crying tears of joy. I'm so happy just thinking about what it must be like when Miss Tasha gets to hug Deamonte Kendrick, right? As a free person, right? Maybe they've hugged in court. I don't know how the deputies, how much they pay attention. Because it seems like there's been times where people have been able to hug each other in court and it's just talked about later. But hugging your son after they've just been freed, I know that's going to be a whole moment. And just thinking about it makes me so happy. Like, I'm neither of them, but I'm like so happy thinking about it. I see in the chat, does Cash Money Cass have a video yet? Like, her video's gonna be in like a rowboat in the yard. She's gonna be pouring cups of water out of it, and she's gonna be playing Abate, just abandoned by himself. I don't see an update here from Cash Money Cass here on X, but I am sure she's got material to record today. So as soon as I see that, I will reshare it. Absolutely. Let's see. Steph JK, this had me dying when I saw it come up. Vera's somewhere big mad. Yeah, where is Vera? If Vera, mods, if you could do me a favor, if Vera shows up today, let her be. Just let her sit here and marinate. Oh, Vera. Shout out. It's so funny that everybody, well, not everybody, but so many people know the name Vera because of how pervasive these Vera troll accounts are. What a memory here for this whole trial. Let's see. KC Dog says, hey, Simone and Love, how you're feeling right now is effectively what down bad really means. And it's crazy. That's another thing from this trial. I'll never see somebody say somebody's down bad without thinking of these detectives, right? This trial, right? I saw a thread, I think it was like a week ago. You know, you just open X to see posts come up. I didn't really dive into the post, but it was like post text of somebody being caught down bad or down bad. And it was just like, somebody sending 30 texts because somebody wasn't responding to them. Things that could be borderline, but also like, hey, you just broke up with me and I miss you and want you back. And people are using the term down bad to describe that, right? But in this trial, some of the detectives would have you believe that the only reason someone would use the phrase down bad is they were lacking and we were able to shoot at them while they weren't suspecting that we were about to roll up and shoot on them. So, love that every time I hear that phrase now, gotta think of this trial. L1915 says, so happy with this outcome. I think Georgia needs to look at this district attorney's office. Kat, I will miss your coverage of this, but time for something new, right? Always got to be time for something new. And I do think even this continued, as this plays out for the remaining co-defendants, I think it's going to be a little different, even though it's going to be so much the same. It's still going to be different. So, so glad you've been here with us. Start Pushing Weight again says, great work on this chapter of the YSL RICO trial. Can't wait for the next chapter. I'm telling you, I really think it's going to be interesting. And it was one thing to hear there was an attorney that said, hey, I just got admission to represent whoever on this case. I think he said August. It was a guy speaking, and I haven't gotten any discovery. And Whitaker was kind of like, oh, well, but maybe also the previous attorney can send that stuff over to you. But then we have Nicole Fagan, who's been here longer. She went through a whole pregnancy, right? I think she gave birth since she's been representing Tanquarius Mender. And she came up and said, hey, I haven't gotten any discovery either. So it's one thing a new attorney comes on the case, is looking for discovery. Maybe there's confusion. But what about when an attorney who's been on the trial, named as the attorney of record, the lead attorney for a client, she doesn't have co-counsel, it's only her. And she's like, I didn't get any discovery either. Right? So to me, that signals, oh, state's going to be up to the same messy, disorganized, not prepared, not doing their homework, not doing the things that they're supposed to do, and whatever 10 other things I could clap my crab hands at here to say that the state's doing once again. Right? It's going to be a whole nother chapter, and there's going to be the same messiness from the state. So, oh boy. I also can't wait. Hope to see you there. Start Pushing Weight again. Angie Lay says, my beautiful cat mods and the chat, it's been a wild ride. This has been the best coverage and chat I've ever had the pleasure of being part of. We love you, Angie, so this means a lot. Show Angie some love. Angie, throughout the days, has gifted so many memberships, made so many people green, created a whole RICO within this chat, a whole gang. So show Angie some love. I'm glad to have had you here, Angie. G and K Play All Day said, oh, hold on, we got birthdays too. G and K, happy birthday. Get some presents going in the chat. What a gift, not mad at all at the verdict. There you go. I hope you get to enjoy your birthday today. And I think there's 2 people in your picture. So, what's better than a birthday for one person when 2 people get to celebrate? So I think both of you, I hope you have a great, great birthday celebration today. Happy birthday to you. And look, I'm scrolling up. Angie's out here gifting again. Look at Angie go. Thank you so much, Angie. And thank you, chat, for showing love here. Stephen Hickman says, justice served. Going to miss your smile in the morning. I know, my hi, guys. One morning I started the stream and I didn't say hi, guys. And the chat was like, we're lost. We didn't start the same way as usual. Can't wait to see the next gathering. So definitely December 17th. We'll get together and watch that, maybe some stuff in between. I want to do some catch up on a trial in Johnson City, Tennessee. It's a federal case, so it's no cameras in the courtroom. But that's the Sean Williams case. And what's interesting is there's allegations in several civil suits alleging a police cover-up and corruption, an extortion scheme where Sean Williams is accused of having 50 plus victims of SA, rape, pushing a woman out of his 5-story apartment window. And on top of all of that, if that's not bad enough, there's allegations of extortion where Johnson City Police Department officers were either taking money out of his safe while they were searching his home or extorting him. There's some bank payments that came out in discovery of $200 weekly payments going to the officers from a holding account that Sean Williams had. Like, just crazy. So there's, I guess this is still, his trial keeps getting pushed back, the criminal trial, the federal case. But I do want to catch up on any of the civil happenings. I've been behind on that. The last update I did was the beginning of November. So that's going to be something I'll probably cover between now and December 17th. Again, crazy story in and of itself. But when you add the layer of a police extortion scheme to support someone that's doing all of that, it's just disgusting. So it's something I want to keep following because it's something that pissed me off. It's something that's pissing me off. So thank you so much for the kind words here, Stephen. We're definitely going to be looking at December 17th here, the next status hearing for the remaining defendants, plus whatever else just pisses us off. We'll do it. FFS, thank you for the reminder here. Sorry I'm getting to you late, but I love it. In all caps, FFS is like, Cat, Doug's on 11 Alive. So we got there eventually. We got there a little late, my bad. And love you, FFS. Thank you for being here as always. I can't wait. I know I'm late for Flesh of the Gods, but hope to see you over there. 8K says, love the joy Paige had with the verdict sentence. Right, I really felt it. And I think that's hilarious. Like, I'm glad she had joy and didn't use the worst that she could within her discretion. She did the minimum she had to do with the sentencing for 10, but said, all right, time served, and the rest can be served on probation. That's a very nice... I'm glad she didn't go to the extreme, right? She went to the lowest extreme, the lowest end of the extreme for sentencing instead of the harshest that she could. But the tone of joy just brought me so much happiness because it's an FU to the state. It really felt like that. So AK, I'm with you. I loved it. Survivor Speak says, I'm sure Steele will look into what options Doug has regarding being around Yak since he's a convicted felon. Yeah, and I really think however that plays out, I mean, I won't know it until I see someone try to raise an issue about it, right? So I just won't know. All I know is that I have no doubt that the state, the prosecutors, APD are going to be like binoculars in the bushes. And that kind of sucks for anybody to be under a constant state of surveillance. Toggling over to the chat, I see someone asking for an all caps. Viral me crazy. Heck yeah, we can do an all caps. And holy moly, what is this? Hold on, let me go find this. So I wish I could show you how StreamYard, I think it would do like an infinity mirror if I tried to show you what StreamYard looks like. But when I'm going through chats, I can't always see everything. But I just toggled over. What the heck? Holy moly, Chippy Wing. Holy moly. If you're doing an all cap session, take some time to shout out Chip. Holy moly. This is a 22222. Thanks for covering this trial back when no one else was interested. You're so smart, caught so many things I missed. Thank you. Well, let me be clear here. I've been watching this trial since pre-trial. I was not always doing videos. The videos that I did do were about civil forfeiture, were about what I thought was wrong with the plea deal for Tick, right? So they weren't trial watches. They were just like summary commentary videos. But this is incredibly sweet. And thank you so much, Chip. I think you guys might have heard me say out loud. Chip pops up in the chat. Chip is extremely insightful. Chip has had so much information and context about this case that there are times where I've learned things about this case. Like I'm talking months ago already. And I would see Chip say something in a chat where I was watching it. And it would be like an earworm. It would stick out to me and I'd be able to go and do some research, look at the documents, look at it in greater detail and learn more from Chip. So Chip, this is entirely a two-way street here. Same back to you. I'm so glad you've been interested in following this case. I'm so glad you've joined us to watch it here, but I appreciate all of the conversation and insight that you've shared across other channels. I feel like, I don't know, like Lead AV, I've seen you over there. I've seen you in a bunch of different chats. Maybe recently Flesh of the Gods. But you've really dropped like nuggets of wisdom and information all over the place. So this is incredibly generous. Thank you so much. But guys, show Chip some love in the chat. Because there are really a ton of people out there that we've gotten to learn from, and Chip is one of them. Heck yeah, Biff. Chip knows. Chip knows. We got the salute here to Chip. Seriously awesome in all caps. Who's saying I'm late for the first time? I'm late a lot. I'm late a lot. But yeah, shout out. Chip is really slime. Chip, Chip, Chip. Thank you so much, Chip. Big, big thank you here. And also, chat, thank you for sharing the love on the B-Day wishes. G&K Play All Day says, thanks for the birthday wishes. Always love to have a good birthday. I love gifting. I love someone having a special day. I think everybody deserves a special day. So thank you for being here. Thank you, chat, for sending well wishes to other members of the chat. Finding Good says Whitaker said it with candor. Yeah, she said it very politely and professionally, but with a little hint of a tone. So she did it perfectly. And again, when you read a transcript back, you don't see that tone. You don't hear the tone. Maybe you can read between the lines, but sometimes that type of tone is lost in a transcript. But we got to watch it. Brian B says no jury poll. Is that normal for Georgia? Love to Maz and all my slimes. I don't know if the defense attorneys, I mean, maybe Shart on the one charge if he wanted to press his luck. But I don't always hear a jury poll. Sometimes I hear them asked for. Typically when I see it asked for, it's either procedural for that courtroom, or it's a guilty verdict and the defense attorneys are looking to poll the jury. So I don't think it's a thing where it's always something you see done. I think some courts do it as a procedure. But I'm not surprised that these defense attorneys didn't ask to poll the jury. So, like, maybe they just wanted to salt the wound, right? Have us reiterate one by one that we did not agree with you, state, right? Hilarious. That would be hilarious. Heck yeah. And guys, don't forget the origin here of the slime panya, the green champagne glass channel emoji, is when Cash Money Cass, I think she went on vacation. And something interesting was happening in court on like a Friday. You had left on your vacation and something really crazy was happening and people were looking for you and we're like, oh, she's on vacation. She's on vacation. So the whole chat got to know that you were on your vacation. And then you come back and you're like, I got engaged. So that's where the slime panya glass came from. It came from Cash Money Cass's engagement. And I think you're setting a December date, right? For next year. So we'll all have to get back together then. And Chip Ewing is saying Thugger Daily is way out of my league. All love to Thugger Daily, but all appreciation here to Chip as well. But yes, feel free, you guys, drop some champagne glasses for any occasion, either to celebrate Cash Money Cass, to celebrate these birthdays in the chat. We have Shamina celebrating, as well as G&K Play All Day. We could also celebrate, you know, today's verdict. So Donna Grenz is saying, does anyone think the prosecution learned anything from this trial? Oh, I'll let the chat handle that one. Heck yeah, Jennifer Devine says now Shannon's lyrics are true, but he beat 2. Yep, hilarious. Imagine he re-records it and re-releases it with the updated lyric. Definitely gotta stream that one, give it a play. Again, as an FU to the state or to support Shannon Stillwell, whatever the reason, give that a play, give it a play. Sleepy in the all caps says, thank you, Cat, Slat, and the chat. Thank you so much, Sleepy. Another person, very grateful to have you in the chat and sharing your insight through and through. Isabella says, Doug promised after they rejected the plea deal that he was going to walk out with Yak with a not guilty, and he's done it. I'm so happy for them. And can you imagine being Doug in that moment when they asked about the watch and wondering if they're thinking, oh my gosh, what if Doug was thinking, like, I spent so much attention on that watch, they're going to think that that's my client's and think that my client is also responsible for the drugs and gun charges, right? Can you imagine that moment of, for Doug, like, this has to be a super relief, because not only is it your client's freedom after all this time, but I would imagine he had a little bit of nerves racking, wondering, did I make a mistake by harping on this watch? And that's not the case. That's not the case. So what a big relief there that must be for Doug. Very, very happy for Doug. And again, guys, this was He's a civil attorney before this. He was a civil attorney before this. And now he came in, he's doing this criminal case. It's a RICO. It's had a whole team of prosecutors putting this case together. And he got up there. Who would ever know? Who would ever know? And thank you, Isabella. Natasha Robert says, I'm at the hospital for my chemo. Oh no, love to you. And scream and cried of happiness. And the nurse ran in to see if I was okay. Did you tell her about the trial? I am that meme. There's like a meme of like a girl yapping in a guy's ear that looks like they're at like an outdoor concert, but it's like the picture itself became a meme of you rambling on about something that the other person might not care about. And that's really how it feels sometimes talking about this case when someone brings up, it doesn't even need to be all that related, right? Just anything that's like, oh, somebody's ridiculous. Oh, well, you know who's ridiculous? Let me tell you about the prosecution team in the YSL trial. Just because you said the word ridiculous, that got me thinking about this trial. Hope you're doing well, Natasha. I can imagine the nurse running in to see if you're okay. But probably a happy moment when you get to say, I'm all right, and I hope you're doing all right. But here's why I just yelled. So well wishes here to Natasha. Nancy New One Too says, fantastic that Miss Weaver was there to see this. Yep, I really think Miss Weaver has a big heart of compassion. And so might the other court reporters. We just didn't get to know them on the same level as Miss Weaver. And maybe we will, especially if we follow more and we get to see Whitaker's court reporter in this next trial that's going to move forward. But it was really cool to see Miss Weaver in here for this day, right? A little bit full circle. Sentencing is done, you guys. Sentencing is done. So no sentencing needed for Yak because he's not guilty. And then for count 64 for Shannon, she said, all right, well, I have to do the max because of the recidivist notice from the state, which would be 10 years, right? It would be 5 to 10 would be the sentencing, but I have to do the max. I don't have discretion here. But you have to serve 2, and I'm going to give you time served because you've been in custody for so long. And then the remainder to spend out on probation, right? So sentencing is done there. And that's how it played out. So, hold on, wait. For real, there's a Juror 56 over on Twitter? And always, you never know. People can make accounts and claim to be anybody. At the same time, I wouldn't be surprised if somebody in this trial, a juror in this trial, wanted to make Twitter and talk about this after all this time. But that would be hilarious. If we have their Twitter, I'll pull it up. We can pull it up and look at it. Oh, heck yeah. Okay, let's go. So Thugger, I went to Thugger Daily first. So always love to Thugger Daily forever and always here for his work on this case. Let me share my screen and start this back at 0. All right, so Juror 56.
I'll report that I was one of the jurors for the YSL court case here in the state of Georgia, the longest court case in the state history. We just wrapped up a few hours ago, delivered the verdict for 2 of the remaining individuals. A long time, a year and some change. It took us about 4 or 5 days to deliberate, and now we can get back to our normal lives.
Thank you, Steph.
I talked to my sister not too long ago. I'm the infamous juror number 56, as well as the foreman, and we'll talk more about this court case at some other point. In the meantime, I'm going to relax, get my life back to normal, my regular routine, and get back in the friendly skies and travel around the world. And yeah, we'll talk soon. All right. I can finally report that.
All right, so I guess more to come there for that. I think he's going to end up doing like a TikTok or YouTube route, just the way he's recording this. So I'm sure we'll get to hear a ton of insight directly from him. So again, I would imagine Thugger Daily would, and I love that this guy got a video too, Thugger Daily. I mean, maybe I'm reading into it, but there aren't any watermarks here. Like, it's not like he made a TikTok, Thugger Daily went and found it, or someone sent it to him and then he uploaded it. This is like an unwatermarked video. So did this video get sent directly to Thugger Daily? Because I love that for Thugger Daily. Love that for Thugger Daily if that's the case. But very interesting. He knew to go right to Thugger Daily if that's the case. Not sure, but just saying. So let's. Thank you, Steph, for dropping Thugger Daily's link. I'm gonna link to this because I have it open. And again, if you don't plan on watching the trial for the remaining co-defendants but would like updates, Thugger Daily is a great place to follow for that. Right, better copyright Juror 56, start making some jerseys. Hilarious. The infamous. He said infamous. Is it really infamous? Is that the right word? Is that the right word? So, there you go. Can't wait to hear more. Amber C says thank you with the green amphibious emojis and the green hearts. Thank you so much, Amber. Yeah, so I don't know. Do you guys want to do is the Fani hearing even on yet, or is that 1:30? Let me know if that's on yet. I mean, we can pull it up if you guys want. I think that's 1:30 though, right? So they're probably just showing, you guys said it's Judge Ingram. Notorious 56. Is there a stream? I know it's going to be streamed, but is there a stream already live for the hearing? The open records hearing? I thought it was starting at 1:30. I mean, maybe I should look on X and see if somebody is talking about it. See, I don't know why I'm thinking 1:30 for the Fani Willis hearing. But let's pull up, I'll just open an 11 Alive window. I gotta close, I have so many tabs open. I feel like I've closed my tabs 3 or 4 times today and somehow I still have more creeping in. Let's see. All right, so I do have an 11 Alive window up here. We will toggle over if we see them start this up. Well, I guess I can mute it. So 11 Alive has like a theme song that they play that always gets a copyright hit. Oh, and they're disabling chat. So I'm going to keep this window up just because I can't, when the stream hasn't started yet, I can't mute it in advance. Oh, it just pulled over. There we go. I do want to get through some of these. I want to make sure I'm paying attention, getting through our conversation and wrapping up our thoughts on this verdict. So we will 2 times to catch up. We've got 20 here still. So again, big thank you to Amber C. Ariana says, thank you, Kat. You are the reason I watched because you explained everything in great detail. They will be home in time for the holidays. I think that's possible that might be possible for Shannon, the way Shart was saying he hopes that wraps up pretty quickly. And that would be really great, I think, for anybody, especially anyone that's awaiting trial that might consider taking a plea deal on December 17th. So, and thank you so much for the kind words here, Ariana. Jenny Not From the Block says, thank you, and mods, what's our next case? So we're still going to follow this YSL case. But, we'll see. I will do the Courtney Clenny OnlyFans trial whenever that gets a trial date. That's been in like hearing purgatory forever. But we'll be here. And again, I hope I see you guys in other chats for other cases. I do love to hang out and watch other cases chat side and not always the one streaming them. So really, again, glad to have met you, Jenny Not From the Block, and so many others. KC Dog says, and we still have yet to find Rico. Well, if we go back to Y Turner, Rico for the state, maybe. Maybe that's where we've got to find it. So thank you, KC Dog. Harp City says, SB's new song, Beat Another Murder Rap, paid my lawyer $300K for that. He should have been charged. He never should have been charged in the first place. And yeah, what do you think about that price tag of $300K compared to what this may have actually cost? Like, I know this was just a song recorded a while ago, but what about now if he had to write the same lyric about what this trial cost? So, Bridgetta says, Kat, thank you for letting me be a part of your YouTube, and this is my family for life. Love it. Peter Ortiz says, a happy ending to this drama and miscarriage of justice. You did great. Kat, I will continue to follow you. I'm now in Fort Lauderdale for the winter. Okay, Snowbird. Trying to be like me. I always joke that I moved down here as an early retirement from New York, starting my snowbird life early. Merry Christmas to you and my fellow slime. Merry Christmas right back to you and to Lucy with the Santa hat. Feel free to drop some holiday wishes here in the chat, you guys. I know people celebrate different things, but always just good cheer all around. I love the holiday season no matter what I'm actually doing. And love to hear this that you're in Fort Lauderdale. It's a little cold down here today. I've got a sweater on, but hope you get some nice weather for the remainder of the winter. And thank you so much for being here. I know sometimes we don't always align on how far we think this person's guilty or not guilty, but it's always a pleasure to have this discourse with you, Peter. I'm so glad that you're here. Latasha Gaffney says, Thug, Shannon, and Yak's attorney's fee has just went up. Heck yeah. Toothless Tiger says, I heart me some KNW, mods, and the chat with a capital C. You've really done this trial justice in your coverage of it. I hope you get an interview. Thank you for your philanthropy. And we've got some more to order again. Thanks again to Sapphire Ridge News. I still got to get up there and pick out some toys before we close the stream out. Thanks to him. Thank you for your philanthropy. Such a beautiful humanitarian and help us small content creators. We'll get bigger because I need you guys. I need you guys to survive and thrive so I can watch you guys. There's a little bit of selfishness there. I want to keep having stuff to watch and a place to hang out when I'm not on screen. So Toothless Tiger, thank you so much. It's been great to get to meet you through this trial. And again, of course, it doesn't stop here. As far as an interview, I mean, I guess I'll talk to anybody. That'd be cool if someone asked. But there's so many people I want to hear from, and I don't really care who's interviewing that person. I'm just excited to see people speak their piece now that this is over. So thank you again for the kind words here. Show some love in the chat for Toothless Tiger, and give her a follow if you haven't already. Katie Henry says, thank you, Cat Mods, and the chat for a great experience with this trial. And thank you guys so many of this praise. Thank you so much for shouting out the mods and the chat. The community here is top tier. Hope to see you guys around. We've got to spread our wings, gang. We've got to infiltrate. We've got to take over more territory. So thank you so much, Katie, for the kind words to me and to the whole community. Brian B says, no jury. Well, we did this one. Finding Good says, Whitaker said it with candor. And then Dark Brown Queen Krisha. I love the name Krisha. Had a fun friend named Krisha back in the day. What's next for you, Kat? Well, I think I've gone over this. We're still going to cover that YSL trial. Flexible on other stuff. If there's stuff you guys really want to see me cover that isn't being covered somewhere else, I might be inclined to take up a crowd vote. But really, there's so many. I know a lot of people are saying maybe Dirk, which is federal, so there's no real camera stream for that. But some of these other big cases where there's so much coverage already, I don't really feel like it's the same fit. But I'm open to suggestions. Jenny, not from the block, thanks here for the super sticker. Hold on, let's see what it was. It might be long gone. Let's see if YouTube comes in clutch. Scroll back up. Oh, it's the lemon. It's the waving lemon. So thank you so much, Jenny, not from the block. And some guy with cancer, your name tugs at my heartstrings, says DA Love is incapable of learning from failures. I think this is the truth. I really don't think there will be self-reflection. And again, her boss just gave her praise and said, your job is safe. So is there really a motivation for self-reflection besides, within the goodness of your own heart and wanting to be a better person? If that's not there and your boss isn't prodding you like you need to do a better job, what motivation to learn from your failure would exist? So I think this is a great point. Thank you for the 2. Squirrel Brain, oh, we missed you. Got here late. I'm going nuts with happiness. I love this, and I love your festive. Guys, if you haven't paid attention, Squirrel Brain is like an advent calendar of squirrel pictures that match whatever the detectives are doing. And today it looks like we have a very festive Squirrel Brain, a momentous occasion. So glad you got here. Thanks for stopping by, Squirrel Brain. Great to see you. And A Skywalker says, can't wait to run into Cat Slat Side. Oops, I meant Chat Side in another channel. Heck yeah, say hello. Can't wait to see you guys and remember your names and faces. And again, tune back here if you ever want to watch anything else we cover in the future. And let's see, let's get caught up here.
Maybe the school's water.
Maybe some of this is just filler.
We are here on Willis versus Kaiser et al. 24 CD 011204. All parties are present. I understand some of you want to share screens, so you should have a link there. You can join.
There's no closed captions,
and share your
guys.
screen when you need to. I am ready.
Who do you want to hear from first? We file first.
Yeah, I hear from you first.
All right. Can I hand up to you the PowerPoint?
So, were you, oh, thank you. Sorry. You wanted to share the screen there?
Yeah.
Okay, that's fine. I just want to make sure it was going to come off or it looks like that.
Yeah, we
It
do
is.
too. You know, if anything can go wrong in technology,
Right.
it will.
Except for, it's not going to come up on those screens unless you join the Zoom. Did you bring a device? You have a device you can join? If not, then
I'm giving them a copy.
Huh?
I'm giving them a copy.
They have a copy. Okay. I mean, I can see it fine from here. As long as everybody has a copy, it's fine.
Awesome.
Right. I'm saying, so if you join the Zoom, you can share your screen from the regular. Putting it into the device means it's only going to come up physically over there.
Okay.
I can see it just fine.
That's fine.
And as long as you've given them a physical copy, then you're fine with it.
Okay.
Okay.
Now, Judge, it's hard for me to talk in 45 minutes, but I'm going to try to do so. The issue here is the General Assembly may define, as we agree, its own subpoena power, but it has to be done by statute. It cannot be done as just, we want to do it, we pass a rule in the Senate. Ruth, what you saying here? And in fact, we go back to the case of Dean versus Bolton. This was Roscoe Dean down in Jessup, Georgia. It says the General Assembly may by statute place limitations on investigations of members of the General Assembly or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. But the operative word here is General Assembly. And the General Assembly has taken that from Dean versus Bolton, Arthur Bolton and Roscoe Dean, and they have defined when they can issue a subpoena, both in the 45-15-19. It says that in addition to any power conferred upon the Attorney General in this article, the governor or the General Assembly, not one house of the General Assembly, is authorized likewise to make investigations, and all authority and rights granted to the governor and the General Assembly shall be complete and absolute as those granted to the Attorney General. So the question here is, as the Supreme Court keeps ad nauseum reminding us, words mean what they mean. The General Assembly says what it means, the law says what it means, and it means what it says. Now they have exercised this by statute in the Committee on Ethics. The Committee on Ethics of the Senate or House of Representatives says that they are authorized to issue subpoenas in connection with ethics investigations. But that is, the General Assembly passed the bill. So we suggest to you that the textualism that the Federalist groups and the Supreme Court keep saying, you know, you got to read what it says. And we suggest that that's exactly what you should do here today. The Supreme Court said when we consider the meaning of the statute, we must presume that the General Assembly meant what it said. Now that's a big presumption that it meant what it said, and said what it meant. To that end, we must afford the statutory text its plain and ordinary meaning. And so when the statute in Title 45 says that the General Assembly is authorized to make investigations, that means both houses of the General Assembly agree by joint resolution or by statute. And in regard to the Ethics Commission, or the Ethics Committee, they did that by statute. The General Assembly knows how to grant subpoena power to committees, as it's done so in the past, and the General Assembly and the framers of the Georgia Constitution know how to distinguish between the General Assembly as a whole and an individual chamber such as the House and the Senate. Now there's a reason in the Constitution and in the statute, and I guess I'm the oldest one that has been through all this. This has been debated many, many years, and there's a reason that there is not just one house can run off and start investigating. They investigate whatever they want, but they have to have the statutory power to issue a subpoena. There's a reason. What if the Senate decided they were going to form a committee to investigate the House? Call the Speaker. Let's subpoena him up. Why are you not calling Senate bills up? That is ridiculous, and it's the reason that the power has been kept from individual houses and has to be devised by statute. Now, the committee, in its brief, cites Coggin versus Davey. Frank Coggin was a member of the state Senate. He's from East Point. And in 1974 and 75, this was a big issue. The conference committees met in secret, and what they called executive session. Conference committee is when the House passes one version of a bill and the Senate passes another version. The President of the Senate and the Speaker of the House appoint 3 members, and they get together and they come up with agreed to language, and then that's adopted. Well, the conference committee, particularly the one on the budget, was done behind closed doors. And so the press, rightfully so in my view, said, that's not right. You're spending billions of dollars. Well, the budget back in 75 was less than $1 billion. It didn't cross $1 billion until the late 70s and $2 billion in the early 80s. Now it's 32 or 33. But the press sued Frank Coggin and the members of the conference committee. Says we should be allowed in under the Georgia Sunshine Act. They said no. Supreme Court said no. Said, listen, the General Assembly is not defined as an agency, and that is subject to the Open Records Act. So they are not subject to the Open Records Act. And Judge Gunner, in the opinion, says if the General Assembly wants more sunshine in, they have the power to do it. They only have to change it. Now, this has been cited for something that is completely different. That's all this means, is that Coggin versus David simply means that the General Assembly is not subject to the Open Records Act. The second issue, so the first issue we have here that we claim is dispositive is what the statute says. Title 45 says only the General Assembly has the power of subpoena. Not the Senate, not the House. The governor has that power, of course, but a bill must be passed or a joint resolution. Now there's a difference, and I noticed this in rereading the briefs last night. And so when we pass a resolution can have the force and effect of law, but it has to be passed through both houses, and it has to be signed by the governor. It cannot just, and is loosely used by my distinguished friends here on the other side, is loosely used as, well, there's language that says resolutions. Resolutions that have the force and effect of law have to pass both houses and be signed by the governor. So we come back to this basic premise. It says that just what it means what it says and says what it means. In addition to the power conferred upon the Attorney General in this article, the governor or the General Assembly is authorized to make investigations and the authority to issue subpoenas and for production of documents, not just the Senate. Now they're going to argue here, as they have in the papers, and I know you've read all this, oh, well, that doesn't mean we can't rule ourselves. You can rule yourself. You can pass a resolution or a rule that says that every member of the Senate is subject to something. But you cannot go outside and issue a subpoena unless the General Assembly approves it. And it is done by joint resolution or by statute. Now, the second issue that I'll posit to you today is this. This committee, and I'm going to talk more about how all of this occurred. This committee issued this subpoena after adjournment sine die. You've seen sine die on the television where they throw all the paper up in the air. You know, I never have understood why they do that. But sine die simply means not to meet again. That's exactly what it has. And so what happens is Georgia is a General Assembly. It's a 2-year session. And on the second year, which is an even-numbered year, when it adjourns sine die, it is gone. It has no more force and effect. So what we suggest to you is, there's not a direct Georgia case on this, but there's plenty from Congress that says that after the General Assembly adjourns sine die, that is, not to meet again, that it has no power to do anything. It cannot issue a subpoena. Can it meet? Yes. Can it make recommendations to the next General Assembly? Sure. But it does not have the compulsive power of the state to summon someone before them under the pain of contempt. There's one of the early cases in 1821, they tried to hold this fellow in contempt of Congress. But the Congress, which I think one of the things wrong with the federal government is they stay in session all the time, but they used to adjourn sine die, not to meet again. And in Anderson versus Dunn, against Dunn, it was an 1821 decision of the Supreme Court of the United States. It held that the contempt power died with the Congress. That is, you couldn't hold somebody in contempt after the Congress had adjourned sine die. Peterson versus Elko, which is a Nebraska Supreme Court case in 2019, committee investigations and attendant subpoenas are presumed to cease to exist at the end of the term in which they are commenced. 2 separate Department of Justice memorandums from the Office of Legal Counsel under both the Reagan and the Clinton administration held likewise that when the Congress adjourns, that's it. They can't issue a subpoena, they can't punish for contempt. Now, the way they get around that up there now is they don't ever adjourn. But Georgia has a limitation on the number of days you can meet. So so that would be more difficult in Georgia. The resolution, House Resolution 978, says that the General Assembly adjourned sine die on March the 28th, and they did so. They ceased to exist. Now, from the opinions of the Department of Justice, it says, I'm just going to quote from part of it, this understanding that Congress subpoena power inheres in and is ancillary to the power to legislate leads logically to the conclusion that the legal obligation to comply with a congressional subpoena lapses upon the cessation of Congress's authority to legislate. So they can't have it both ways. They say, well, we can, yes, we adjourn sine die, but we can continue to issue subpoenas and punish for contempt. They can't have it both ways. Either they're in session or they're not. The decisions of the federal courts dealing with the Congress make it very clear when the Congress ends, its power ends. Now they don't argue with you, well, we form all these study committees. They form all these study committees so they can get the per diem every day, to come to Atlanta and get paid a little bit and all of that other stuff. I've never seen one that did much, but they do it. And I'm not saying that's their business, that's their constituents. But you cannot, under pain of contempt, bring about and punish somebody for not complying with the subpoena because they had no power to issue a subpoena after the General Assembly adjourned. Now the next point, so the statute means what it says and says what it means. That's number one. We think that's dispositive of the whole matter. Number two, General Assembly adjourned sine die. That's it. They can study all they want to, but they can't hold somebody in contempt or subpoena them after they die, after they've decided to die. The third point is the subpoenas are overbroad. Even if you got past those first two. We set forth what is asked or produced. All documents relating to the personal relationship between you and Nathan Wade from 2019 to the present day. I told somebody now, if the General Assembly's going to start investigating sex, they ain't going to be able to have a forum before the General Assembly to act on anything. But in any regard, then it says all documents relating to services performed, all documents referencing or containing text messages, all documents. I won't go on, but listen, there are privileges here that apply. There's the work product privilege. There's the prosecutorial immunity. I mean, this is what they were trying to do. Here's the president-elect, got elected. He's my president, he's everybody's president. But what they were trying to do was chill the prosecution of Donald Trump and find out what they had. That was all this is about, and as I'll discuss just a little bit later. The subpoena ducis tecum seeks every email or text sent by the former special counsel to the district attorney, including privileged emails concerning State versus Trump. All written work product generated by the former special counsel in the course of working on State versus Trump. All documents sent to or received from the Department of Justice. Now, can you believe that? It says, we want to see what you got from the Department of Justice, regardless of any privilege. That's what they say, regardless of any privilege. We suggest to you that the law is clear, even under a civil case, that the subpoena is overbroad, even if it was validly issued, even if they could issue a subpoena after they adjourn and sign it out. Then they talk about Gonzalez versus Miller and says, well, this is just the end all to our questions. Let me tell you what happened. Deborah Gonzalez, the district attorney of Clark County, she is today, where she got beat by an independent candidate down there, whose name I cannot pronounce. But anyway, there's a lawyer who got somebody to make an open records request on the district attorney. The committee claims, and she says, listen, I'm a part of the judicial branch. That's where she's placed in Title VI of the Constitution. And so therefore, the judicial branch is not subject to the Open Records Act. And so therefore, I'm not subject to the Open Records Act. The committee claims that Gonzalez against Miller justifies the breadth of the request, and that this lawyer asked for everything. And what the question before the Supreme Court was not on the breadth, and anyway, it's an open records request, it's not a subpoena. What Gonzalez has recognized, however, is that work product, attorney-client privilege objections to open records requests were not subject to the Open Records Act. It said that she was, the Office of District Attorney was, because she did not decide cases and therefore was not a part of the judicial branch. She had to interpret the law, that her job was to prosecute the cases, and that she therefore had an executive function that overrode the placement of her in the Sixth and Title VI. And at the Constitutional Convention, that was a big debate on where the district attorney should be. I won't get into whether they were right or wrong. But the main thing here is that it shows you how overbroad the requests are, and the case particularly holds that the attorney-client privilege, the work product privilege, the prosecutorial, all of those privileges apply even to an open records request. Those are gathered, that's on page 18 of the opinion, and it's in note 15. It gathered all the cases applying work product and pending prosecution objections to the Open Records Act. And further, the Open Records Act has statutory protections for work product. None of this, this rump committee created by one body of the General Assembly says, oh, wouldn't it be fun for us to just drag the district attorney down here and see what she's got on Donald Trump? Let's just see what she has. None of these protections are in what has been done in the resolution or in the subpoena. Thus, we suggest to you that the petitioner and their subpoena that says, well, you can't claim privilege, and I always says who? Privileges are matter of statutory and common law right. The one house of the General Assembly does not have the right to override what the common law is. My goodness, imagine what they do if one house could do that. All right. Our next point is that this violates the separation of powers. Now, this comes back to a case dealing with Donald Trump that went to the Supreme Court of the United States. It's called Mazars versus Trump. The House decided they'd investigate Trump. How much taxes have you paid? How much have you done this? What kind of deals have you made? He objected, rightfully, I will tell you. I think the House committee overstepped too. So here's what Mazars against Trump said. This is a 2020 case. It says, we're not going to say that they can't do some, that is the House committee, because they have the right by statute to subpoena. But they said this, because the subpoena power is unenumerated in the Constitution and justifiable only as an adjunct to the power to legislate, it is subject to several limitations. Legislative subpoenas to executive branch offices involve two different political breaches of government and thus implicate weighty concerns, questions regarding the separation of power. The Supreme Court went ahead to say the legislative branch may seek to exert an imperious control over the executive branch and harass it. And so therefore, we're not saying you can't do it. And all their cases said, well, this doesn't apply, says there's cases that say you can legislate. Yeah, of course you can legislate. You pass both houses of the legislature. But you cannot harass a different branch. Given these concerns, the Supreme Court set down several limitations. So number one, the subpoena must serve a legitimate legislative purpose. Number two, it may not be issued for law enforcement purposes, because that's the executive branch's domain to enforce the law. And the recipients retain common law and constitutional privileges. And so therefore, let's look. Is there a legitimate legislative purpose? The Mazars Court further specified that the courts that examine these kinds of subpoenas should look at several factors to decide whether there is a legitimate legislative purpose here. They say, does the asserted legislative purpose warrant the significant step of subpoenaing an executive branch official? To narrow the scope of possible conflict between the branches, courts must insist on a subpoena no broader than reasonably necessary to support the legislative objective. The legislature must offer detailed and substantive evidence of its purposes, not vague or loosely worded like, oh, we got oversight over the district attorney's funding.
Is he making fun of Bill Cowser?
That's a vague, and it's just a pretext. And the burden...
Right? Was he just doing Bill Cowser's voice from the Georgia Senate?
...imposed by congressional subpoenas should be carefully scrutinized because of the potential for constitutional conflict between the branches. Then it went ahead and says, other considerations may be also important. So Mazars in practice has held this, that in McLaughlin against the Montana State Legislature, which is a case in federal court, they said, listen, y'all issued a subpoena, but you're not exercising functions reserved to another branch. They went ahead to say that and that legislative, let me tell you what that subpoena was. It was a subpoena to the judges to investigate judicial bias in the courts.
Judicial bias.
And the federal court said, no, wait just a minute. You can't do that. You can't do that. You've got, it's just not a proper executive function or a proper legislative function. And it could not act as a law enforcement or trial agency. That's Watkins against the United States, 1957 United States Supreme Court. And you could not seek to expose for the sake of exposure. Mazars again. And there is no evidence of a legitimate purpose at all here. And so it fails to satisfy even one of the Mazars tests. And you say, well, how do you know that? Well, we'd have to be blind to not see what all of us can see and understand. But the subpoenas do not represent, this is exactly from Mazars, do not represent the run-of-the-mill legislative effort, but rather a clash between rival branches of government over records of intense political interest for all involved, that is, his income tax returns. They were targeted at one individual, targeted at interfering with one prosecution, which is what this is doing, and it's done at the behest of the president-elect. And it's pushed by Georgia elected officials who in the first place sought to undermine the 2020 election. I have heard for the last 4 years from my Republican friends,
The arm cross and the glasses
stole
off.
that election in 2020. I think the 2024 election shows Democrats are not organized enough to steal anything. And it was ridiculous from the very beginning to say, well, we want to look into Fani Willis because she's prosecuting Donald Trump, who on a telephone conversation told the Secretary of State, can't you just fix this for me? Can't you just find me so many votes? Just a few, that's all I want. So, and how do we know that? Well, we know this. The vice chairman, or I don't know if he's the vice chairman, Senator Dalzell, whispers into the ear of the chairman. He's the one that signed a letter to the governor, says we, after the 2020 election, we need to call the General Assembly into session. Now, the Lieutenant Governor did this too, he was state senator at the time, so that we can override the vote of the people of Georgia. That we can select the electors ourselves rather than what the people voted upon. We also know, and we have here, that he felt so strongly about it that he, Brandon Beach, Burt Jones, Lieutenant Governor, the state senator attacked, signed an amicus brief for the Supreme Court in the Pennsylvania case saying they stole the election from us in Pennsylvania. This is not a legitimate legislative purpose. This is nothing but a charade. As Mazar said, we would have to be blind to see what all others see. One district attorney, did I hear, I went to one of the hearings, and when I asked I don't generally go to the Capitol except when we're burying dead governors, but this was of such interest, I went up there. I asked the trooper at the door, I says, I hear that they are investigating district attorneys. He said, yes, it's up on the 4th floor. Same room, I might point out, this fake electors met in 2020. I said, well, I am sure they're going to have that lady, Jackie, whatever her name is, down on the coast, who failed to prosecute her former employee who killed a young African-American man just for jogging through the neighborhood. I'm sure she'll be up there and being questioned. I'm sure of all of these cases that have been found where there have been convictions of those who were innocent. I am sure that they're going to bring these district attorneys up and question them and see what went wrong. And when I get up there, all they're talking about is sex. Well, Fani Willis had an affair with Nathan way. This is a pretext. We would be blind not to see what all of us see. This was nothing but singling out one person who's been duly elected in this circuit and duly re-elected in this circuit to embarrass. It's not for any legitimate legislative purpose, or they would have been subpoenaing all these other district attorneys that have done these things wrong. Only one person, and that is an improper purpose. Now, I'm going to reserve my balance for rebuttal, but I want to say one last thing. You need go no further than to say, listen, the General Assembly knows how to grant powers to committees, and they haven't done it. They haven't done it. The statute says they can grant the power, but it has to be granted by the General Assembly, and not by just one committee, not just by one house, not for just one purpose, to single somebody out to embarrass them. She's been embarrassed enough.
Thank you, sir.
How much time I got left, Judge?
10 minutes. 10 minutes.
10 minutes. Oh, that's good. I can give another 4 days.
Oh boy.
Back to you, Judge.
Let's see. So I guess I need to share my screen, is that the?
Yes.
Okay.
No, are we having a tech issue already?
And
We're gonna get a PowerPoint. I don't like PowerPoint.
Oh. How is it still? Okay. He's on his laptop, so you can still. Okay. Yeah. Thanks.
Here we go. All right.
Will you email me the PowerPoint?
Yes, Ron.
While they do this, like figuring out how to get the PowerPoint up, I did see, was it Michael Seaton or was it Kathy Roussan that put up? Remember what I said about how, like, the state can't just come out and blame the jury? There was a statement on the YSL verdict from the DA's office. So, yeah, it was Michael Seaton here. So, we'll catch up on that hearing while they get their tech stuff sorted out. A spokesperson for Fulton County DA just issued the following statement regarding today's verdict. We always respect the verdict of the jury. It's one sentence. They said the one thing that, you know, you can't just come out and fault the jury. What are you going to do? Fault the jury? They have one sentence. They have one sentence. That's it. Look at the comments. They scared to show their face right now. Fulton County DA is corrupted. Tails tucked. Tell them we said go F yourself. Oh man, this trial. Oh, and I guess we could play this too. There is a update from Doug. Who
This
says
will
it'll
be my
his
last
YSL.
YSL update. Jury deliberations, day 4, end of day. Not guilties across the board for Deamonte Kendrick. Not guilties, just as it should be. We have worked our ass off for this. This was done in partnership with, of course, Katie Hingerty and CashApp, but also my learned co-counsel, Mr. Kendrick, who we worked together throughout this. And that's not always the case. So Mr. Kendrick is going to get out of here. He is going to get on with his life. He is going to start making music again and see his family. And it's a wonderful, glorious day here in Fulton County. So from the last YSL update, at least on this trial, Doug Weinstein out.
And again, we'll get caught up on the hearing. I shared in the chat that Judicial Watch had a separate open orders case opened against Fani Willis in her official capacity as District Attorney of the Atlanta Judicial Circuit. And they motioned for a default judgment because Fani Willis never responded. Judge McBurney granted this. It was dated December 2nd, so yesterday at 1:36 p.m. So Fani Willis took an L on a different open records request case yesterday. And I wanted to highlight, I just unhighlighted it. Let's see. There was an italics. So Bernie spelled out all the things that the defendant could have done to avoid this default judgment. And then within italics here, it says, but defendant did none of that. She didn't do the basics that she could have done. She never moved to open default on any basis during the period when she could have opened default as a matter of right. She never paid costs. She never offered up a meritorious defense. Plaintiff is thus entitled to a judgment by default of every item and paragraph of the complaint were supported as if every item and paragraph of the complaint were supported by proper and sufficient evidence. So here this means that the plaintiff has established that defendant violated the ORA by failing to either turn over responsive records or else notify plaintiff of her decision to withhold some or all such records. So, like, this is just a quick look. This is separate from Ashley Merchant's request. This is separate from the hearing that we're looking at now, which is being led by the Senate Committee on Special Investigations. I just thought you guys might find that interesting. It's just a lot of L's here for this district attorney's office.
And if I may actually approach, I've got a notebook with a hard copy in it as well.
Oh, okay. So they've got a hard copy. All right, so it looks like he starts his argument here pretty shortly. So we'll just do here.
Good afternoon, Your Honor. I'm Josh Fani, along with my colleague, Vincent Russo from the Robbins firm, here on behalf of the 9 members of the State Senate Special Committee, the Special Committee itself, which is intervened, as the court knows, and also Chairman Cowser of the committee, and Senate President Pro Tem, member of the committee, Senator John F. Kennedy, who are here with us in the courtroom today. As Your Honor knows, this is an important point. It is in many ways a question of first impression, and looking at the specific authority of the State Senate. Personality shouldn't matter. Politics shouldn't matter. It is a question of constitutional law. And as the Supreme Court said in the Gonzalez case, just as district attorneys play a critical role in, quote, enforcing the law by prosecuting criminal cases, the General Assembly also plays a critical role in making the law. And 2 specific provisions of the state constitution authorize the General Assembly to impose duties on district attorneys by general law. Another says that it can provide the means of sanctioning district attorneys. That's Article 6, Section 8, paragraphs 1D and paragraph 2. In other words, the General Assembly has an express authority to look at and therefore legislate over issues of district attorneys' offices and their practices. And in that vein, it passed Senate Resolution 465, which looks at those practices. And we know that because the operative paragraph 6A says in the event the committee adopts any specific findings or recommendations that include suggestions for proposed legislation or changes in appropriations, the chairperson shall file a report of the same. The 6th whereas clause says the same thing, that they are looking at issues in order to determine if legislation or changes to appropriations are necessary. Whereas inquiry into these allegations is a key word. Senate Resolution 465 does not say that the petitioner has done or not done anything. It is that's why they're investigating. They're investigating and making an inquiry into these allegations that may show that existing state laws, including those establishing the processes for selecting, hiring, and compensating special assistant district attorneys, are inadequate. That is the constitutional prerogative of the Senate as set forth expressly. Now it's interesting, the petitioner and we actually agree on a lot. You're going to see there's a lot of the same quotes from cases. And the petitioner agrees on page 6 of his trial brief that the General Assembly has the authority to investigate. That's a given. So then the questions before the court are these. Does the state constitution prevent the state senate or the special committee from issuing enforceable subpoenas? Answer, no. Is the special committee prohibited from convening and acting after the legislature adjourns sine die? Answer again, no. And has the petitioner properly objected to portions of the subpoena ducis tecum? Answer once again, no. And on that point, Mr. Russo will address it, but I'll just say at the outset, none of those arguments apply to the witness testimony subpoena in terms of overbreadth. So now what is the petitioner's burden? And I know the court has competing petition and a competing application before it. We weren't sure which side would go, so that's why we're sitting over here. And if it pleases the court, if we do have any remaining time, if we would be afforded just a slight rebuttal, and I would be fine to give opposing counsel a rebuttal to that as well. But what is the petitioner's burden? Well, in some ways, this court has already examined that. In the order denying the emergency motion, which is tab 1 in your notebook, no need to turn to it, it's just there. It says this court has the power to refuse to take some action to compel compliance should the petitioner demonstrate that doing so would be inappropriate. But because of the nature and challenge of the petition, 3 other incredibly stout burdens of proof apply. The first is, and make no mistake, the petition is a facial challenge to Senate Resolution 465 and the authority of the state Senate, not just the committee, but the state Senate to issue subpoenas. How do we know that? Because it says in the petition, in the addendum clause, they're seeking to declare the subpoenas are void because they fall outside the statutory grants of the legislative subpoena power, and the committee cannot exercise legislative subpoena power. That's the authority provided in SR 465. So the court can't declare that without invalidating a portion of Senate Resolution 465. And we know in C it says they ask to declare the subpoenas are void because they violate the separation of powers clause of the Georgia Constitution, not the federal Constitution, the Georgia Constitution of 1983. It is a facial challenge. And as the Supreme Court of Georgia said, and this is in your notebook at tab 2, because we don't cite it in our brief, but I think it's a well enough established proposition. A facial challenge is, of course, the most difficult one to mount, because the challenger must establish that no set of circumstances exist under which the act would be valid, meaning the state Senate could never issue subpoenas and enforce them. But there's also a presumption of constitutionality that the petitioner has to overcome. That Senate Resolution 465 is constitutional, that the subpoenas are constitutional, passed pursuant to it, and a presumption of good faith. And the presumption of good faith looks both forward and backwards. We cite in our brief the McDowell versus Judges Officio decision from 1975 that says the law presumes public officials will follow the law in the exercise of their statutory duties. Meaning, when the district attorney testifies, the presumption at this point is that the members of the committee, 9 members, bipartisan, will act in good faith. When the documents are submitted, they will act in good faith. But also it looks backwards. We also cite in our brief the Irvin versus Woodruff decision from the Court of Appeals in 1971. There the court speaks in the past tense. The court will presume in favor of public officers in the absence of all proof to the contrary that they discharge their duty in compliance with the law. In other words, the Senate acted in good faith in passing Senate Resolution 465 and in issuing the subpoenas. So we look again at Senate Resolution 465. It's in your notebook in tab 3. I know the court has seen it. But it looks specifically at those issues identified. For example, lines 27 to 30. Inquiry into these allegations may show that existing state laws are inadequate to address various legal and fiscal issues raised. In the exercise of the Senate's authority on page 50, or lines 55 to 58, it is necessary to determine whether the alleged conduct of District Attorney Willis, if proven to be true in whole or in part, should be addressed by the enactment of new or amended laws, promise of change in state appropriations, or both. That's why she's been invited to testify. They're not taking the position on whether the district attorney has done right, has done wrong. The Court of Appeals has that question. The state Senate is entitled to investigate whether there is a need to reform practices, and it specifically identifies it. There's state money that flows to district attorneys' offices. That's the appropriation piece. And to the extent that there needs to be placed limitations on special assistant district attorneys, that's the legislative purpose. And the subpoenas are consistent with that, and there's 2 key points about the subpoenas. And this is why the issue is not just the authority of the committee. At the top it says, by the authority of the Georgia Senate. It is a question of the Senate's power and not just the committee's power. And there's 2. And again, the challenges on overbreadth are limited to the document or subpoena duties to them. So with that background, the first question before the court is, what is the state Senate's authority and the special committee's authority to issue subpoenas? Now, the petitioner says that that can be determined by looking at statutes. We suggest that that has it backwards. The question is not, is the state Senate authorized to issue the subpoenas? The question under the Georgia Constitution is there anything that prohibits the state Senate from issuing the subpoenas without the consent or some joint resolution of the House? Because I think the petitioner would agree if there was a bicameral decision that the House and Senate work together on it, the subpoenas would be enforceable. So the question really before the court is, does the state constitution prohibit the state Senate from issuing the subpoenas alone? The answer is no. We look at the constitutional text that both sides cite. Article 3, Section 3, Paragraph 1. The legislative power of the state shall be vested in a General Assembly, which shall consist of a Senate and a House of Representatives. Both have some aspects of legislative authority. In order to enact laws that go into the code, it has to pass both chambers. That is part of the legislative authority. But we know that both have some, at a minimum, just by...
Oops, sorry, opening a link.
reading the text of the Constitution. And we know that too from Article 3, Section 4, Paragraph 4, which is in your notebook. We compiled a series of constitutional provisions that we'll refer to, but I just didn't want to clutter up the slides. There it says, interim committees may be created pursuant to the authority of the General Assembly or of either House. Pursuant to the authority of the General Assembly or of either House. Thus, there is authority within the Houses acting alone. And we know from the Supreme Court of Georgia that the power of the General Assembly is, quote, also. The legislature is absolutely unrestricted in its power to legislate so long as it does not undertake to enact measures prohibited by the state or federal constitution. And where Senate Resolution 465 authorizes the issuance of subpoenas, that is the challenge and the attack that the petitioner makes in their petition. We also know, and we'll get to this on the Trump versus Mazars discussion, that the Senate has plenary power. Unlike the United States Congress, which has only delegated powers, the Georgia legislature is given full lawmaking powers. And that's why the question is, does the state constitution prohibit the state Senate from issuing subpoenas? Again, the answer is no. Part of the reason is we look at what the state constitution says about resolutions versus what it says about laws. And we know, and several of these are put in your notebook at tab 6, that all resolutions are not intended to be the same as laws. Several provisions of the state constitution say no bill or resolution intended to have the effect of law, ... That's Article 3, Section 5, Paragraph 12. There's others cited in our brief today. Senate Resolution 465 is not one of those. And if the Constitution said, for example, no resolution seeking to investigate and issue subpoenas shall be passed by one chamber, great, then it can't happen. Or if you look to footnote 4 on page 7 of their trial brief, they cite provisions in the state constitution where both houses are expressly required, passing apportionment or reapportionment legislation or adjourning, that you need both chambers. And that's the second point, that there is no bicameral requirement or action of both chambers required in resolutions. Article 3, Section 5, Paragraph 14 says the General Assembly may provide for the joint sponsorship. It doesn't have to. The concurrent resolution one, the same one cited by the petitioner themselves, says that separate periods of adjournment may be fixed by one or more such concurrent resolutions, meaning passing both chambers. Article 3, Section 9, Paragraph 6, R5B, also talks about a joint resolution and how it would be effective. The fact that it mentions joint resolutions and the fact that it says in here, here's where you need both chambers, it doesn't do that. The state constitution does not, with any investigative or subpoena power. In other words, Your Honor, they can't show you a provision of the state constitution to invalidate Senate Resolution 465 or the committee's action pursuant to it. That ends the inquiry. Petitioner says something else. They say that it violates the Georgia separation of powers provision, but they rely on that on the Trump versus Mazars case, which is about the federal constitution. But let's look at the state constitutional provision. It says that the legislative, judicial, and executive powers shall forever remain separate and distinct. But as Justice Ellington wrote in the Gonzalez case, that provision asks about powers, not departments. The reason the petitioner can't prevail on their separation of powers argument is what they say on page 6 of their trial brief. The legislature has the authority to investigate. That's the power that it is exercising. And it is not, in doing so, violating the separation of powers. And we know that because of the Boston case and the analysis there. That because the General Assembly has the authority to pass legislation governing the offices of district attorneys, it can't violate the separation of powers provision by acting pursuant to that authority. So there's no provision of the state constitution that supports that, and that's what their petition claims. Again, it's a violation of the state constitution. But let's just look at the Trump case and see why it doesn't apply. Starting with, Congress has no enumerated constitutional power. And because Congress must have an enumerated constitutional power to act, there's numerous restrictions placed on it. We know from the Bryan case that's not the same with the Georgia General Assembly. In fact, it's the opposite. But it's not just that. In the federal government, we have this idea of a unitary executive branch. And as the Supreme Court said in the Trump case, part of those limitations look at, quote, the unique position of the president. The president's unique constitutional position means that Congress may not look to him as a case study. This is a different case. This involves district attorneys in the executive branch joined by other state and local executive officers, and the Mazars case simply doesn't apply. So then they say, well, but Mazars says you need a valid legislative purpose. Your Honor, I looked at valid legislative purpose in the Georgia cases on Westlaw, and the only thing I could pull up was like equal protection analysis. Is there a rational basis behind this legislation? It's a federal standard that doesn't apply. In fact, it's created by federal case law. It's not applicable here in Georgia. It hasn't been applied. But also, if we're looking at what is the valid legislative purpose, our own Supreme Court, Hollowell v. Jove says, you look at the text of the resolution. And the text of the resolution, as we've shown, addresses issues that were covered broadly in the news, that are now again before the Court of Appeals, and that the State Senate and the General Assembly have expressed constitutional authority to legislate about. It cannot be said that looking into those issues, and we've documented in our briefs how looking at DA's offices has gone back to the code year of 2020. And back then it was the Democratic Party and their leaders pushing it. 2021, same thing, and then Republicans in the same session. 2022, it shifted for whatever reason. But the point is, the General Assembly has been looking at practices in prosecutors' offices for the past 5 years, if nothing else. That is a valid legislative purpose. Now, the last slide that the petitioner showed you, number 14, says, well, this is all done at the behest of the president-elect. Of course, we don't have evidence of that. And statements of legislators is inadmissible in determining anything one way or the other. That's the Jackson versus Dell decision. It also ignores there are 9 committee members, and they pointed out the acts of 1 or 2. It also ignores that if you look at, again, lines 55 to 58 of Senate Resolution 465, it focuses on practices, specifically practices of hiring special assistant district attorneys. The General Assembly has in the past looked at similar things. I think it was in 2016, roughly maybe 2014. They placed a limit on district attorneys hiring special assistant district attorneys on contingency, because you had cases where they would go out, file RICO against folks, keep a percentage there, and they stop it. This may be if legislation comes from it. Again, we're in the investigatory phase, not the legislative phase at this point. And so there is a valid legislative purpose, if that is even matters, which it doesn't. So what petitioner really collapses in their argument today has crystallized it, is they're making a statutory argument. Because they can't find anything in the state constitution that prohibits the Senate from doing this. And they cite 2 statutes. And effectively, as the court heard, their argument is, there's only 2 places where the code, not the Constitution, the code says the General Assembly can issue subpoenas, and that is limited to those 2 areas, period. And because it says General Assembly and not Senate, it's over. It has to be the General Assembly. That's in effect their argument. There's a couple problems with that. One, no one disputes that the Senate committee is not the Committee on Ethics, so we're not even looking at Title 28. Interestingly enough, Senate Resolution 465 cites to Code Section 451519 as part of its statutory authority. And that makes sense. If you look at the language about the General Assembly, the Senate, as we know, is part of the General Assembly, and it has constitutional power regardless. But the problem ultimately with and so you can analyze the statute and interpret it, which is that it is constitutional, and find no conflict, because it doesn't say that the Senate, that is the exclusive method. And I'll get to the Dean versus Bolt decision in a minute. But the problem with their statutory argument begins with the state constitution itself. They're asking this court to interpret that statute as limiting the authority of the General Assembly, which Georgia Constitution Article 3, Section 4, Paragraph 3 says courts cannot do. If they had a constitutional provision, one of those many that says it needs to pass both chambers or a joint resolution or something of that nature, then absolutely, that would be correct. But you can't just interpret a statute to limit the authority of the General Assembly. The next is Coggan versus Davey. And there, it was the Open and Records Act. That was a statute. And the court said not only that the General Assembly is not an agency, it also says we do not believe that it can be reasonably be argued that the House or Senate cannot pass an internal operating rule for its own procedures that is in conflict with a statute formally enacted. Thus, even if there was a conflict between the Senate acting in Senate Resolution 465 and Code Section 4515-19, that's okay, because the Senate has its own authority and procedures to issue enforceable subpoenas. So then, given that, what they're really arguing is because Senate Resolution 4515-19 says this is the place for subpoenas, and it doesn't say state Senate, it must mean that the drafters did not mean the state Senate. That's the negative implication of statutory construction. I've tried to use it several times. Sometimes it works, sometimes it doesn't. And the courts have said that it has to be applied with great caution, since its application depends so much on the context. And interestingly enough, the city of Douglasville case, if you go through the things it cites, it ends up in the same place as the authority of the petitioners. They both go to the Scalia book where that is taken from. And so the context here in dealing with presumptions of constitutionality, the plenary power of the General Assembly, means that the negative implication canon is inappropriate, because this is not like the United States Congress. It is presumed the General Assembly can act unless the Constitution says otherwise. And what the petitioner's statutory argument is asking the court to do is to invalidate Senate Resolution 465 on the basis that it violates the statute. But if the Senate has the authority to issue subpoenas, which we've shown it does, then the statute cannot invalidate it. Or phrased better, if the Senate is not prohibited from issuing subpoenas pursuant to its investigative authority, then a statute cannot do it. So they then, in their slide 2 of their presentation, cite the Dean versus Bolton decision from 1975. And interestingly enough, we again quote the same provision. The court said the General Assembly may, by statute, place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against investigations. So the problem with relying on Dean is twofold for the petitioner. Number one, nothing in 4515-19, using the word of the Dean versus Bolton decision, places limitations on the state Senate from acting. It says the General Assembly can do this, but it doesn't say it's exclusive. The petitioners are asking you to read that into the statute, which these 3 pieces of authority up here say you can't do. The second issue with Dean versus Bolton is that it's talking about the power of investigations, which is conceded here the Senate has. It doesn't address subpoenas and the issuing of subpoenas. And to read Dean versus Bolton as saying anything more than that would be imposing dicta on the state constitution. And the City of Sandy Springs case we cite in our brief explains why that would be the problem. So their statutory argument doesn't overcome the Senate's authority. The last is, and this was more in the briefing, that the state Senate did not effectively delegate authority to the state or to the committee. I'll be very brief here. 2 provisions kind of dismiss of this pretty quickly. One, the state constitution authorizes interim committees, which the special committee is. 2, Senate Resolution 465 is an act of the state Senate, expressly delegates authority. But 3, in some ways, this is a bit of a distraction because, again, going back to the subpoenas themselves, they are issued by authority of the Georgia Senate. Again, make no mistake, Your Honor, the question before the court is Senate Resolution 465 itself constitutional? And does the Constitution prohibit the state Senate from issuing subpoenas? The answer to 1 is yes, it is constitutional. They've not shown otherwise. And the answer to 2 is no. Nothing prohibits the Senate from issuing the subpoenas. And with that, I'll hand it over to my colleague, Mr. Russo, who will take the remaining couple arguments, and if we have any time that we can serve for a rebuttal, if that please the court.
That's fine. I have one quick question.
Yes,
Is that very last page, I just want to make sure I'm not supposed to be looking at a different resolution. Is that just the inverse of numbers? If you go back.
Okay.
I just want to be sure I'm writing down right. See at the very bottom says SR
456.
Yeah, it's supposed to be 465, right? Okay.
Yes,
I just want to make sure.
at the top I had it right, at the bottom I caffeine wore off. So
I just want to make sure I wasn't looking at 456 as well. Okay.
Yep, no, you're right.
Okay. Thank you.
Thank you.
Good afternoon, Your Honor. I'll be addressing petitioner's arguments regarding the special committee's authority under Senate Resolution 465 and whether it terminated at the end of the regular session of the General Assembly, and also whether the subpoenas are overbroad and seek privileged information. Now, as Mr. Fani just finished discussing, there's not much question regarding whether the Senate committee has the power to issue subpoenas and to conduct legislative investigations for the purpose of developing public policy. And because the petitioner cannot satisfy her burdens on those issues, the petitioner has 2 fallback arguments that go to the timing of the subpoenas and the scope of the subpoenas. Petitioner's argument regarding the special committee's authority to conduct business after sine die fails for 3 reasons. First, and unlike the cases the petitioner does rely on in her briefing, the Georgia Constitution expressly authorizes the Senate to create interim committees and establish their own rules. Article 3, Section 4, Paragraph 4 of the Constitution states that each committee shall determine its rules of procedure and may provide for its employees. Interim committees may be created by or pursuant to the authority of the General Assembly or of either house. So, the plain language of the Constitution gives the Senate and the House the authority to create interim committees. Petitioner does not cite any legal authority, of course, in Georgia to support her argument that the special committee is not an interim committee. Instead, petitioner relies on cases from other jurisdictions and from federal courts regarding the state constitutions in those jurisdictions or the federal constitution. But those cases are just similarly not applicable. Those cases do not involve interim committees that a chamber is authorized to create pursuant to a constitutional provision. And this is an important distinction. Petitioner's counsel discussed the Anderson case earlier, it's an interesting case that dates back nearly 200 years, where the Supreme Court, recognized for the first time that Congress has inherent authority to fine an individual in contempt for violating a subpoena. That case, though, is not applicable. Again, the U.S. Constitution does not allow for interim committees like the Georgia Constitution does. And one quote out of that case that I think is relevant here, and what Petitioner seems to hinge her argument on, is where the Supreme Court states, although the legislative power continues perpetually, the legislative body ceases to exist on the moment of its adjournment or periodical dissolution. Sine die is the adjournment of a regular session or of a session of the General Assembly. But the state constitution provides that the General Assembly's term is for 2 years. So the General Assembly doesn't cease to exist when its regular session ends. Of course, there are special sessions many times where the General Assembly was called back into session. But the session, the term of the General Assembly is 2 years. It's not, doesn't cease to exist at the time of sine die when it adjourns from its regular session. Now, Your Honor, the interim committees, there's a question. What do the interim committees have? Is it an interim committee that exists while the legislature has adjourned overnight and comes back the next day, or is it an interim committee that exists between sessions? And I would offer that it has to mean that it is an interim committee that exists between sessions. Otherwise, we would create an absurd result, which would mean that all of these committees that meet while the General Assembly is not in session are unconstitutional. And that's simply just not the case, Your Honor. Second, Senate Resolution 465 does not confine the special committee to meeting only during the session of the General Assembly. 465 gives the special committee broad authority to decide when to conduct its meetings, in fact. And let's take a look at what Senate Resolution 465 does say. First, meetings. And this is in tab 3 in your binder, Your Honor. Meetings. The special committee is authorized to meet when the committee deems it necessary and convenient to enable it to exercise fully and effectively its powers, perform its duties, and accomplish the objectives and purposes of the resolution. The resolution doesn't say you can't meet outside. The resolution doesn't outside of session. The resolution doesn't say you can meet, you can't conduct official business. Of course, the Constitution that allows these interim committees to be created also does not put some restriction on what type of business can be conducted by an interim committee. Can they meet? If they can't vote on something, can they not meet? What is official action? And that's simply the reality, Your Honor, is that an interim committee under the Constitution is allowed. And at that point, there are no restrictions under the Constitution for what it can do. Now, the resolution, petitioner in the briefing references several Senate rules that pertain to standing committees. This is not a standing committee. The Senate rules list all the standing committees that exist, and that's in Senate Rule 2-1.3. And this is not a standing committee. Petitioner does not cite a single rule of the Senate's that prohibits special committees from conducting business after sine die. And of course, the resolution is that authorization for the special committee to conduct its business when it deems it necessary and convenient for it to conduct its business. Again, this is consistent with the interim committee powers under the Constitution. Interestingly, Your Honor, the membership of the special committee, it's appointed pursuant to the Senate Committee on Assignments. And the Senate Committee on Assignments under Rule 2-1.1 is authorized to meet and take action after adjournment sine die and prior to the convening of the next session. But what this could mean under petitioner's argument is that the Committee on Assignments could meet after sine die, appoint the members to the special committee, but then those members could never actually do anything. It would effectively make the resolution meaningless because the committee could not act. Third, to the extent there's still a question lingering regarding whether the special committee was authorized to issue the subpoenas, the Georgia courts adhere to the well-settled principle that the acts of public officers are presumed to be constitutional and in compliance with the law. And this goes back nearly 175 years to Doe v. Peoples, which is at 1 Georgia 1 in 1846. And the court found that it will presume in favor of public officers in the absence of all proof of the contrary, to the contrary, that they discharge their duties in compliance with the law. The petitioner cannot overcome this presumption. There's no proof that the special committee acted in any manner that's contrary to the law, to the Constitution. It's an interim committee. Thus, at minimum, Your Honor, we think that the court should adhere to this well-settled presumption and presume that the subpoenas were properly issued because there's an absence of proof to the contrary. Moving to petitioner's second fallback argument, that the subpoenas are overbroad and seek privileged information. First, as my colleague, Mr. Fani, pointed out, petitioner does not address the witness subpoenas whatsoever. There's no argument that the witness subpoenas are overbroad or anything to that effect. So that's done. And in regard to the document subpoena, the problem here is that the petitioner never specifies, well, until today we heard 2 document requests that the 13 that she contends are overbroad. But the petitioner never specifies which requests are overbroad and why, and which ones are not, or which documents she contends are privileged. The subpoena is at tab 5 in your binder, but looking at the slide here, we have 13 requests. These requests are not simply asking the petitioner to produce everything or conduct any unreasonable effort to locate documents. They seek documents related to the hiring of the Special Assistant District Attorney. They seek documents related to the existence of conflicts in the hiring of the Special Assistant District Attorney, payments and other things of value to and from the Special Assistant District Attorney, communications with the Special District Attorney, document requests received by the petitioner or her office from the U.S. House Committee on the Judiciary, communications with the White House, the Department of Justice, the United States Senate, the United States House of Representatives, pertaining to election investigations and prosecutions, the use of federal grant funds and policies that her office implemented in regard to the receipt and use of those funds, various court filings, and documents related to employment action taken against a witness to allege the misuse of public funds by the petitioner's office. First, the only case that the petitioner cites in support of her argument that the subpoena seek privileged information must be quashed is the Holbrook versus State case. But that case involved a notice to produce in a criminal case. This is, of course, not a criminal case. The subpoenas are issued in a legislative proceeding. Second, the attorney-client privilege clearly could not attach to several of these document requests, such as the district attorney's communications with the White House or the Department of Justice related to the 2020 election investigation and prosecution, and other third-party communications. Those communications were not made for the purpose of giving or getting legal advice, so they're not going to be privileged. Similarly, subpoena documents related to payments to and from the Special Assistant Attorney General, Special Assistant District Attorney, and other things of value that they may have exchanged. Cell phone records, documents related to that individual's hiring, federal grant funds. Those are not, those could not be attorney-client privilege documents under any scenario. So what documents does the petitioner contend are privileged? Problem again, we don't have a privilege law. The petitioner did not respond to the subpoenas. So we do not know. But to the extent privilege even applies to any of these requests, that privilege is narrowly construed. Again, Your Honor, because we do not know what petitioner contends are privileged, because she did not respond to the subpoena, we don't have the ability to even assess whether they are privileged or not. Now, today we heard about the work product doctrine, which is also a creature of the Civil Practice Act. And there, Your Honor, and as you are aware, when there is a work product doctrine question, the court looks at the documents in camera. But we don't have documents. There are no documents to review. And again, that gets back to the problem for a petitioner's non-responsiveness. Now, there's a time and place for a petitioner to assert her privilege if she believes one applies. And that is at the hearing, when she's testifying, and in response to the documents subpoena. Third, Your Honor, the petitioner in the briefing makes very conclusory statements about executive privilege. We didn't hear about that today, but and the briefing does not explain why she believes executive privilege is applicable to her or to the legislative subpoena. Neither the Georgia Supreme Court nor the United States Supreme Court have ever directly addressed the issue of executive privilege in the context of a legislative investigation. The Mazars case, while it involved congressional subpoena for presidential records, that case did not involve an assertion of executive privilege. And the court stated in that case, the president did not, however, resist the subpoenas by arguing that any of the requested records were protected by executive privilege. And that's at 591 U.S. at page 857. So what would be the basis for claiming executive privilege by a local district attorney in these circumstances? We just don't know, because the petitioner didn't ever address it other than to make passing conclusory arguments. Finally, Your Honor, as to the breadth of the subpoena for documents, petitioner does not identify a standard for determining whether a request is overly broad in this context of a legislative subpoena. Petitioner simply states that it would require some work to locate documents. So what is the standard for assessing the breadth of a legislative subpoena in Georgia? The document requests are tailored to the investigative purpose of the special committee. We can look at the request and look at the resolution and see that. Although the Civil Practice Act does not apply to the special committee's proceeding, it may provide some guidance regarding whether the subpoena is overbroad. As this court knows, relevance in the discovery context in civil litigation is construed very broadly. Courts should and ordinarily do interpret relevant broadly to mean matter that is relevant to anything that is or may become an issue in litigation. Here, the documents that are requested are in an analogous manner relevant to the special committee's purpose under Senate Resolution 465 and the public policy that may be created as a result thereof. Additionally, Your Honor, we've talked a little bit about the Gonzalez case already, but that case does make clear that the petitioner's office is subject to the Open Records Act, which also requires parties objecting to a request to notify the requester of the specific legal authority exempting the requested record or records from disclosure. While the Open Records Act does not control here, it can provide some guidance. There are exemptions under the Open Records Act, but those exemptions are required to be construed narrowly so as to exclude from disclosure only that portion of a public record to which an exclusion is directly applicable, and that's in OCGA 50-18-72B. Thus, Your Honor, even if you construe a legislative subpoena to be the equivalent to an open records request, petitioner cannot assert a blanket exemption over all of the documents and refuse to produce any of them. Again, Your Honor, the problem for petitioner is that she failed to respond to the subpoenas and failed to timely file a motion to quash. She's effectively waived these objections by not responding to the subpoenas. The petitioner cannot hide behind boilerplate discovery objections and claims of privilege to hinder the legislative branch from conducting its duties under the Constitution and considering important public policy changes. The Supreme Court in Commonwealth Investment Company versus Fry in 1963 stated that the legislature and not the courts are empowered by the Constitution to decide public policy and to implement that policy by enacting laws. And the courts are bound to follow such laws as constitutional. Here, what the petitioner is asking this court to do is to disregard the Constitution. The language in the Constitution allows interim committees to exist. The language in the Senate Resolution in 465 that outlines the scope of that committee's duties. And to ignore that would lead to an absurd result, Your Honor, that limits the legislature's plenary powers, and that is wrong. So, Your Honor, for these reasons, the application should be granted and the petitioner's petition should be denied. If we have remaining time left, we'll reserve this for our survey.
All right, thank you.
Oh my gosh, there's going to be more.
And you do have
We're not done yet. Let's do a quick break and 1.25 speed for these rebuttals here. There's going to be a rebuttal and then a rebuttal. Oh boy. Some of this gets dreary because again, it's a bench, it's for a judge. And these are all attorneys, but you know, these are representatives representing the Special Senate Committee over here, and then Roy Barnes is representing DA Fani Willis. So it's a different environment than a trial where you want to like keep the jurors engaged, and it's a little bit of a struggle here. So we'll take a quick break. We'll up the speed to get through it with a little bit more oomph. Big thank you here to Chris Peterson, showing love. Love your channel cat and her channel cat, and has been a member for 2 months. So thank you so much, Chris. Glad to have you here. Shannon, and I think this is important to note here, especially since we didn't get it before this all started. But Shannon says, Judge Shakira Ingram, I know her, she's wonderful. So this is great insight to have. I can't get a read on her, so I'm curious to see what she says and why. So Judge McBurney just granted a default judgment because Fani Willis didn't respond, didn't feel like it was necessary to respond to a request for open records by Judicial Watch. She didn't respond. Judge McBurney was like, you didn't even try, so I'm just going to grant this default judgment that petitioner is asking for. Right? So I'm interested in seeing what Ms. Ingram does here. Thank you for the insight here, Shannon. Harp City had me dying. The whole chat started playing like how words are pronounced in different areas. I saw a little bit of, you know, country versus southern accent and how they're different, even though they might be called the same thing sometimes. Harp City says certain words are meant to be said with a southern drawl, like evidence. That's my best pronunciation imitation there. I love to hear it. That was a good time, I think, when Roy Barnes he did his impression of Bill Cowsert. 403 is ready. Let's send some well wishes to 403 is ready. Missed you earlier today during verdict read. Hello, Kat and gang. I've been in the hospital. I hope you're doing well. Definitely missed you earlier. You've been around for so much of this trial, and sad you weren't with us earlier in the morning, but glad you're here now. Lou Rose says, let's see. I had 2 messages here. I pinned this. Thank you so much for the kind words. Kat, thank you for your coverage of the YSL trial. I've been a silent member for a while. I'm looking forward to joining you in whatever trial or other things you cover. This is so nice. Lou Rose also dropped 10 gifted memberships in the chat. I saw you guys saying thank you, but if you want to show some love again, that'd be super awesome. Big thank you here to Lou Rose. I'm glad to have you here, and we always love, except for Viverito, we love everybody else that lurks in the bushes here. So big shout out to you. And also Lou Rose with another 2 saying thanks for making it make sense. Hey, when something doesn't make sense, we got to stop, pause, try to figure it out. Of course, of course. So always something we try to do here. The chat comes in with assists all the time. So always glad to have you guys here with us. JC also missed the whole morning. Crazy morning to miss, you guys. Not gonna lie. Crazy morning to miss of all mornings, right? And a few of you guys like tuned in right after the verdict and the sentencing. But glad you guys got to catch up now. I know that feeling of like missing things right in the moment. Also want to say thank you to Courtney, who sent 5 over on CashApp, who said thank you for the coverage. Oh, this is Corky. Good to see you. Put a face to a name. So thank you to Corky. Coffee on me. Heck yeah. Gonna do some caffeine after this. Especially this is making me feel more tired than I think I am. And thank you to Ralph. Big thank you to Ralph. 50 on Cash App says, thanks for your insight on the case. Best wishes. So that's super generous. Thank you so much, Ralph. And we also still have, let's do a flash gifting, you guys, and then we'll hit the play button again. We'll finish this up. Can you guys pick a gift real quick? Now, Sapphire Ridge News sent 20 to chip in towards an angel tree gift. This is the wish list. What do you guys want to order? I'm willing to double up and match, so let's do 40. Let's do $40 here. Putting the wish list in the chat as well in case you guys want to explore it on your own. This is for a nonprofit that helps foster children, 900 kids in Brevard County here in Florida. They do an angel tree program to make sure the kids can get gifts on Christmas. But what do you guys, let's pick something. Let's do a flash order here. Big thanks again. This is going to be sponsored by Sapphire Ridge News. Make sure you're checking out Sapphire Ridge News. Lots of content on Fulton County, YSL stuff, good rants and bants. Love to hang out over there. You'll see familiar faces in the chat. Okay, guys. So I knew you guys are going to say the soccer ball. We actually already sent, there was an option to order in bulk, and it's not counted here. But we did the 12. We ordered 12. And it didn't count it because I guess it's going off of, we went outside of the constraints of how the wish list is sent, but it is being delivered to the organization. So just so you know, we've already sent 12 soccer balls. We can send another one though. We can send another one for good measure. There was a glowworm. You guys want to do the glowworm? And a leapfrog. Hold on, let me start scrolling. Where was the glowworm? Was this the leapfrog that you wanted to do, LaDonna? This one? Let's see. Is this the glowworm? Oh, this is the glowworm. Okay, we'll get a glowworm in here. So we'll do those for now. We might come revisit this again. Again, the way I've been doing this, since every time I go to my cart to check out, it pulls up a lot of the addresses that I've sent to before. Let me... Friends of Children of Brevard. And we'll check out. Guys, by the way, if you do feel inclined to order something from this wish list on your own, you don't need to do gift wrap. They keep all the gifts unwrapped to make sure, I guess you want to make sure you can see everything that's inside of a package. Yeah, you don't need to do the gift wrapped option. And delivery by December 7th. Let's see. Yes, because they're going to get their little warehouse together to sort everything starting on December 9th. So this will arrive in time. Let's place this order. And there you go. So thank you to Sapphire Ridge News and the Cat Not Williams chat, everyone that's watching and supporting. We're sending a soccer ball, a glowworm, and a leapfrog, in addition to everything else that you guys have so generously sent. I've seen some of these items fall off the list entirely because they've been bought out, and I have no doubt in my mind it's because you guys are out there supporting their efforts here, which is just so awesome. So, oh, what the F? You're so smart. Good point. And you know, I've looked at that option. I've seen it say right there that you've bought this somewhere else. Yeah, let me do that. I don't know if I can up it. They're gonna get so many soccer balls. They want 2 more, so we're gonna do that. We're gonna mark that, and we'll get to playing this again. So they're gonna get what? They asked for 6, and I think we sent 18 total. It'll be 18 total. So, heck yeah, shout out to Destined to Be in the chat. Destined to Be ordered some items, and they're going to arrive today. I'm loving my emails getting filled every time, even though I think I did 5 or 6 total orders the day we did the shopping stream together on Saturday. The way Amazon's processing them, it's separating them into more orders than just those 5 or 6. And every time one individual item is shipping, I'm getting the notification. And it's really nice to see. Ordinarily, that would annoy me, but because it's heck yeah, this is going to get there in time for them to get to these kids. Every single one is very, very good to see. So thank you again. Shout out to Destined to Be for sending some gifts to these kids. And Peaches, I've been in the foster system, and thank you, Kat, for doing this. And that's the thing, right? I don't want any kid to go the week after Christmas ends, they go back to school, and all the kids are bragging about the stuff they got, and some other kid just sits there why not me? Why am I left out of this, right? So big thank you to everyone for doing this. But we'll hit the play button here. Thank you guys for taking this detour and supporting that little effort there. Super fun.
Judge, I once said that I was in high school before I knew that the South had lost the Civil War. It was the way everybody talked that I thought they had won. I wonder how long we will go on with the 2020 election. Is that going to last another 150 years where everybody's complaining about something? Let me just reply, and I won't tarry with you long. All of what they have said is the General Assembly can do this. The General Assembly has the authority. Sure they do. But it has to be the General Assembly and not just some one body of the General Assembly. Let's just use a little common sense. Does the General Assembly have the right to issue a subpoena by a proper resolution? They do. If it's signed by the governor, it has to have the force and effect of law. You know, the first thing I do when I'm researching something, I go to the title. So you go to Title 45, which deals with subpoenas. And it says, in addition to the power conferred on the Attorney General, the governor or the General Assembly is authorized to likewise make investigations, issue subpoenas. Not just the Senate or some committee of the Senate. Now, let me, Mr. Fani, who's a good lawyer, his daddy was one of our oral surgeons in Cobb County. Good fellow. He was a Democrat, too. He slipped me a little contribution every once in a while. I don't know what happened to Josh. But in any regard, he's had a tough, what he's trying to say is, well, we can do anything. One body of the General Assembly can act on behalf of the General Assembly. That is not what the Constitution says. The Constitution says the General Assembly shall be composed of a Senate and the House of Representatives. It is not one body. And then he says, well, the Constitution says we can investigate. You can investigate till the cows come home. You just can't subpoena anybody. And there's a reason for that. There's a reason when we passed the statute. There's a reason that we didn't put in the Constitution. They shall investigate and shall have the right to subpoena or compulsory service. There was a reason. And you know what the reason was? Because from time to time, one body of the General Assembly could go crazy and could do something. And my brother says, well, all we're doing is just investigating the district attorney's office, all of the district attorneys, and how they hire special assistants. Let's look at what they said in the resolution. Whereas it has come to the attention of the Georgia Senate through public reports and court filings that Fani Willis, district attorney of the Atlanta Judicial Circuit, which comprises Fulton County, has been accused of various forms of misconduct relating to the prosecutions of cases related to the 2020 presidential election. If that is, this is not saying let's go investigate how district attorneys operate so we know how to appropriate. This is singling out one person in one case, the 2020 presidential election. And one district attorney is not an investigation as to the general authority and the general appropriation and how in the Okmulgee circuit or in the Glenn circuit, how they're expending money, singles out one person in one case. And as the Supreme Court said in Trump and Mazars, we would be blind not to see what all others see. This is nothing but seeking to embarrass a district attorney, one district attorney, not all of them, one district attorney. And it is nothing but to determine what the case was against Donald Trump. Now, I'll leave it to another judge and another court to say where he can be prosecuted under a state statute or under a state law while he's president. People of the United States, in their wisdom, has decided to elect him as president. But that does not mean that they should be allowed a vendetta against one district attorney to embarrass her when she's already been embarrassed.
Okay. Mr. Belafonte?
Thank you, Your Honor. Petitioner argues again that it has to be the General Assembly that issues subpoenas and not one chamber. The question it begs again is why? Where in the state constitution does it limit the Senate's investigative authority to acting bicamerally? We know that the state constitution has provisions addressing when a resolution needs to pass both chambers. And what we heard today, just now, is the only way a subpoena can be effective is if it passes both chambers and is signed by the governor. Now, Your Honor, I used to work for a governor. I know Governor Barnes was the governor. But if the General Assembly wanted to investigate the governor and it needed to issue subpoenas to do so, but it needs the governor's permission, that's the limitation that they're asking the court to adopt. And that's, frankly, it's again putting the statutes as controlling the Constitution, when it is the Senate's constitutional authority, which is not limited by the Constitution and is not limited by the statutes. And even the language of Dean versus Bolton makes that clear because it says that the General Assembly passing a law can limit its own authority. We would disagree with that based on what the Constitution says. But 45-15-19 is not a limitation. It has to be read into the statute as a limitation. And we've seen why that method of statutory construction it would be inappropriate in this case. The Bryan case makes clear that the General Assembly has the authority to act unless prohibited from doing so. And that's why the Trump cases and the Mazar cases don't matter. So the last argument that collapses to is challenging the intent of the Senate in looking at these issues. But we see from Senate Resolution 465 that it is looking at practices. And it cannot be said that those practices are not of public import. They've been described as containing a significant appearance of impropriety that infects the current structure of the prosecution team, and a perceived conflict in the reasonable eyes of the public that threatens the confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and moral focus of our already weakest branch of government. That's not the words of the state Senate. That's not the words of any particular party within the state Senate or any member of the special committee. That's the judicial opinion issued from this circuit on these practices. It cannot be said that the Senate lacks the authority to look into these issues to determine if legislation is needed. And that's exactly what Senate Resolution 465 does. That is exactly what the Senate committee is seeking to do, to investigate, to see if there's a statutory need, as there was in 2014-ish with the contingency type basis. It has the authority to investigate those issues. The district attorney has the ability to come explain her position. But what she can't do is say that the Senate itself lacks the authority to issue the subpoenas. And this court has the authority, as it recognized in its order denying the injunction, to issue an order enforcing those subpoenas. And that's what we've asked the court to do. In your notebook, we hopefully not taken as presumptuous, but there's a proposed order in the pocket of the notebook. We'd be happy to email that to the court and opposing counsel as well as in theirs. But what it asks for as relief is that the documents be produced. And if there is an issue of privilege, that a privilege law be created, similar to civil discovery or even the Open Records Act. We've asked that if the Senate committee reconvenes, that the district attorney be required to appear, and they can work out a time. What we suggest in the proposed order is not later than some early day in January or last bit of December. And she can then appear, testify, and allow the Senate to determine if going into this next session, what is described as threatening the public confidence in the legal system itself requires legislation or not. That's the open question, but that's for the state Senate to decide when it convenes again. Unless there are any questions, Your Honor, I'll rest.
Thank you.
Just a minute or two left.
You do?
Rebuttal.
I'll say the last word. You heard again. The Constitution does not grant, let's make very careful. The Constitution does not grant either the General Assembly or the House or the Senate acting alone the right to subpoena. That would have to be created by statute. And the statute says that it must be the action of the General Assembly. Could they not have to have a signature of the governor? Probably. I mean, this is new ground. The General Assembly has been in existence for over 200 years. Well, a good ways over 200 years. And no one body of the General Assembly has ever tried to do this. Now, the last word I'll say to you is this. Listen, it's very clear. What they're trying to say is, no, there's no authority to do this. This is just implied. It's just something that we can bring in, something we can reach out there and have. What other implied powers might they have? Implied powers, as the Supreme Court of Georgia says, should be strictly construed. Do they have the right to, I was a member of the state Senate at one time, say, we want to investigate former members of the state Senate for what they've been doing since they left, because it might bring disrepute upon us now. Listen, this is an important issue. Can you allow one? The beauty of our system is it's balance, checks and balance. The Senate can do certain
How are we
things.
supposed to balance
the House
what we
can
can't
do
get
certain
access
things.
to?
They can discipline their own members. They can provide when the committee meets. They can do all. They can investigate. But when they go outside that door, that is the Senate, they have to have specific authority to do so.
Right up there.
And to bring somebody, drag them in by compulsory service. We think the law is clear. The General Assembly knows how to create the power of the subpoena, but it's the General Assembly and not just the House of the General Assembly, either the House or the Senate, that must act. Thank you.
Thank you.
All right, there we go.
Thank you all. As soon as I make a decision, I'll get an order. Fine.
Would you like a proposed order date?
If they've given one, I'd love to get one. From
We'll
the
get
town.
one.
Okay.
We'll send you one.
All right, thank you so much.
Thank you, Dave.
Send the proposed orders. Let's see.
All right, can I get those PowerPoints?
Yes, sir.
Yes.
All right, they just do a little cleanup here. I don't know if they say anything
Thank you so
important.
much.
got like 4 minutes here. They're probably just like cleaning up their stuff, but we'll see. I think we might get one today. Oh. Oh, okay, then it's just frozen for like 5 minutes, according to the scrub. So that was it. Yeah. And I mean, I really think, and again, this is the difference between a judge and a jury. A judge might not just be fixated on the last word that's said. I think that's more important with the jury. But that final rebuttal here from Roy Barnes, I think goes against his argument. This is supposed to be a balance, but at the same time, you're trying to block transparency. So that punchline you have at the end kind of supports what the Senate committee, the issue the Senate committee is raising, right? And I don't think the final last word is that punchy for a judge with a bench decision, but still. Either way, I did enjoy, it was entertaining to listen to him speak. Doesn't sway me. I think we need transparency. I think that there is enough case law that supports the arguments here in favor of, Fani should have replied to the subpoena. She can't just ignore it. And yeah, as soon as there is an order that comes down, we can talk about it. Again, I'm going to link to, there was a separate order in a different open records case filed by Tom Fitton and Judicial Watch. Judge McBurney granted a motion for a default judgment yesterday against Fani Willis in response to that request. Judge McBurney. Let me get the link again. I tweeted it, but I've like retweeted so much today because of the YSL verdict. Where is it? Oh my god, sorry to everyone if I like flooded your Twitter feeds. I can't even go through my own today. Okay, wait, here it is. So I'm going to link to this tweet here from Judicial Watch that summarizes it. It is a separate case from the hearing that we're watching now. It's a different open records case that Fani took an L on. But if you go here to the tweet, you can get the summary, and on their website, they link to the 6-page order from Judge McBurney. We read a little bit of it. He italicized some stuff that I think was some good shade. Like, the DA didn't even try to respond to this or come up with a meritorious argument. So we'll see what Judge Ingram does in this case, which is a separate case, but it does involve an overlap of an issue, right? Your failure to respond to requests, failure to respond to a subpoena. So there's that. Want to give also a big shout out to Allie B. Saw lots of love for Allie in the chat. Allie B says, thank you for all you do. Kat, I'm so glad I found your channel. You are brilliant and also have an amazing heart, which is the best combo. Your chat is also very wholesome and it just feels safe here. I love you all, slimes. Slat, heck yeah. So big thank you. This is super generous. I'm so glad that you like being here and glad that you're here. I think the chat was showing you the same love. Glad that you're here as well. So guys, I think, what a week. We're on Tuesday. What a week. Whitaker says next trial should be 90 days, not 2 years for the remaining YSL defendants. There may be a disorganization with the discovery that should have been turned over. Looks like we're going to have the same mess. Maybe not. If they just let Abate do it himself, maybe it'll be a different approach to the case. We have huge not guilty verdicts for Deamonte Kendrick and Shannon Stillwell. Shannon Stillwell does have a guilty on a possession of a firearm by a convicted felon charge. That again was one of the counts that was reduced. It was missing an element. It was charged under 16-11-133. Whitaker, in granting directed verdicts that I'm going to partially grant, we're going to reduce that to 16-11-131. Which is good because I think that reduced the maximum sentence available. And because of that recidivist notice, Whitaker was constrained to go for the higher. She had to sentence to the higher number of years. But under 131, I think that gave her the wiggle room to probate what she probated. So, and then let's see. What else did we go through today? separately, like this whole martial law in South Korea, guys, I don't really know much about geopolitics. I can't speak on it, but I do like to watch it. Thanks, chat, for reminding me that both Legal Vices and Legal Mindset are over in South Korea, so they are YouTube creators as well. It'll be interesting to see if they talk about it. And also had a recommendation. I gotta find it again. Agenda. Who said it? I think it might have been Ali B. I thought I pinned it, and now I don't see it in my pinned stars. Agenda something for something to watch for South Korean news, because that sounds crazy. That sounds like a big old crazy. Agenda Free TV. Thank you, Ali B. Cool beans. Because I do really like to learn about, like, I'm not going to do a stream talking about what's going on because I would not be equipped to talk about it. But when something crazy is happening, I do like to go learn about it. So thank you for pointing me to a place to go. Hitting that subscribe before I lose this comment. Okay, and Mindset's commenting on X. Let's get, link here. Thank you, Mama Ro. Cool beans, because he's actually living over there, so. Oh, okay. It's already over. Long story short, martial law already over. Wrapped in under 2 hours, voted down by Parliament. Likely to see Yoon impeached or step down in the near future. Cool beans. Look at that. There you go. So yeah, I had no idea what was going on, and now I have a huge update here, all things considered. So thanks, Mama Ro. Let's see. Is there mixed chick? Is TLA doing something? Because I can like shout it out. I'm trying to look through the comment to catch the context. But, I'm back up to my one piece of hair comment here. So is there like a raffle event going on? Yeah, cool beans is part of my, I don't even know why it's part of my vocabulary, but certainly just ingrained up in there. So, and Mama Ro, so we're going to be wrapping it up, but Dennis Byron's interviewing another juror, so you guys might want to check that out. And I do think I had it right? Hip Hop Inquirer. Let me get the YouTube channel. Although I think he streams on X too. That's why I never really like looked for him on YouTube. Wait, oh no, he does have 2 channels. Okay, I get so confused when people have 2 channels. Okay, so I'm gonna link to the channel where he did the stream earlier. I guess he'll be going live. It'll syndicate soon. He'll be starting up soon. So, oh, okay, so he's giving away some of his YouTube courses. I mean, shout out to TLA anyway. And still, I think people would be interested in that. But anytime someone's doing like a giveaway or a raffle, you know, especially I was thinking like in line of like a Christmas thing, but still, this is a great giveaway because it can get people started. It feels so weird linking to the lead attorney, like somebody doesn't know who TLA is yet, but just in case, right? Just in case. Here is the link to the lead attorney's channel in the chat. But seriously, like something like that YouTube, his course giveaway, it's something that could get people started up. One of my first like YouTube friends that I met was someone that took his course and really has launched her channel. Let me see. And I know she's a guest sometimes on his content. She isn't always, she's like a devil's advocate. People are like, oh no, every time she gets up. But I love that she does it. I love that she's willing. And we disagree. Me and her disagree on a lot of different things. But her name is Tamara. And I don't know if I've seen her get up on one of his panels recently. But she took his course, really started doing her thing, and then had her son start doing YouTube. and super impactful that that's just coming because lead attorney put this course together. So if you're interested in taking his course, if he's doing a raffle, that's a great time to participate and try to get in there for the free 99. So thank you, Mixed Chick, for letting me know. I had no idea. I mean, I'm missing every time he seems to go live, I'm live over here. So it's just been so long since I've caught up over there. Same thing with AV. So, okay, and it's random and you have to be in the chat for it. You never know when he'll do it. Cool. That's a cool strategy, I think. Either way. And let's see. I do want to... Who's live right now? Where do you guys want to go on a trip to? Is Flesh of the Gods still live? And that was like noon. I was like, we're going to redirect over there. We can do a late minute party if he's still live. Because we did this Fani Willis hearing. That took us a few hours later. Let's see. Redirect. Let's see if we have Flesh of the Gods. If not, I'll need a different place to send us. Let's see. Ah, he is still live. Okay. So this is a very late raid over to Flesh of the Gods that we'll do. I'm also seeing that Nick Starro is live, so I'm going to link to Nick in the chat. And I need YouTube, my browser, to change to his new username in my saved links. So there we go. And, oh, and he's doing FOIA hearing. He's doing the Fani Willis hearing rather than the, anything YSL. So this is going to automatically take us over to Flesh of the Gods. There is Nick's link if you want to catch him. He's also live. If not, YouTube's going to drag you along on a trip with us over to Flesh of the Gods. I think he's doing YSL stuff. So if you haven't been over there, it's a great time. Familiar people in the chat. I think you'll have a lot of fun. Hit that subscribe button and like button wherever you go. And, you know, since we have a verdict now, guys, we'll definitely catch up on December 17th for the next status hearing. It might be a short little stream, but we'll do it. And anything else that's related to this, I'll pop up. We can do some videos, have a conversation. But other than that, I mean, what I know in the immediate future I'm going to be looking at is, again, that Johnson City, the possible police extortion scheme with serial rapist Sean Williams protecting this man. I'm going to do some catch up on that. That might be video on demand over a live stream, just because there's so many terms speaking certain things, different pieces of evidence, a lot of sensitive content. It's just an easier format to do as a video on demand rather than a stream. And then Courtney Clenny. Courtney Clenny has a status hearing on Friday. We had one on Monday just to reset a status hearing. But if we finally get a trial date, we might do a live video. I followed that. I've looked at a lot of the exhibits. I've gotten almost everything available in discovery that isn't otherwise protected. Like, I can't get hospital records for the victim because they're not going to release that. But her personal journal notes, all that stuff. We can do a bigger stream when we get a hearing date set and know that, a trial date, when that's finally moving forward. We'll do a big stream on that for anyone that has either been following that and wants to talk about it or hasn't followed it at all and wants to see what it's all about. We'll rope up everything from the beginning of the storyline and do that. So we're going to end this here, get us over to Flesh of the Gods. Big thank you to you guys for hanging out for everything. This is kind of a real fluid stream today. Thank you guys for all the support. Yes, that's Courtney Clenny. That's the OnlyFans model that, according to her, she threw a knife from like 10 to 15 feet away. It pierced his subclavian artery. She claims it was self-defense. And not only that, but last month, she filed notice of intent to rely on a battered spouse syndrome defense. So a lot of interesting stuff there. Big issue. They tried to charge the parents and her with an unauthorized access to a laptop. Those charges ended up, the state prosecutors decided to drop the prosecution of that after a judge found that they violated attorney-client privilege by looking through communications they shouldn't have been looking through. So to me, innocent until proven guilty, but I think she's going to have a rough hurdle to overcome if she wants to assert self-defense. It doesn't look that way from her personal journal notes, which again, she didn't plan for anyone to see. So my own opinion, I think the evidence points to guilty without justification, but I don't know everything yet. However, when that's the way I feel as a layperson, to watch a state prosecutor violate attorney-client privilege. Why do you need to go low, period? But why do you need to go low when you have evidence that's fair game, right? You don't need to do anything dirty to come across it. You have the evidence you need. Why do you need to violate basic ethics, basic rules of conduct? So there's a lot in that case that's interesting and frustrating, more than I thought there would be. So, and yes, we'll do an ABCs of Steel, finish it out here. See you guys next time, even though I'm not sure what exactly that will be, but see you then.
A as in Alicia, and B, Your Honor, as in Barry. C as in Colette.
G as in Goldfetter. K as in Kittens. M as in Magic. P as in Perfect. C as in Colette. U as in Unbelievable. V as in Victory. W as in Wonderful.
O for objection. S for sustain. B for buffering. E for Pepto-Bane. S for slime, my friend, and you, as in what you mean. I as in adultery call. M as in may I sleep. All the ABCs of Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. G for gavel slams down E. T for tell 'em anything. R for rights we stand. I for infinity. Life's a courtroom dance. Keep your stances strong with ABCs of Steel. You can never go wrong. Oh, the ABCs of Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Of Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Oh, the ABCs of Steel